Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020. 7:44 p.m. How does the FBI find people? The people is misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
All right. I think we're back. Can you guys hear me? Thumbs up if you can hear me. Give me a thumbs up if this is working. All right. I think we're good. We can hear you. Okay. Excellent. All right, let me send a quick link out to Rob really quickly. Don't peek, guys. No copy. No, don't peek. There we go. All right, I'm going to decline this one. Go paste. All right, as the music winds down here. We have confirmed that there is a verdict in this case. We're gonna go and watch this. I think I'm gonna see if we can check out Law and Crime on this one. Man, I thought this. Let's see. There we go. We've got view. We've got audio. We're on there. We're good. This is going to be a little weird because I'm coming in. I'm bringing myself in one way, and if we have a guest, they're going to come in another way. But it'll be all right. It was a hurried change, so hopefully everything is working right, and more importantly, I hope if a guest comes, they'll be able to hear as well. All right, big shout out from. Let's see, why are they not posting? Come on. There we go. Okay. Not that Mickey says, bring this jury. We've got Toyo Toys, member for 7 months, and a fantastic social media account. You need to follow this guy on Twitter as well. Haley's comment says, let's go. Combating Chaos with Sherry says, I'm getting seasick. Slow the chat down, please. Let's see. Let me see if I can. I don't even know if I can. Give me just 1 second. I think I can. I don't know. I feel like the little engine that could. We are waiting time wise. If we put the verdict up, let's see. I'll go here. Time wise with the verdict on 2. That's where we are. We're roughly. Look how close we were. Look how close we were to hitting 1,000 minutes. 1,000 minutes. They heard my plea, my silent prayer out to the jury, saying, "Please, don't make it roll over to 1,000 minutes." The speed of this chat, Ari, you're loved. Thank you so much. It's wonderful to be here with all you. This is a lot of fun. We've waited 9 months for this. Well, it seems like 9 months. It was only 9 weeks, but it feels like 9 months. There's the announcement saying that a verdict has been reached. That's going to be happening. So we're going to keep listening. We have the audio on from court. As soon as something happens, I'll let you know. I'm also watching on the Zoom feed right now to see what's happening. It's on like Pokemon, says Matt Bond. Also, let's see, Bug Dugger gifted a membership. Thank you, Bug Dugger. Lacey Spano, member for 5 months, says, hi, lovelies, from the good old ICU. Good old ICU. Mickey Duff, thank you for all your hard work covering this case. Thank you very much, Mickey Duff. I appreciate that. Drama Llama, Rob called the time pretty close. He said verdict at 2. Yeah, he's within an hour. Within an hour. And by the time you think of the delay that's happening, because everyone has to be called to the courtroom, everyone has to be invited in, sit down, the jury has to bring in, it's going to be like 2 o'clock on the dot when this thing's going to be read. So Rob pretty much nailed it. If we can, Runkle's in chat, he needs a wrench. Runkle, let's get you a wrench. Give me a second here. And if only I knew what I was doing. What I really need right now is a professional that could help me out. If you guys know of anyone that could. Oh, hey, Rob's a professional.
I really hope you're not confusing me.
Rob's a professional. He's going to be connecting here if we can get it working. Rob, I put you in already. Are you ready for this? I'm trying to get Ian a spot on chat. Okay, Ian, I think we got you past the timeout timer. Rob, I can't hear you. I think that's my problem.
Let me check.
Let's see.
Can you hear me now?
Oh, I've got my sound turned off.
I'm just going to keep talking until you can hear me. I'm just going to keep talking.
That's good.
There,
I hear you now, but
back.
not the way I want to. But give me just 1 second. I'll get it fixed.
We have a verdict. We have a verdict.
So one of the upsides of having don't do that. One of the upsides of having all this gear is I can pretty much connect any two devices and have them work.
But it's remembering how to connect them.
Yes, it's and what buttons do I have to push to make it work? So what I'm going to do is I'm going to reroute your audio to the Rodecaster. I'm going to solo me, mute you on that because it's already going out. You're coming in on Zoom that way. All right. Are you there now?
I'm still here, yeah.
You're still here. We'll push this button. I think you'll go to my ears now instead of my laptop. One more time.
Am I in your ears now?
Oh, no. Try one more time. Let's try that.
Are we in your ears yet?
You're in my ears now. Are you hearing yourself in a repeat?
I've got a reverb.
Is that any better?
Checking now. I'm good on my end.
Okay, hang on. Let me need a mix minus.
There's a lot of buttons, Scott.
We'll fix it just 1 second here. Sorry about that. I just need to change my feed to get my audio from the Rodecaster. Good. Test 1 2. Test 1 2.
I've got you.
1 2. And Rob, now are you there?
I'm here. Now you're a little bit low volume wise.
Rob, do you want to talk for just a minute while I connect the last cables and make this
I'd be
work?
happy to. I'm going to keep people occupied for a second here. So we've got a verdict. It's now how many hours into deliberation? I think we're 3 days in. So the case went to the jury. I'm not surprised it took this long. I think the question wasn't really liability. I think that was one of the ones that the jury had kind of indicated pretty early on that they were there. They had gotten there. It's a math question, and it's on what counts are we going to find liability? Is it all counts? Is it two of the counts? Is it one of the count? And then how do we allocate damages between them? The form alone, completing this form. So I basically blocked, actually, let me confirm that. I'm going to block off my calendar for at least the next hour and a half because it's going to take that long to read the damn form because this form is exceedingly complex. Everything about it. And it's really kind of unfortunate because jurors are remarkably well attuned to processing the information, digesting the information, but then they get faced with this massive document that's full of a bunch of legalese. And you look at it, you're going, okay, now what the hell do I do? And I made the remark yesterday, that one of the biggest things that attorneys can do in closing arguments when you come to jury instructions is you actually have to take the verdict form and you have to show them. And Mr. Whitney did a good job of this when he was talking about if you want to reward, if you want to bring justice to Jack and Kyle and Maya, or Jack and Kyle and the estate of Beata, then you must check box 34. And if you check box 34, go and look at box 36. When you do that and physically check the box, you have to lay the roadmap out for the jurors to go through. Now, I don't have the benefit of the chat and seeing what's going on in the comments. I don't think I do. Do I? Oh, I do. Look at that. Not that it's going to do very well because I think the chat's probably flying. I do see that Ian's in the chat hanging out for a bit.
Thank you, Rob. I think we've got Ian as a wrench as well, so he can talk. I'm not sure. Ian, does Ian want to come on? I think we're going to have the judge here any minute now. Let me just double check and make sure we're up to the second on the feed. That's it. Do you have a feedback, Rob? Or are you good? Did he say he said bring in this jury? Did you hear that? He said bring in this jury. Are you good on feedback, Rob? Oh man. Oh man. Maya's just a bundle. Oh my goodness.
Scott, I think we don't have sound on the audio for the court.
Are you not having audio? Rob, do you have audio?
Not from the court. Not from the court, no.
Is that better?
Nada.
I'm hearing it.
You got to repeat it while you're working on that audio.
Okay, here we go. The judge is looking at the verdict right now. He says, bring me the verdict. Bring it to me. We're going to ask the clerk to publish the verdict. I'm sorry, guys. This is killing me. I should not have this problem. In the 12th Judicial Circuit, Jack Kowalski individually. She's reading the verdict. Hang on one second. Do you have sound now? We the jury return the following verdict. Claim 1.
Nope, I'm reading out loud. So the clerk has it. Hang on. We the find following.
One.
We find following.
The Johns
False
Hopkins
imprisonment.
on count 1. Yes. They found yes. Rob, I don't know what I'm doing here. Give me a second. $2,497,000 on count 1 on the guys. We're going to pause this and I'm going to bring this back. I don't know how else to do this. Rob, can you give me a thumbs up if you got audio now?
What is the reasonable value or expense of hospitalization and medical
You're at the bottom in StreamYard. Pull that up. You might be able to
for
share
his
it. I've got audio
child,
playing.
Maya Kowalski, in the past
Rob, can you raise the volume? There we go.
or to be so future until Maya Kowalski occurred 16. $67,200. 5. Under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted for the false imprisonment occurring between October 7th and October 13th, 2016. Yes. Through October 20th, 2016, Maya Kowalski. 6. Did Johns Hopkins All Children's Hospital falsely imprison Maya Kowalski without legal authority under circumstances that were unreasonable and unwarranted between October 18th and October 20th, 2016? Yes. 7. What was the total amount of Maya Kowalski damages for medical and psychological expenses to be incurred in the future after she reaches the age of 18, based on the false imprisonment occurring between October 18th and October 20th, 2016? $1,400,000. 8. What is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on the false imprisonment occurring between October 18th and October 20th, 2016? $3 million. 9. What is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18, based on the false imprisonment occurring between October 18th and October 20th, 2016? $561,298. 10. Under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted for the false imprisonment occurring between October 18th and October 20th, 2016. Yes. Claim 1, false imprisonment, January 6th, 2017, of Maya Kowalski. 11. Did Johns Hopkins All Children's Hospital falsely imprison Maya Kowalski without legal authority under circumstances that were unreasonable and unwarranted on January 6th, 2017? Yes. 12. What is the total amount of Maya Kowalski's damages for medical and psychological expenses to be incurred in the future after she reaches the age of 18, based on the false imprisonment occurring on January 6th, 2017? $188,000. 13. What is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future, based on the false imprisonment occurring on January 6, 2017? $15 million. 14. What is the reasonable value or expense of hospitalization and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18, based on the false imprisonment occurring on January 6, 2017? $325,000. 15. Under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted for the false imprisonment occurring on January 6, 2017? Yes. Claim 2, battery, January 6, 2017, Maya Kowalski. 16, did Catherine Beatty and any bedside nurse commit a battery on Maya Kowalski on January 6, 2017? Yes. 17, what is the total amount of Maya Kowalski's damages for psychological treatment incurred in the future after she reaches the age of 18 based on the battery occurring on January 6, 2017? $4 million. 18, Maya Kowalski's damages for pain and suffering, disability, physical impairment, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on the battery occurring on January 6, 2017. $8 million. 19. What is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18 based on the battery occurring on January 6, 2017? $559,000. 20. The circumstances of this case, whether warranted for the battery occurring on January 6, 2017? Yes. Claim 2. Battery, hugs, pats, kisses, and placing on lap, Maya Kowalski. 21. Did Catherine Beatty commit one or more batteries on Maya Kowalski through hugging, patting, kissing, and placing Maya Kowalski on her lap? Yes. 22. What is the total amount of Maya Kowalski's damages for psychological treatment incurred in the future after she reaches the age of 18 based on Catherine Beatty's hugging, patting, kissing, and placing Maya Kowalski on her lap? $8 million. 23. What is the total amount of Maya Kowalski's damages for pain and suffering, disability, physical impairment, inconvenience, and loss of capacity for enjoyment of life sustained in the past and to be sustained in the future? Hugging, patting, kissing, and placing Maya Kowalski on her lap? $11 million. 24. What is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child until Maya Kowalski reaches the age of 18 based on Catherine Beatty's hugging, patting, kissing, Claim 3, medical negligence, Maya Kowalski. Children's Hospital at the time and place of any treatment she provided to Maya Kowalski? Yes. 26. Was Dr. Sally Smith negligent in the medical care of Maya Kowalski? And was that negligence a legal cause of loss, injury, or damage to Maya Kowalski? Yes. 27. Excluding and not considering the conduct of Dr. Sally Smith, were one or more healthcare providers negligent in the medical care of Maya Kowalski at Johns Hopkins All Children's Hospital? And was their negligence a legal cause of loss, injury, or damage to Maya Kowalski? Yes. What is the total amount of Maya Kowalski's damages for lost earnings in the past, lost earnings, loss of earning capacity in the future, medical, psychological, and nursing care and treatment? 29. What is the total amount of Maya Kowalski's for pain and suffering, disability or physical impairment, mental anguish, inconvenience, aggravation of a disease or physical defect, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future? $22 million. Claim 4, fraudulent billing for Mr. Kowalski. 30. Did All Children's Hospital fraudulently misrepresent a material matter in its invoices to Jack Kowalski or his insurers? Yes. 31. Did Jack Kowalski or his insurance company rely to their detriment on the fraudulent misrepresentation you found in answer to question 30? Was it the total? What is the total amount of Jack Kowalski's damages for any deductibles or co-pays incurred as a result of Maya Kowalski's shell coverage in the past or in the future, including increased premiums, co-pays, and higher deductibles? $3 million. 33. What is the total amount of Jack Kowalski's damages for the difficulty of finding insurance in the future? $2 million. Claim 5. Survivor claim for the intentional infliction of emotional distress in the estate of Beata Kowalski. 34. Did Johns Hopkins All Children's Hospital, through the acts of its employees, engage in extreme and outrageous conduct, intending that conduct to cause or with reckless disregard of the high probability of causing severe emotional distress to Beata Kowalski prior to her death? Yes. 35. What is the total amount of Beata Kowalski's damages for pain and suffering or mental anguish caused by the extreme emotional distress prior to her death on January 7, 2017? $3 million. Claim 6. Wrongful death claim for intentional infliction of emotional distress causing death in the estate of Beata Kowalski. 36. The Johns Hopkins All Children's Hospital, through the acts of its employees, engage in extreme and outrageous conduct, intending that conduct to cover with reckless disregard of the high probability of causing severe emotional distress to Beata Kowalski that was sufficient to be a legal cause of Beata Kowalski's death by suicide? Yes.
Wow.
37. The conduct that you Beata Kowalski an uncontrollable impulse to die by suicide? Yes. 38. Wow. Was the conduct that you found in question 36 of substantial factor in Beata Kowalski's death by suicide? Yes. Question 39 addresses damages of the estate. What is the total amount of any damages sustained by the estate for loss of net accumulations? $653,676. Question 40 and 41 address damages of surviving spouse Jack Kowalski. 40. What is the amount of any damages sustained by Jack Kowalski for the loss of Beata Kowalski's support and services and funeral expenses resulting from Beata Kowalski's death paid by Kowalski? $18 million. 41. What is the total amount of damages sustained by Jack Kowalski for the loss of his wife's companionship and protection and for his pain and suffering as a result of Beata Kowalski's death? $50 million. Number 42. What is the total amount of damages sustained by Maya Kowalski for the loss of Beata Kowalski's support and services? $2 million. 40. For the loss of parental companionship, instruction and guidance, and Maya Kowalski's suffering as a result of Beata Kowalski's injury and death? $18 million.
Oh my God.
Question 44 and 45 address the survivor damages of Kyle Kowalski. 4. What is the total amount of damages sustained by Kyle Kowalski for the loss of Beata Kowalski's support and services? $2 million. 45. What is the total amount of damages sustained by Kyle Kowalski for the loss of parental companionship, instruction, and guidance, and Kyle Kowalski's pain and suffering as a result of Beata Kowalski's injury and death? $18 million. Claim 7. Intentional infliction of emotional distress, Maya Kowalski. 46, did Johns Hopkins All Children's Hospital, through the acts of its employees, engage in extreme and outrageous conduct, intending that conduct to cause or with reckless disregard of the high probability of causing severe emotional distress to Maya Kowalski? Yes. 47, what is the total amount of damages for lost earnings in the past, loss of earning capacity in the future, medical expenses incurred in the past, and medical expenses to be incurred in the future? $3 million. 48. What is the total amount of Maya Kowalski's damages for pain and suffering, disability or physical impairment, mental anguish, inconvenience, aggravation of a disease or physical defect, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future? $7,500,000. So say we all, this 9th day of November 2023, per person.
Hand me back the verdict form, please. Do the attorneys wish to inspect the verdict form?
Yes.
Please come. Oh, counsel, please come forward if you wish to inspect the
Rob,
verdict
do you
form.
have your calculator out? Oh my goodness.
I'm calculating.
I can see you flipping pages, burning through a notepad there.
Hang on, the math is. Well, my calculator only goes up to a certain number of freaking digits.
Did the jury award more than they asked for?
I think they did. I think they did. No, it's two. So I've got 203.
Mr. Anderson, did you also want to see it?
I looked at this.
Thank you.
Oh, hang on.
Madam Clerk, please poll the jury and use juror numbers as opposed to names.
Juror number 1, is this your verdict?
Yes, it is.
Juror number 17, is this your verdict?
Yes.
Juror number 19, is this your verdict? Yes. Juror number 93, is this your verdict? Yes, it is.
$203,797,478. So Rob,
Yes, I know my feed. Like, yes, I know my feed is really glitching right now.
Hey,
But
Rob,
I
thank you
couldn't
for
switch
saving me on
away
that
to
one.
a different thing.
Thanks for saving me on that. I switched my feed
So-
to go through my Roadcaster, and it caused major problems. I'm gonna set it up. We're gonna go back and rewatch the intro as this came in, maybe do the math again through it. It was actually a fairly quick read. Didn't take as long.
Why
as
don't so why don't
through.
why don't you do that? I'm going to switch my camera over to my non-work computer, which is actually a little bit faster, and I'll rejoin.
Okay, sounds good. Thank you, Rob. Appreciate that.
Right. Yep. Bye.
All right, let's see. Let me take this right here. Okay, so those numbers were absolutely phenomenal. Huge numbers. Let me see if I can bring this in. We're gonna go back and listen to this. I realize that they're moving forward here. We're gonna catch up. It's we're not gonna miss anything. Obviously, incredibly emotional. I'm gonna switch my audio to Blackmagic. There we go. Okay. Test 1 2. I think it's still working. Let's pull up this feed right here. This is how it went down.
Turn on the feeds.
Can you guys give me a thumbs up in chat if you can hear this? We're going to watch this again and do the math one more time just to double check our numbers.
Okay, this is case number 2018 CA 5321, Jack Kowalski, etc. et al. Versus Johns Hopkins All Children's Hospital. I've been handed a note from the jury that reads as follows. We have reached a verdict. Do the attorneys wish to look at the note?
Not on behalf of plaintiff.
Okay, I'm going to go ahead and file that with the clerk. Are there any issues we need to address before we bring in the jury?
Not on behalf of plaintiff, Your Honor.
Not from the defense. That's your honor.
Do the parties need any moments to talk with each other before we bring them back?
I don't think so, Judge.
No, Your Honor.
Okay. For the folks here in the courtroom, I would ask that as this verdict is read, it's going to take a while to read the verdict, but as the verdict is read, I would ask that we not have any sort of audible or visual reaction. So please keep your emotions in check. At this point, let's bring in this jury.
All rise. Jurors entry.
This is going back, watching this as it went down. When the verdict first came in, we had some problems with the audio. That is all my fault. Big thanks to Rob.
Please be seated.
Bailed me out there with a quick connection.
Okay, members of the jury, welcome back. I have been told, or I've received a note from you that you have reached a verdict. Is that correct?
Yes.
Can the foreperson hand the verdict form to the court deputy who will bring it to me? You're going to ask the clerk to publish the verdict, please.
In the 12th Judicial Circuit in and for Sarasota County, Florida, case number 2018 CA 005321NC.
So you guys do the math on this one.
Jack Kowalski, individually, Jack Kowalski as parent and next friend of MK, a minor, and Jack Kowalski as personal representative of the estate of Beata Kowalski plaintiffs versus Johns Hopkins All Children's Hospital Incorporated defendant. Verdict form. We, the jury, return the following verdict. Claim 1, false imprisonment, October 7th through October 13th, 2016, Maya Kowalski. 1. Did Johns Hopkins All Children's Hospital falsely imprison Maya Kowalski without legal authority under circumstances that were unreasonable and unwarranted between October 7th and October 13th, 2016? Yes. 2. What is the total amount of Maya Kowalski's damages for the medical and psychological expenses to be incurred in the future after she reaches the age of 18 based on the false imprisonment occurring between October 7th and October 13th, 2016? $2,496,000. 3. What is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on the false imprisonment occurring between October 7th and October 13th, 2016? $3 million. 4. What is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski
Rob, we're
for
just
his
going back
child,
through this one
Maya
more time.
Kowalski, in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18 based on the false imprisonment occurring between October 7th and October 13th, 2016? $67,200.
As this goes on, Rob, what? I'm going to play this in the background here. What was your take as you heard these numbers rolling in?
Are warranted for the false imprisonment occurring between October 7th and October 13th, 2016.
I don't
Yes.
even know yet. I'm still processing.
Claim 1, false imprisonment, October 18th through October 20th, 2016, Maya Kowalski. 6. The Johns Hopkins All Children's Hospital falsely imprisoned Maya Kowalski without legal authority under circumstances that were unreasonable and unwarranted
Yeah, I think it was the full
between
238.
October 18th and October 20th, 2016.
So everything they asked for, basically.
Yes. 7. What
So I
was the
missed some
total
of the
amount of Maya
numbers.
Kowalski's damages for medical and psychological expenses to
So
be
they were out a
in the
clean
future
sweep as
after she
far as all the
reaches
charges go.
the age of 18,
They found
based
for
on the false
everything, fraud on the
imprisonment
medical
occurring
billing,
between October
everything.
18th and October 20th, 2016.
I've got Jules calling in. She's going to join us here if that's all right, Rob. I'm going to turn down the audio from the courtroom.
Yep.
8.
Hey, Jules, you're on with Rob and the Recovery Addicts. I can tell you're emotional. What is it like? Because I just saw you walk out of the courtroom. What are you feeling?
It was, oh my God, I can't even explain it. I probably shouldn't call because I can't talk. The emotions were like, it was bad because we were instructed like 4 times before the judge even came out that you can't show any reaction. You know, like nothing. They wanted you to be like stone-faced, nothing. And they did it like 4 times. I mean, I felt in my heart that they were going to win, but I didn't realize. You had to hold your emotions in, and you know how hard that is. And then hearing the kids break up, and then once Jack got the thing for Beata, that was it. And you know, and it was really difficult to hold all of that in, and we couldn't let anything out in front of the jury or even the judge. And once the judge walked out, then it was all, I mean, everybody was hugging and crying. The kids, the families down the hall, and you know, I don't know. Just ask me questions because I can't think. So I would rather you ask and then me answer, because if you don't ask me, then I'm just going to ramble.
I'm not sure if you're going to be able to hear Rob because of how I've got the system linked up. Rob's on with us right now, so if he asks a question, I might have to relay it to you. But
yeah, that's fine.
The math was doing Rob was doing the math while we were going through this, and it seems to add up to about 238 million. Is what the totals.
Oh, then my math was, I thought it was 244, but okay, that works for me.
That's still when we're talking about a number that big, it's still pretty close. So
The
still,
numbers, I mean, at that point in time, the numbers.
I tried.
Rob says
what did he say?
Go ahead, Rob. I'll let you talk.
I was going to say, at that point in time, the numbers, once you get beyond the $100 million mark, I think that was kind of the threshold that I think Peter and I discussed. But once you get beyond that,
it says once you get beyond the 110,000 million mark, it's huge. We're dealing with massive numbers here, but absolutely incredible. I can see the emotion. We saw Maya, we saw Kyle, we saw Jack. Very emotional. Just supporting each other, just reaching out. They've been like, statues through this trial for the most part, having to hear and relive just an awful memory, an awful time, and then to hear this is like a stamp of approval where somebody finally says, yes, we hear you, and we know what you're going through and what you went through was wrong, and it was a flood of emotions. You heard Kyle just burst out in sobbing, just open sobbing. As at this, where he's been rather stoic and sort of kept it in for so long. It's just been.
He has, absolutely, and it's like total validation now. Like we believe you.
Yep.
You know what I'm saying? They spoke loud and clear. We believe you.
Yeah.
And you don't have any idea how much that means to this kid, that finally somebody believed in them. That's how much that's how important it is that finally the world knows. Finally the world knows the truth.
Yeah.
But I have a legal question for Rob. If you would please ask him this, because I don't know if he can hear me.
Rob, can you hear Jules? Yes, okay. He can hear you. You just can't hear him.
You're right. The next phase of this. Did he get any confirmation on? In other words, I don't even know what I'm trying to say here. Okay, this second phase that we're going into, now that the jury has spoken, does this mean the second phase is going to be like worse than this one?
Well, I'll let Rob answer that. Jules, let me tell you, thank you very much. I know you've got some people there you need to put your arm around, and you need some people to put their arms around you as well. Jules, thank you. The next phase 2, deals with punitive damages, and we're going to be talking about that here in just a minute. So I'll let Rob answer that and explain that a little bit. But thank you very much, Jules. We'll talk again very soon. All right.
All right. Thank you. Bye.
Bye.
Yeah, we were trying to do it. That's y'all like through it. I have two sensors.
Okay, hang on.
There are a lot of them different.
There we go. Okay, Rob. Do you have an air raid siren going on your end, or is that my end?
There's a yard guy that's doing noise.
Nice. He saw the live stream. He's like, now's the time.
Yeah,
okay,
exactly.
let's fire it up. Walk back.
So I think they're still live though now, aren't they?
No, this is a replay right here that we're watching. Everyone's left the courtroom. I've heard that at 2:30 they're coming back. The jury's coming back for the punitive phase. So we've got half an hour of a break. We did not watch the very end of this. I can tell you that the end is. I'm going to skip ahead as they read the numbers. This is how it ended, as the family, obviously Kyle and Maya are just both validated, vindicated, and at the same time just a flood of emotions as they relive this. Hugs all around. We're going on. I'll let that play right here. But it's the next phase is punitive. And this is just yes, it will be money and it will be an award that goes to the Kowalskis, but this is the punishment for Johns Hopkins. This is additional payment, right? And so I think Florida law, for the most part, says 3 times the actual damages is what you can get, unless they were able to somehow lift that cap with the question that they were talking about this morning. So we'll see. I'm now showing they're back in court live. Let's see if we can. Looks like the judge is coming in. Let me see if I can bring this in now. Give me just a second. Are you able to hear this?
No, his I'm gonna hook directly in as normal, and because his equipment is gone, so I'm just gonna hook in through the court
Can you give me a thumbs up if you can hear this,
like we
Rob?
did the other day.
But then the TV folks won't be able to pull it off of the TV.
I could communicate with them and see if they have a switch, and I could patch into it. But I think that they could push into one of the big gallery monitors if they need to see any visuals.
You can set that up, but I'm going to go ahead and proceed. We're now going to turn our attention. Let's see, Mr. Hunter's coming back in. Mr. Altenburg's already here. Actually, I need the plaintiff's lawyers. I mean, Miss Lawrence is here. Yeah, there's Mr. Williams.
It's okay. Ms. Lawrence had an internet. It was well handled by her. She's grabbing Mr. Anderson.
And I do have Mr. Elliott by Zoom. Let's talk about the proposed instructions. And Mr. Elliott, are you finished with your oral argument at the District Court of Appeal?
Yes, sir. Yes, Your Honor, and I'm back in Tampa, although I'm having some computer problems, so I'm still on my phone.
Oops, I probably on the wrong setting, Mr. Reyes.
Okay, so they're gonna deal with a couple issues that are still outstanding regarding this last verdict form for the punitives. That's why the jury's been kicked out for a bit.
That's fine. Could you hear what I am back in Tampa?
You're back in Tampa. I heard that. Have you received the draft verdict form and draft jury instructions that were circulated approximately 12:45 today?
I have received them, but I can't access them right now because of having a computer problem. But I think it was what we looked at before with just adding that other question in, wasn't it?
Well, I added a little extra language.
Oh, okay. I saw that you had sent something.
Do you want to talk over this, Rob? Or?
Is there someone in your office that can print it out or somehow bring it?
No, I just realized I had the wrong microphone plugged in.
Oh, you sound great right now. You did before. It wasn't too bad. I brought the verdict with no audio, so we're batting 1,000 between us.
We probably should start with the instructions and then get to the verdict form.
Okay. I'm opening those now. Okay.
Yes. I mean, I just wanted to let the TV folks have access to the feed if they were so inclined.
I see the alternate between clear and convincing or very good weight. Are there any questions that match up on the verdict form to that?
Yes. Mr. Altenberg, do you have?
I have this open on my phone. I am not. This came in about the same time I started traveling.
Hey, Rob, can you send the invite to Ian as well?
I can just print out another copy and I can give.
I understand what you did, and first I'm going to object as vigorously as I can to the fact that we are now having the jury answer a phase 1 question by clear and convincing evidence that I had no notice of until this morning. We didn't have a chance to defend against it. We've had no chance to argue against it. It should have been in the Phase 1 instructions, and now you're going to intermingle the Phase 1 and Phase 2 instructions when we wanted a bifurcated proceeding. So I object vigorously to this second question being on this form.
Doesn't the standard jury instruction have this in a Phase 2?
No, there is no standard jury instruction whatsoever on this specific intent question, and the only case that I can find, and I think that Mr. Elliott has found, is a case that put it in the Phase 1 instructions.
Mr. Elliott, anything you'd like to say?
All right. I don't have a case in front of me. That's the Longwood case. I don't think it says it, isn't it?
It's the Longwood case. It doesn't discuss it, but footnote 10 quotes the instruction, and that instruction was given in Phase 1 because it's not an instruction on damages. It's an instruction on the substantive elements that are going towards punitive damages, and that has to be tried during the case and presented in Phase 1, not in Phase 2.
Mr. Elliott, any response?
Your Honor, I think they're going to answer it now. I don't read Longwood to say that's where it has to go. That's just the way it was done there, and there is not a lot of law. So I think, I assume they want that asked, and it should be asked here.
It's a due process matter. We were entitled to notice of this and an opportunity to defend it and to have it on the first verdict form.
Well, here's what we're going to do. I'm going to allow the question to go, especially since, when I say go, it'll go to the jury, especially since Section 768.73(4) prohibits us from telling them why we're asking them the question, which is basically whether or not the punitive damage cap applies or can be avoided. And since we don't tell them why we're asking them the question, I don't see, it's the same evidence between Phase 1 and Phase 2. There's a little extra evidence in Phase 2, so I'm not exactly sure why it would matter, but I recognize the objection.
Are we going to be allowed to put on the evidence we need for that question?
You're going to be able to put the evidence that you wish to put on. Mr. Cottrell is coming back, I see.
But to be clear, we were not preparing anything to put on for this
So
particular
Ian, welcome. Good to have Ian and Rob here with us today as we're watching through this. They're now doing the last minute, it's very last minute, arguments about the verdict form for the punitive damages. And Mr. Altenburn is arguing very vehemently that something shouldn't be added. And I think the question is referring to is one that lifts the cap on the punitives, which is huge.
And this is where, as a lawyer, you want to make some noise because your client just took a huge loss. You want to be sitting there seen to be active.
We can definitely readdress it then, but I'm going to get the finding from the jury as to what they are thinking. So, with respect to the instructions, Mr. Altenburn had a slight change to go to when you determine. Any problem with that, Mr. Elliott? On the second line.
Let me get back to them. I'm sorry, Ronald. Flipped over to the verdict. Let's see. Well, if you can read it to me, I probably don't. I'm just having trouble calling it up here.
Well, currently it reads, members of the jury, I am now going to tell you about the rules of law that apply to determining whether. And Mr. Altenburn suggested tell you about the rules of law when you determine whether.
Oh, that's fine. That's fine.
that apply when you determine what.
That apply, yeah, absolutely. I apologize for not saying that word. I'm just going to make the change here so I don't forget it.
They also got a clean sweep on intentionality. So all the punitives are on the table right now.
The next is at the end of that paragraph where it talks about should decide any disputed factual issues. What it currently talks about by the greater weight of the evidence. I added, or by clear and convincing evidence as specifically indicated on the verdict form. So it will reference both standards and then define both greater weight of the evidence and clear and convincing evidence. That's my recommendation.
And I think that is consistent with our effort to have questions that will answer this one way or the other, depending on legal rulings later.
Mr. Altenberg.
Well,
knowing
my prior objections that have been overruled, I guess that goes with what you want to do, so I can't stop it.
Right. And again, I know you are objecting to having the specific intent question on the verdict form.
Yes. And anything and everything that relates to it, yes.
And I also know that you are suggesting that the specific intent has to be a clear and convincing evidence finding. And I'm actually leaning in your camp on that but that's why I didn't quite know, because the case law doesn't really say whether it is clear and convincing or greater weight.
There's very little case law, but it lines up as a finding on something that is a predicate to being entitled to damages, which means it's a finding of fact on a substantive matter for which clear and convincing evidence was necessary during the trial and during the first verdict.
So I will add the language that I proposed on page 1. Now, Mr. Altenburn, on page, I guess it's technically page 3, A1, 2, and 3, you had some comments.
And I've taken those out. That's all right.
Okay, so is the language okay as it's circulated, where one has whether the wrongful conduct was motivated solely by unreasonable financial gain?
Yes.
And so we're leaving that in?
Right. I mean, I believe there's no evidence of that, but I think they have to know that they're supposed to have that to do this. So, yes.
And I haven't had a chance to talk to the trial team on that. I guess I would ask Nick or whoever's there. I mean, if we want that in.
We need a question.
Okay.
Well, no, hang on. No. I didn't mean it that way. We're wondering what the question is.
Well, the question is, does A1, whether the wrongful conduct was motivated solely by unreasonable financial gain, should that be a question, an instruction in the verdict form, in the instructions, and then I assume there's a question on the verdict form that corresponds?
There is not a question on the verdict form.
I understand why we would need that.
Yeah, I don't think that's the contention. So I think maybe one can come out. A1 can come out.
Yeah, I think we're talking about. I confess to being a bit behind schedule here on where we're going to insert such a thing.
Mr. Altenburn is suggesting that number 1, which would require the wrongful conduct was motivated solely by unreasonable financial gain, that isn't something that we need to instruct on because that wasn't the theme of the case.
Agreed.
But let me check with my trial counsel because they didn't prove it. It's not an issue. And if that's normally a factor, we ought to be able to point out that's not why we did it. So I don't know how you want to argue.
I think it's a factor in the sense of it gets you, it's another cap alternative that we're not asserting.
Yeah, but for some strange reason, it's in the standard form as if you give it every time. And so, I mean, I don't think there's proof of issue 1 or issue 2 on that form, which is why I question whether they should be there. Let me, if you don't mind, can I?
No, you can ask. Absolutely.
Let me see why a lot of this.
Would it help if I just had my assistant print out a couple paper copies?
That would help.
Yes.
The trial team tremendously.
Say that again.
It doesn't matter. A lot of this doesn't matter. We're having an academic discussion. Whatever standard they put on these jury forms right now, the jury has just indicated
it is
they will find
I
that
do see that it's in
that cleans
to subpart A.
Juries come for blood.
I think, let's see if there's an instruction.
In fact, this might be a place for defense to hope that they lose so that they have an appellate issue.
Yeah.
Okay, Your Honor, I'm looking at the note on page, well, it's note 5. In the printed version, I guess that doesn't matter, but it says instruction 503.1C2. I'm looking at the right thing.
Your Honor, right now, we don't know whether you're allowing opening statements and arguments.
Sure, you get opening statement.
Okay. We'd like to leave it in.
Okay.
They said they wanted to leave it in. Defense wanted to leave it in.
Ms. Syback, go ahead and print what I just forwarded you, 4 copies, please, and bring it in. Okay, well, I'll go ahead and leave it in right this second. I then added, you may in your discretion decline to assess punitive damages. That seemed to be as a standard that the prior version didn't have.
That's right. That was supposed to have been in there, it just wasn't put in there for some reason. That's in the standard.
So you're okay with me adding that
Yes,
sentence?
I had added precisely the same language in what I said.
And
yes, plaintiffs are okay too, because that is in the standards.
okay, I think that was the balance of the issues in the instructions. Let's go over to the verdict form. And then hopefully my assistant will bring this in just a moment.
The jury's just on ice back
Do
there
you have the
waiting.
verdict form there, Mr. Elliott?
I do, Your Honor, thank you.
I wouldn't necessarily say they're on ice. I would say they're pretty hot-tempered at this point.
They're ready to write some zeros.
Oh, they're going to run out of zeros. All the zeros.
Got a question for you. Go ahead, Ian.
It'll be interesting to see how Maya runs the hospital after she owns it.
Start by changing the name, right?
Mr. Altenberg, do you want me to proceed or wait for the printed paper to come out?
I'm able to read this fine.
I'm sorry, are you going to read it fine? Okay, so from a conceptual basis, what I did is the question number 1 is the damage question. And I think that comes from the standard, and I don't think there's any objection to that. And then following the damage question, there are 2 additional questions, which is the specific intent question. The first specific intent question would be to the clear and convincing evidence, and then if they answer no to that, then it directs them to go to the greater weight. So we would know by what quantum if the jury were to conclude that there was a specific intent of harm. Now, I know this is over the defense's objection and they don't want it, and I'm saying we're going to have it. So under those circumstances, Mr. Altenburn.
Given your prior rulings, this is consistent with your
But how it's framed, doing the clear and convincing evidence standard and then going to the greater weight.
If it's on this one, that's how you have to do it.
Mr. Elliott.
Agreed, Your Honor.
Are there other matters within the verdict form that we need to address?
Yes, Your Honor, and it actually impacts the jury instructions as well, now that I'm looking at it. We had discussed combining January 6th into one. Somewhat, I guess since I'm objecting to this, the clear and convincing part of this, it might as well be combined for the 2 of them. It's easier to combine the 2 of them than it is to try to explain non-duplication to a jury that hasn't been avoiding non-duplication in the first half of this. So I just assume have them combined by you.
So what
I can take issue with that, but...
Well, Mr. Elliott, the concept here is for the photography session, just ask combine the false imprisonment and battery.
I would turn to my trial counsel and ask a chance to talk to them, ask if they're okay with that. I mean, I see the logical sense, and it's the same in the past.
Just find the questions.
The 2 January 6th, yes.
Yes.
Okay. That sounds good, and then we avoid the non-duplication that you were identifying. My comment before was I wasn't agreeing that the jury had disregarded anything as far as the duplication goes.
Okay, so what question 7 will read, at the top it says claim 1C and claim 2, false imprisonment and battery, January 6, 2017. Question 7, what is the total amount of punitive damages, if any, which you find by the greater weight of the evidence should be assessed against Johns Hopkins Children's Hospital for the false imprisonment and battery of Maya Kowalski occurring on January 6, 2017?
I think that's a correct combination.
Agreed.
And so that means the verdict form will only go to question 9. Okay, so I got to change the instruction.
As far as the appeal issue goes, wouldn't it be better for the number to be lower? The higher it goes, the better chance they have of somebody looking at this and saying, yeah, something went off the rails here?
Not necessarily. It's how they allocate it. If it's purely arbitrary, it's very obviously purely arbitrary. That's risky. But there's nothing that really says the jury can't say that all of the aggregate injury is worth $220 million. Now, punitive, those routinely get struck down, but that's why there's 2 phases. There's the punitive section of this. That's a separate appeal. So the punitives can be taken.
Then questions 8 and 9 need to be modified slightly too.
And I am doing that as we speak.
I thought you might.
I'll move my microphone closer to my voice. Hopefully that helps.
And in a few minutes, what I will do is I will recirculate the final version, and please check all of my cross references. And make sure when I consolidated the false imprisonment and battery for the photo session that I didn't mess it up. So this will be on page 7. Okay, now Mr. Altenberg, you said that there needs to be a change to the jury instructions as well?
I changed the verdict. We combined it so we don't need a non-duplication in the jury instruction.
Now, knowing, Mr. Altenberg, knowing that I am going to allow the specific intent questions, and I know you object, and I know you've preserved that, and
I don't believe I have any other objections to the form.
Okay, that's my question is there any other change to the language other than the fact that we are going to have the specific intent questions?
No, Your Honor.
That's the one that lifts the limit.
Mr. Elliott.
The specific intent.
Any other?
The hospital literally did this on purpose.
Okay, so what I'm going to do, let me just send this real quick.
And just for reference, there are about 2,000 Runkle fundraisers to make up this damage so far.
You got your work cut out for you. The last one practically killed you. I did a 24-hour live stream and took a few days off just to get your help with that.
Yeah, I'm still recovering a bit, but I don't think I'm gonna be raising money to help them cover this loss. So
I think I just did that, but let's see if I actually attach the documents. While I'm waiting for the email to go through, for the members of the media who've been asking, the clerk of court has already processed the verdict form and it is now published on the clerk of court's website at docket identification number, or DIN, D-I-N, 3,629. That's the docket entry, the 3,629. It's on the clerk of court's webpage now. You can grab it there.
Thanks, Judge. Grabbing now.
Received your email.
Did I have attachments on it, or did I forget to put
Yeah,
it?
nope, the attachments are both there.
Okay, great. So I'll let the appellate lawyers check that, because obviously we don't need them right this second. So you'll have a couple minutes to look at that. Let's talk about the proceedings. How much time does each side wish for opening statements?
Yeah, I don't think I need more than 15, 20 minutes, Judge.
15, 20 minutes, fine, right?
So each side will get 20 minutes for opening statement. And is there anything other than we're now in the round two that you want me to tell the jury before we start?
I'm sorry, Judge.
Is there anything else you want me to tell the jury other than we're in the second round of this trial?
We have some exhibits we'd like to admit.
Okay. Let's deal with them.
Could I first, Judge, ask what you honors perceived as the scope of what we're doing, how much time you shut up for something about it?
My understanding was each side was talking about 90 minutes or so.
We're trying to do it within 60 to 90 minutes, close to 60 if at all possible. We want to get out of here.
60 is fine.
We're waiting for Mr. Keys. He should be here, though.
We'll be at that time you're done with your openings.
Yeah, he should be.
And so they say they want 60 to 90 minutes. How much does the defense wish?
That's fine, Judge.
Okay.
Then closing?
How long do you want for closing, Judge?
Is 30 minutes aside enough for each side?
Yeah.
That's fine, Judge.
So everything to this point was actual damages, right?
Can I approach it?
So what we'll do, 20 minutes for opening, up to 90 minutes for case in chief and any rebuttal, and 30 minutes closing. How many exhibits are we talking about?
We're talking about 8 to 10, 12.
And let's go through them and...
May I approach?
Sure. Has the defense been handed up?
I'm going to right now.
I'm going to turn down the sound from the hospital, the courtroom a little bit. Can you guys still hear on your ends?
Yep.
I think that it rolled over the dates between October 18 and
People saying they can't hear you.
2016. I think that needs to be January 6th, 2016, 2017, sorry.
Did I not? Oh, you're right. Good catch.
I think it was just a roll. I'm sure when I block and move things, it just got caught.
I made that change. Okay, so the first few are these financials?
Yes, Your Honor, and we could proceed with the what's labeled there as 2279H and J, which are the most recent tax returns for Johns Hopkins Children's Hospital. The two previous ones at Charlie and Delta are there so we don't face an argument that we're not using the financials from the relevant time period. There was a deposition yesterday of our punitive damages expert where it seemed to be stipulated that we'd be referencing the most recent tax returns. So long as that's the case, we don't need 2279 Charlie or Delta.
Yeah, can I have a copy, please, of whichever is 2279J?
We can put it up.
Or just send it to places we print it, please.
Oh, it was provided by Mr. Hunter about in mid-September.
Oh, the one we talked about with Mr. Heath?
No, you were talking about the fiscal year 21, but we went back and looked and saw that fiscal year 22 was provided mid-trial.
Got it, okay. Yeah, just want to make sure we're working off the same document.
So what is the position of the defense on 2279H and J?
Yeah, I have no objection because the documents are going to go off.
Okay, the court receives 2279H and J. Do you have those documents in your possession?
We have J. 279. J. It is. If you don't mind sending that. You have it? Can you print
Yeah, we'll need to print these as. Okay.
Yeah, we're going to need them. Okay, so I've received 2279H and J. What's?
All right, Your Honor. From there, we'd like to proceed with 2828 and 2829 on the same proviso that if we're not going to be required, there's not going to be a appellate issue about not having the 16 and 17, and we don't need 2826 or 27.
Sorry, Mr. Whitney, I apologize.
That's okay. 2828 is what's been called the audited financial statements for 2021. 2829 is what we've been told were the audited financial statements for 2022.
Yeah, my only objection, Your Honor, is when we took Mr. Heath's deposition yesterday, I asked him what documents you're going to rely on. And he said, I'm only going to rely on the ACH Form 990 from 2021. He said, if I get an updated, the tax return, because their fiscal year is, I think, June to June. If I get the most recent one, I'll update my opinion on that, which is why I don't object to 2279J. But I do object to him putting in audited financials. That was the purpose of the deposition. He told me what he's going to rely on. And now I'm seeing they're going to rely on new documents. I haven't had a chance to propose them on. I mean, the ACH Form 990 contains somewhat similar information, but based on the representation you made to me yesterday, for surprise, I would like them to be limited to the tax form that I'm prepared to cross them on.
Yes, Your Honor. Any problem with the clerk going to get the actual evidence from the jury room? Okay.
One of the issues here, Your Honor, is that we had a deposition of the CFO of Johns Hopkins Ultra-Rich Hospital scheduled for 1 p.m. We had asked for 9 a.m., so it didn't happen.
Well, that's unfair, Mr. Whitney. You asked for either 9 a.m. or 1 p.m., and I gave you 1 p.m. So
right, we gave the option, so here we are without a deposition of the CFO. We would move to admit 20.
These are audited financial statements. I mean, are they audited financial statements?
Yeah, I'm sure they are. I'm not questioning the authenticity. It's surprise testimony. That's why I take a deposition.
I will receive into evidence the audited financial statements 2828 and 2829. Now, on the specific issue, Mr. Shapiro, Mr. Whitney didn't put in the 2016 and 2017 financials because of this discussion that y'all were going to rely on the most recent. I just want to make sure that you agree with that.
Yes, Your Honor.
Okay. What's next, Mr. Whitney?
Your Honor, we'd like the court to consider admission of 2451, which is Catherine Beatty's arrest record.
That's still not allowed to come in. So no. What's next?
They went for the arrest record?
We would like to play for the jury sworn testimony by Catherine Beatty regarding her cooperation with Sally Smith in other cases.
Let me hear what this is.
And this is 2758 Delta.
Show the dependency action.
Yeah, let me just hear it, but let me understand the context and then we'll go from there.
What's the page and law? It should be your auto clip there, 2758 Delta. Do you have it?
Looks like it's 46 seconds.
It's 30. Page and line is. 3626 to 3714. All right, we're gonna move past that one. Let's proceed to. Do you have 2830, the video?
So the plaintiff gets to peek into the bank accounts and the wallet of the hospital before they ask for money. So the jury gets an idea of what they're dealing with as far as funds wise, how much is available, and then determine what the punitive is going to be. What should the punishment be? That's why you're hearing all the bank statements, the audited financials, the tax returns, and then they're also going to try to bring in anything that really makes the hospital's actions look like they meant to do what they did.
You're
And the
instructing on
hospital's
both.
going to have to pay in cash. It can't be like here's 2 Band-Aids and a bill that says.
Yeah, that's in there. I added that.
You can do both options?
On the verdict form?
Yes.
Yes, that's what we talked about, that the,
Oh, I did not understand. I thought, for heaven's sakes, you were going to still use clear and convincing evidence, which has got to be the finding on that. It can't be it's not a damage element. It's a substantive element to allow for damage.
which is why the question says something along the lines of, based on clear and convincing evidence, do you find, or something like.
Yes, but then it's followed by one that says greater weight of the evidence. You're giving a pair of them each time.
Correct, because I'm not sure if, I think you're right.
This is like the causation thing. You don't know what the law is, so you're going to give the jury both options right now? Is that what you're going to do? I'm sorry, I object to that.
Okay, well, Mr. Altenberg, because the law isn't
He needs to
as
dial it
clear as
back
we
before he
need to
gets
be,
smacked down.
I am giving both variants. I'm going first with the clear and convincing evidence, and if they find by clear and convincing evidence the specific intent, they will not answer the greater weight. If they answer no to the clear and convincing, then I'm going to ask to the greater weight of the evidence. That way, it gives us the maximum flexibility to address it, and then when and if this goes up to the appellate court, it gives the appellate court the maximum flexibility. I would hate to say it's clear and convincing, and then the second tells me, no, Judge Carroll, it's greater weight, and I got to do this whole thing over when I can just ask one more question.
This whole thing is to make unlimited punitive damages against my client. So I object to all of this, but the record's clear that I have.
I know you vociferously object. Okay, Mr. Whitney, are you ready
Mr.
on your
Anderson.
clips?
We are ready.
Just about
with
hits his head on the desk.
Could you flip the?
Oh, I need to flip the control. Okay, I flipped the control. It's just one button. I can do it. What are we playing right now?
I don't think he thought it was a good reason to it, by the way.
2830.
Yes. Oh, absolutely. But his manner of objecting is a bad idea.
Yeah.
And it could hurt him on appeal, too.
And how long is this clip?
Like, you want that as in your transcript?
45 seconds to a minute. 1 minute, 2 seconds.
Okay, let's play it.
Your Honor, let me flip the audio because I had it on Zoom. Just a moment. My apologies.
As you may know, we are defending ourselves in a trial regarding care we provided to a patient in 2016. We anticipate that the jury will begin deliberating in the coming days. We don't really know how long they will deliberate, but you may hear the verdict before we're able to communicate with you directly. Please know that given the nature of this case, any decision will be complex and will take time for us to fully analyze. As a nurse, I've been doing this for a very long time, and I've seen a lot in my career. And I want you to know that I have never been more confident of anything, more confident that the care we provided to this patient was exceptional, compassionate, lawful, and
Oh my God.
This
Oh
case
my
has
God.
attracted substantial attention in the media, and much of it has been wrong. What has
What are
been
they
made
doing?
clear in court is that our team of providers did something both heroic and yet for us commonplace.
What are they doing? What are they doing?
This is a comment on the pending litigation. This is, first of all, we've never seen this before. It's never been provided before. This is complete ambush.
Your client apparently
created it.
Did it. I mean,
I understand that, Judge, but sitting here, this is a comment on the defense of the case that is essentially trying to punish the defense for trying the case and defending the case.
No,
it's
for making
trying
statements.
to make the defense look bad for defending
They
the
do
case
look
and
bad.
taking a position with respect to what they've done. They're commenting on what's going on in court, but it's taken completely out of context, and it should not be admitted at this point.
Who let that happen? Yes, Your Honor, it's a party admission by the current president of Johns Hopkins All Children's Hospital as to exactly what Mr. Anderson argued in his closing statement, which is they still don't get it. They still maintain their actions were heroic and life-saving, and the jury needs to see this at the punitive damages stage.
Okay, the court is going to exclude 2830. It is not something that occurred contemporaneously, and this is not something
judge just did
the jury
Johns
should
Hopkins
see.
a huge
What's
favor.
next?
It doesn't matter. I heard it. I can't unhear that.
Oh no, that's
Next, Your
the
Honor,
public
is
heard it.
what is there is 2832. We have
Oh, as a
several
lawyer,
clips
if
from
your client wants to
town
do
hall
that,
meetings
like,
conducted contemporaneous
Freedom of
with
raid.
immediate jeopardy finding discussing this case.
Put that up. How long is this one?
I'll have to rely on Mr. Reyes.
1 minute 14, I think. No.
First clip is 37 seconds. 37 seconds for the first one.
So let's talk about the survey results. So we did have the 12 surveyors, as you all know, on site. You all, for those who were here, had the opportunity to experience that. There's a couple things I want you to understand. Is when they were here, and you may have heard me say this before, they were surveying us on a federal level, which is around the conditions of participation for CMS, and they were also surveying us at a state level. So this was both a survey for federal regs and also state regs. So let's first of all talk about what immediate jeopardy means, because that's the word that I think has gotten everybody's attention. And just so you all know, this is not my first time to be in an organization where there has been an immediate.
This is going to be bad.
Like, just
So that's
keep your mouth
2832.
shut.
Yeah, we'll call
How
that
hard is
2832.
that?
Is there another clip that's following?
There's several.
Let's do them all, and then we can have a discussion. What's the next number on?
We will call this 2832 Bravo.
These were played in the Ms. Green deposition on Friday.
Exhibit list.
It's in that 327-page
Are these
motion for sanctions
things that were
document.
produced last week?
This wasn't. He came into a deposition with this. This was, as far as I know, this has never been produced. It's never been on the exhibit list. It was played during the deposition of one of our witnesses. We still don't know the source of it.
It's exactly like the homecoming photos of Maya Kowalski that were sent to them by an anonymous source, allegedly. This was provided to us by an anonymous source last week, just before the deposition.
Nice.
Okay,
Nice.
play the next one.
Nice turnabout.
2832B as in Bravo.
Jeopardy that you can receive is something that's called around culpability. And that really is around the issue that leadership knew that there were quality and safety issues and did not elevate it in appropriate ways to the board. And so because of that, there were enough what's called conditions of participations noted that they felt it was important to give us an immediate jeopardy. So I wanted you all to understand that the immediate jeopardy really is about system process issues of the way that quality and safety issues are driven to the board so that the board can govern and act like a board on behalf of All Children's Hospital.
You know who the anonymous source has to be. It's got to be someone at the hospital.
Go ahead.
I'll just point out that Ms. Green testified that she recognized the media site, and the source of this is Johns Hopkins All Children's Hospital for the health system's internal media system.
What's the next clip, please?
Next will be
Yeah,
Charlie.
someone at the hospital
Will
wants
be
them to go
46
down.
seconds. This is a audio. Oh, it's an audio clip.
Oh man,
It should be. No, I'm still on 2832.
the murderer is inside the house.
This is the third clip you heard. It's 5003. It's 46 seconds.
And when did you first interact with Dr.
Okay. Let's go to 5006 is the next town hall have 5006.
Okay, so what number are we
We're
playing
still,
right?
I'm sorry, Your Honor. We're still going to call this 2832 Charlie. I'm just referencing Mr. Reyes, our internal number.
Okay.
All right. Should be 10 seconds.
Was about information flow, data collection, how you really look at quality and safety, and how that gets fed back up to the board. So that is what immediate jeopardy means. Those.
Okay.
And one more, Your Honor, 5007, Dan, which we will call, for purposes of the court, 2832 Delta.
Is a cultural issue. I think that's what the one thing that has struck me the most is that while on site, the stories that I've heard and the fear of retaliation and retribution if you speak up and speak out. And people have real stories that they share with me. And I have that.
Okay, Mr. Hunter.
Three things, Judge. First of all, it was referenced during Ms. Green's deposition, and I'll reference it here. That voice that you're hearing is sped up. It's not his true speaking voice, and it's not particularly complimentary to him. Number two, if they're going to play this, if you're going to let this in, I want to see the whole thing, and we have never been provided that. Number three.
Oh, gee, I wonder who has it. It's your document.
We have not previously been provided this, and we'd like to at least have the opportunity to look at the whole thing, because clips are being cut out of this thing out of context, and we don't know what the whole
bring
thing
the whole
is.
thing. That's a good
Okay?
proposal.
There are segments in this thing that were played the other night and that we have discussed internally, that in which Mr. Sowers confronted some people and actually apologized for some of the conditions leading up to the immediate jeopardy. But finally, the immediate jeopardy is, with all due respect to Your Honor and prior rulings, that is irrelevant to this case. Your Honor's laughing, but
I'm saying because I just listened to the clips and there was nothing about the Hart Institute, which is what you were telling me in open court all of this was about.
Well, Your Honor, and
I'm just saying, Mr. Hunter, it seems what you're saying and what I'm hearing do not match.
And what I was also saying, Your Honor, was that you're only hearing seconds-long clips. You're not hearing the whole thing.
No, bring the whole
You're not
thing.
hearing the entire matter. And it doesn't sound like you're prepared to listen to the whole matter.
If I'm the judge, I'm like, you've got
time out,
an hour.
That's a very serious statement you just made.
Yeah.
Do you really think I am not making balls and strike calls? I've just eliminated a couple of items from
Also,
their exhibits,
balls.
and I'm listening to your statement. So I just want to make sure, are you saying that I am closed-minded in this case?
Judge, I'm suggesting that on this particular issue, you have indicated a predilection regarding the Hart Institute issue that I don't think that I'm able to get past. And that's my problem with it. And on these particular clips, what you're also seeing once again, and I hate to sound like a broken record, but you've just listened. This is a town hall meeting that went on for some period of time. I don't know how long it was. They've got the whole clip of it. Okay, a whole clip of it. I
That's a
haven't
big
seen.
allegation.
And frankly, don't to this moment know the entire source of. But you're reacting and visibly reacting to clips from that thing that are seconds long. You're not hearing the whole story.
It's comical.
And that's my problem with it, Judge.
Mr. Whitney, do you have the full clip?
No, Your Honor, we have portions of the town hall meetings. They were sent to us in discrete files. There are approximately 9 or 10 of them. Just to notice,
before they got
Ms. Green testified she recognized the media system these were being played from on Friday evening. And we had a busy weekend through no fault of our own. But at that point, Mr. Hunter and his colleagues could have gone to Ms. Green and Kevin Sowers and figured out where this resided in the Johns Hopkins system. It resided with them, not with us. So they had, what day is it, Thursday? They had nearly a week to watch their own video. And the second thing
right
I
along
point
with
out is that it's no different than Jack Kowalski having to sit here and listen to clips of Stephanie Graham's interview, because we can't admit his that we like. We have to accept them as party admissions, and they should be forced to do the same of clips.
Oh.
Have you turned over any other clips that you have not played here that they can see? Did you get anything else?
Yes, Your Honor, there's more to this, but they've never asked us to produce these clips.
Well, if
No,
the defense
that's not
wants
the test.
to see those additional clips, that's fine, and they should be able to see them.
Well, I would add to this, Your Honor, we tried to find this thing, and we couldn't. And I don't, I understand
Yeah.
that Ms. Lawrence is related to a past or former employee of ours. I don't know whether this is the source of that or not.
So, I mean, that's true that she is related to a former employee, but that was not the source of these, and that's a false
I
allegation.
just said I don't know.
Okay, well, I'm just clearing it up. It wasn't from that person.
The point is, there is a rule
Mr.
of
Hunter.
completeness and context here that irrespective of whether I get the complete set of clips, which I appreciate, irrespective of whether I get those or not, these things are clips that got taken out of context and are being played as party admissions, even though the whole story and the whole statement isn't being played. And that's highly
Call your
prejudicial.
witness.
And it is also ambush, and it just shouldn't be taking place, Judge.
The court's going to receive into evidence 2832, 2832 B as in Bravo, 2832 C as in Charlie, and 2832 D as in Delta.
I hate when attorneys
What's next, Mr.
sling blast at
Whitney?
other attorneys without any
we
predicate
have
found.
I'm sorry, Judge.
That
Yeah. That
Am I
was
to be
that
provided
was
the
greasy.
balance of these clips?
Yeah, didn't I just
We will
ask him to
send
do
it over
that?
immediately.
I didn't.
I apologize if I thought I had said that they need to see it.
And we're going to send them immediately, Your Honor.
Thank you.
That was greasy.
The
Throwing shade
next
at the other
is,
lawyers like
Mr.
that.
Reyes, you have this as 5003 on your system. Your Honor, on the exhibit list here, it's 2758 Delta, and it is an audio clip of Ms. Beatty's sworn testimony.
And when did you first interact with Dr. Sally Smith?
Professionally?
Yes.
I've known Dr. Smith or known Dr. Smith for probably 15 years.
Okay, so you've known her for 15 years. Do you have a personal relationship with her?
No, just professionally, I see her here at the hospital and I've worked other of these cases with her.
Okay. And approximately how many mental abuse cases have you worked with her?
With her, probably here through the hospital, at least, I'm going to say 75 to 100, and in the last 15 years, probably close to 300 or 400.
That's a lot of cases.
Agent of the hospital,
Yeah.
employee of the hospital. It's a sworn testimony. It's a statement against interest. It goes to, and they just checked yes on apparent agency. It goes to the pattern and practice of this institution.
There's going to be a lot of people calling their lawyers going,
And
Hey,
for
we
the
have a case
record, we
too?
had filed a memorandum. We were waiting to see what the jury did. We filed it at 227. It's a memorandum regarding the second stage of punitive damages and talks about the relevant, the determinations of relevance in the context of a stage 2 like we're at here.
Mr. Hunter, your statement on exhibit 2758D as in Delta.
Judge, A, it's from the dependency action. B, it's irrelevant. C, 227, a memo, I mean, I haven't seen it. And I doubt if the Honor has.
I haven't seen it, but I understand the standard.
The jury checked the yes box with respect to Sally Smith. That issue's been settled. This issue is not relevant going forward on this, and this shouldn't be admitted.
Well, I agree they checked yes on apparent agency with respect to medical malpractice. And so I don't see why the statements about, and clearly Sally Smith was wearing her hat as a medical director of the child protection team, presumably in these other cases. And so I don't see how that language is relevant for a punitive damage claim. So I'm going to exclude 2758D as in Delta. Anything else?
One more, Your Honor. It's 2831 on the list here, and this would be 5004 on your system, Dan.
around it. You know, but they're different. It's the way they cut. Here you see the eyes, here you don't. So if they do it this way versus this way, and I'm not trying to argue with you. I'm just telling you what I see, and I understand what you're saying. I understand the position. The situation we're in right now is because, you know, they think we've used our child and take away from us. I understand that. You know, it's not, and you know, we have to like prove our innocence to try to get him back. I mean, so you know, here it's not anything that you know can take lightly and easy. No, and I understand, and I think all you can do is get different opinions. I mean, our radiologists have read it. You've had other people read it. Dr. Smith is our child protection person. Sally Smith. She's done that for years and years and years. She's the person who usually does all that. So yeah, she thought just for 5 minutes. But the problem is, because there's so much controversy and nobody will probably agree on this because it's not cut and dried. And he didn't have retinal hemorrhages. He didn't have anything else. He didn't have, well, retinal hemorrhages are important because that's an important sign of shaking injury. So.
All right, wait a second. Is this talking about someone else?
Yeah.
Yes, sir.
Don't think so.
Yeah, this is not going in.
Not coming in. 2831. It's not coming in.
It was interesting.
Anything else?
Might be in another case, but not this one.
Nothing else.
Yeah.
And
I don't even know why they
the
tried.
defense exhibits after they rest. Is that appropriate for the defense? Okay. Are we ready to bring in the jury?
Judge, I think before the witness was being told.
Mr. Anderson, come on, let's focus here. There was a question by Mr. Hunter. Each side's got their 90 minutes for witnesses. So what was your question, Mr. Hunter?
I've got, there's a list here of several witnesses in addition to Mr. Heath and Ms. Salisbury and Dr. Corcoran, and I'm trying to find out if somebody else is going to be published or played, or if there's going to be other witnesses beyond those people. This is the first time I've seen this. I mean, this is like, I mean, they were told yesterday who we intended to call in the punitive damage phase, indicating we were not told anything other than Mr. Heath. And this other stuff being brought up is classic ambush.
Mr. Whitney or Mr. Anderson, I don't know who's handling that.
Yes, sir. We have Mr. Heath. We would like to call Saisha Mercado.
We object to Ms. Mercado. She's another person that is alleging misconduct during a child abuse investigation.
I'm not getting into other people's Chapter 37 proceedings. We're not doing that.
We would like to call Ms. Salisbury.
We would inquire what she's being called for.
Well, one of the things she's being called for is to discuss that she has had the opportunity to take the deposition of Dr. Sally Smith. And in fact, that was at Johns Hopkins All Children's Hospital, where Sally Smith was wearing a Johns Hopkins All Children's Hospital lab coat during the deposition.
Why do we need that? That's already been found by the jury.
She also, and we have an internal work product memorandum. She's also would testify as to the pattern practice of Johns Hopkins All Children's Hospital calling in Sally Smith ahead of any investigation, and the long-term damage that's done to families by this practice of Johns Hopkins All Children's Hospital.
We object. The chilling effect already on mandatory reporting is shocking. We object to any more coming forward on behalf of abused and neglected children.
Under the law, the hospital has immunity for calling the hotline. We're not going to parade a whole bunch of people in and talking about other people's calling of the hotline and what happened because of those calls to the hotline. That's just not going to happen. So you can keep saying these people are going to be called, but I'm not allowing it. So
may I make one further point?
You may.
Except that the testimony will be it was the result of a hotline call. It was the result of the same practice here, which is involving Sally Smith as a hospital pediatrician ahead of any hotline call, ahead of any Chapter 39 involvement.
I'd like to just make a quick record on this.
I'm saying no.
I understand, but
Okay, go ahead.
This
like,
is the problem.
I've already
It's affected
ruled
this
on your
entire
favor.
trial. Respectfully, I know you're on to try to keep this up, but they've made their entire case about the involvement of Sally Smith to try to destroy the lines between what was immunity and what's not. And their whole argument about the apparent agency of Sally Smith was not for the medical care she performed at the hospital, but her role as a child abuse captain. We'd asked for this to be excluded, but we'd also noted that they're continuing to try to infect this jury with Chapter 39 issues that should have been and have been excluded. We object to these witnesses.
Well, I think I've already declined to allow that witness to be called. What's next?
Our case has been greatly simplified. I think our only witness will be Steve Heese.
Okay, so there's...
Can we have I know you want to bring that immediately, Judge. Can we have you can stay on the bench just 2 minutes because that really cuts down on a lot of our case, and I just wanted to reorganize notes for 2 minutes.
I will tell everybody I will be back in at 3:10. Tell the jury they need to use the restroom, but we're going to start at 3:10, okay? I'll be back at 3:10.
All right, starting a recess.
So we've got 8 minutes. Jury's going to be back. It's a very simplified case, as Mr. Anderson. They were swinging for the fences, really. They were trying to get everything they possibly could here, which, I mean, to their credit, that's what their job is. But I still think they have a lot of material in that will, possibly sway the jury to side with them here on the punitives. Ian, Rob, what's your take on this?
That was some fireworks.
That was the thing that I took from it was that argument they had over the instruction on one of the things that you saw Alton Burn arguing about was which standard to include, whether it's the greater weight of the evidence or whether it's clear and convincing. Both standards are kind of like gray areas in the law, right? But clear and convincing is one of those we always view that as being a substantially higher burden, right? Clear and convincing, you have to demonstrate something by clear and convincing evidence to get punitive damages. Well, the judge was saying, I want to give them both options. And Mr. Altenburn is saying, no, you can't do that. And I see his point, because if you hear the jury, or if the jury is sitting there and they see both options in front of them, having just done what they did, what are they going to do? They're going to pick the highest burden they can and say yes under the highest burden they can.
Yeah.
So, and select both. So I see the point he's making. It's just this jury right now under the punitive phase, I don't know that there's anything the hospital can do, because I saw a lot of potential outcomes, but I didn't know that they were actually going to get to the intentionality when it came to the intentional infliction of emotional distress, when it came to Beata's self unaliving. When they got there, I was going, oh my God, they're going to give him everything. It's everything. Once they get to that phase, it was all over.
I mean, this is important because, I mean, 600 million as the cap is a lot of money. And this is a real argument about whether the jury can go over it. This is like, we think the jury's going to want to go way up. So Johns Hopkins is scared. And I'm wondering if the lawyers realize, like the lawyers on the defense side, realized they were going to lose today. There seems to be a lot of like saltiness and a lot of like bitterness. That makes me wonder if they weren't telling their clients earlier this morning, oh yeah, we'll just get this done with and, have a good day, do our media tour on the way out. And then, that's it. And I'm like, if that's what they were thinking when they walked in, today is a very bad day for them.
There's going to be a very awkward conference call in just a couple minutes. that someone's going to have to do some explaining. Well,
this might be the kind of yelling you do in person.
Yeah, as far as the 4 little clips, or a couple clips of the CEO when he was up on stage doing like the internal training, how bad is that for this? How much does that go to proving that the hospital still hasn't changed or doesn't understand what it's about?
I don't know why they let them do that. Like why their lawyers weren't saying, you need to shut up. Like in criminal defense, that is the primary thing we tell clients all the time is shut up. Don't talk about this on Facebook. Don't talk about this to your buddy. Don't talk about this anywhere. And why they weren't telling their client that and making it really clear. Like, the only statement you make is there is litigation ongoing. We can't talk about it because it is ongoing litigation. That's it. Take it seriously. I think it's going to hurt them. The jury right now they're hungry. Like, they want to lay a hurting on somebody, and anything that lets them justify that hurting is bad for Johns Hopkins, I think.
Oh yeah, I've got the verdict form. I've got that. I'm flipping through it. It was a complicated verdict form, but I mean, you get the impression that the jury, and I'm going to say this, you get the impression, I can't read the mind of the jury. You get the impression the jury started with, this was the number. They felt that what was done was so egregious that whatever was asked for should be what was received, right? They basically said whatever the plaintiffs proved, whatever they asked and set out to prove as far as their dollar figure, that's what we're going to give them because we believe the case that much. And it seems like they got hung up on the math part, and they started with, okay, well, how do we do this math? So they started with the 220 million or 230 million, whatever it ends up being. I'm still doing the math on my end. And they started going backwards. I think the surprising part to me was there was some areas of this case that I still had questions on liability-wise. I still had questions on liability. I had some questions on causation. And I had some questions on the med-mal case, on the medical malpractice, that the medical malpractice was committed in denying the existence of CRPS and how they treated it when it was in the hospital. I thought that was a 50-50 shot at best. The jury obviously saw that case and they were remarkably impacted. So for a verdict that high, this length of deliberation, I found that pretty surprising.
I think the jury I think they went in there and just sort of sat and said, we're all mad, right? We're all really, really mad. All right, let's sit down and hash out just how we settle the mad. But like, they're angry, and that's a bad place.
Yeah, looking at those numbers, they basically got everything that the plaintiff asked for, pretty much. It was pretty much exactly the numbers that they wanted, which tells me that there was not any holdouts. This wasn't a compromise between one juror member who thought, that's too much money or too little. It was just a math problem for them. It's tough math, and that's what took the whole time.
To get to this dollar figure, I cannot imagine there was a single holdout in there. If we're talking about this dollar figure, they all went in there and they all kind of, like what Ian said, they all looked around and says, so we all agree they're liable, right? Okay. And then it's a question of, do we give them everything? I bet some of them were probably wondering, the question probably they had was, can we give them more than what they've been asking for?
And I suspect there was probably some negotiation on just how much, like some people going, that's too much.
How to divide them.
Yeah. But I don't think there's no indication of compromise in terms of which counts, which is where you'd often see some compromise where they'd be going, oh yeah, we'll give you this for, no, it was just how much. Yeah, that's the only question.
Oh, and not going to lie, Mr. Hunter, sir, the inference that, and the thing is, he made that statement without a speck of connection to any factual matter. He just kind of threw out shade and says, well, we know that, Ms. Lawrence has her husband that works for the hospital. Are you freaking kidding me? I want to use so many more bad words than that, but
are legal costs on the table? Because if they are, I'd be bringing that up when that comes up to just say, hey, not only that, but he threw shade at the lawyers because he suggested that we cut these clips out and we were holding back. He threw shade at, Ms. Lawrence.
Threw it at the judge.
And
he's like, Judge, you're biased, is basically what I heard. Judge, you're biased.
And I think he's going to put it in his appellate brief, and I think he's going to get shot down on that. I don't think that they're going to be able to sell bias on this one. The judge was a little pissed when he said that.
When the judge is laughing, of course he's laughing.
Yeah.
He's laughable.
He's laughing because you're dumb. That's like, don't take it as bias when it's just that you're failing. I also love how they threw back at them. Oh, well, you had the pictures of her homecoming.
That was good. That was quick.
And the homecoming pictures annoyed me because I've got a bad back, right? And I've had days where you're just like, I'm in a lot of pain, but you drag yourself to things. You just, because you have to, right? I've run trials where I'm in serious pain and you're not telling the court, like, hey, I hurt. Can we take a break? You just do it. People do that. That's how life is when you've got sort of any sort of painful, lasting disability. You just, so I was like, I hate that.
In light of the findings from the first round, we now move into the punitive damages phase. We're going to have opening statements from the plaintiff and then the defense. Plaintiffs?
How long did they say the statement was? Were they 60 minutes each? Or an hour?
Thank you for the past 90 minutes. We've just got a little bit more to go. So this is where we determine the amount of money necessary to change corporate behavior and make sure this kind of stuff never happens again. And what our case is based around are those series of emails and memos you saw coming down from the highest up, the general counsel, over to risk management, and then directly down to Beatty and the folks kind of on the ground level, I guess, of the interaction with Maya that brought that verdict from you. So what we want to do here now is have you focus, and we can we'll bring them up as necessary. That series of memos when you're back there, you probably already remember them, when there were directions to do these things from the highest level of the company. And that's what we're talking about when you get a question on here about specific intent. It's not just like a general screw-up of the company. It's about whether the company management, for its own reasons, decided on a course of action that they had to know. And in fact, in addressing it, address the fact that it was going to harm this little girl. You know, and this is somebody who is vulnerable by herself. She cannot get out of the way. She cannot escape. So it's about protecting the most vulnerable people in that hospital and in our society. So that's why we have punitive damages in this country. It is to force a change in corporate conduct. It is to overcome the inertia of we've been doing it this way for a long time, and we got hit for a malpractice award. Let's put it over here on this part of the balance sheet, and if we're lucky, maybe the president won't hear about it. You need to make an award to make sure there's absolutely no question. Everyone in that organization, all the way up to the top, hears about it. And I'm going to, we're going to bring here, I think Nick's going to take them, Stephen Heese, who's the president of Chris Craft Boats. They're right over here off 15th Street next to the airport.
It's the second time this company's got a
nation's
shout
oldest
out in this trial.
boat manufacturer. Been around for 160 years. And Steve's not that old.
Maybe they sponsored the defense.
He's going to come in and explain to you a little bit about managing risk and why these kind of verdicts are important. Number one. Number two, fantastically, he's also a certified public accountant and was a partner at PricewaterhouseCoopers. So he knows how to run these numbers. So what we did was we had them produce their tax returns and their financial statements, their audited financial statements. So we know how much money they were making, and we had Steve calculate their real net worth based on the furniture, fixtures, equipment, income, the $555 million in gross income they made one year. He's going to list all those out for you. Please take notes on the specific numbers as they come in. And what we want to do here is assign a certain percentage out of net worth, out of revenue, or both, and that is within your province. But to effectuate what you checked, yes, you believe punitive damages are warranted, it must be enough money to absolutely make sure that the highest levels of a very, very large company hear about this and are forced to ensure, to make the changes necessary to ensure that this never happens to another family. That's the mission, all right? So you'll get a verdict form, and it'll have several questions. This one, thank goodness, is only 9 pages long, so you won't have to spend reading another novel after writing a novel on each witness. And you'll go through it, and it'll have questions that ask you, based on Mr. Hease's testimony, on the various the incidents that we're talking about. I don't know, it just is so insulting to call these things incidents. The damage, the injury to Maya and her family at different, same ones you saw before and checked yes to. And there are 2 types of questions. One is on clear and convincing evidence, how much per incident, just like you did before. And the second one is, importantly, about specific intent. And that is where you signal whether you understood and agree that from that highest point there, they had made up their mind to initiate a policy that led to what you saw for 9 weeks. And so you can have any evidence you want. It's all back there. You can go back and check those emails. I made a big deal about them in my opening 9 weeks ago. If you need those, check them out to confirm what we're saying is correct. But you'll see there that risk management had directed this stuff, and that's why it's so important to get into that specific intent. Because again, this is all about sending a message. The first part of your case was about compensation. Now that's over. Now what we're doing is correcting behavior, right? We're correcting behavior. And again, I keep saying these things because you all have been around this planet long enough to know how companies act, how people act. And you know that to get people to change and to get companies to change takes a lot. And so that's why these numbers are going to be big. As big or bigger than what you've already awarded. But they're based on a different scale, and they're based on how much the company is worth. It's $1 billion company plus, and how much it makes per year. And these are the only ways that our country has come up to find a way to change corporate behavior. So at the end of it, I'll have a chance again to talk to you about it. I'm keeping this short. You've done a fantastic job so far. We only need you a little bit more to do the right thing here on behalf of, now you're talking not only for the Kowalskis, but for everyone. Okay? That's all I got to say right now.
You see why they want to get to the punitive phase so badly?
Good afternoon. No surprise, obviously, my team's very disappointed by the verdict. But I do have a chance to talk to you one last time about what they're asking you to do.
I don't think that's the lead
I
in.
represent a nonprofit organization that's a children's hospital. You're going to hear testimony that every dollar that is awarded in this phase is a dollar that we don't have to spend on medical care in this community. You're going to learn a couple things. And it's simply this. The Kowalskis, so your verdict, have been, so the punitive damages, so you know, are only for, I think you signed the verdict form, and I know you spent a lot of time with it. They're for the false imprisonment and the batteries, right? They're not for medical care. By my math, you've now awarded $57 million to the Kowalskis for the photographs and the false imprisonment, and total compensation for the Kowalskis is approaching $250 million. I would suggest to you that's fair compensation, more than fair compensation. In terms of what they're asking you to, so these punitive damages are to punish and deter, right?
He's pissing the jury off right now.
Obviously, I don't have a chance to just sit down with you and find out what drove this specific anger. But if it was Kathy Beatty, she no longer works at the hospital. So that's not
saying the right
something
words.
that you have to keep in mind. Do we need to punish or deter for anything she did? If you found that there was something that she did that was improper, I would suggest to you that's not something that you need to send a message on.
No longer works at the hospital. Was
I
she
also
fired?
remind you, in terms of if this is corporate misconduct or something you heard from Mr. Corcoran, that you thought All Children's was doing improperly, I would remind you, Mr. Corcoran did say that after whatever surveys came down, that he was concerned about that All Children's did an excellent job of correcting them, and now there is an open culture of communication that can reach the highest levels. So
I don't like
we would
this.
need to see any type of message coming from this jury to correct any future conduct, because all of that's been corrected. But again, we would suggest to you that on the false imprisonment, just keep this in mind, and I don't want to re-argue the evidence because obviously you disagree.
Oh, you
with
do
me.
though.
But in terms of punishing
you
the
just said
deterring,
you
I
do.
thought I did what I could to let you know that the reason why All Children's back in that first week where you've awarded a lot of money for what they called a false imprisonment, just that 1 week before the abuse hotline led to the shelter, that All Children's did that because they were concerned for Maya. And I do fear that a verdict on punitive damages to punish and deter healthcare providers for speaking out when they see children that they think are susceptible to leaving and being put into a ketamine coma that they believe is dangerous, to being taken and put in intrathecal clonidine pumps that they think could lead to patient death, that sending a message for punitive damage is really going to create a silencing effect at my hospital where it's going to chill people from ever speaking up again. So
Start with that part. Start with that.
we won't take too much more of your time, but I would just humbly suggest that since we are talking about policy, that there's been $250 million awarded to the Kowalskis in punishing and deterring and trying to silence healthcare providers when they have a genuine concern is going to be tragic. I look forward to talking to you again once we're done this process. Thank you.
There's a way to phrase that. The thing is, the fact
And he didn't.
We'd like to begin, Your Honor, if we could, by publishing several exhibits of videos.
You may. So long as they're in evidence.
They are, Your Honor. We will begin by publishing 2832 Alpha, previously admitted.
There's a way to phrase that properly, by the way. There's a way to phrase that. It was-
Oh, there's like 1,000 ways to phrase it properly, and he found not the worst possible, but real bad.
Well, he started by saying
This is a video
you got the
of the
verdict
town hall
wrong.
meeting
You're
at
angry.
Johns Hopkins All Children's
Yeah.
Hospital, concurrent with the immediate jeopardy.
I don't
You
want
can
to
play.
argue with the verdict, but you're
So
wrong.
let's talk
though.
about the survey
Like,
results. The survey results. So we did have the 12 surveyors, as you all know, on site. You all, for those who were here, had the opportunity to experience that. There's a couple things I want you to understand. Is when they were here, and you may have heard me say this before, they were surveying us on a federal level, which is around the conditions of participation for CMS, and they were also surveying us at a state level. So this was both a survey for federal regs and also state regs. So let's first of all talk about what immediate jeopardy means, because that's the word that I think has gotten everybody's attention. And just so you all know, this is not my first time to be in an organization where there has been an immediate.
That video excerpt. We'd next like to play 2832 Bravo, previously admitted, further from the town hall meeting.
The jeopardy that you can receive is something that's called around culpability. And that really is around the issue that leadership knew that there were quality and safety issues and did not elevate it in appropriate ways to the board. And so because of that, there were enough what's called conditions of participations noted that they felt it was important to give us an immediate jeopardy. So I wanted you all to understand that the immediate jeopardy really is about system process issues of the way that quality and safety issues are driven to the board so that the board can govern and act like a board on behalf of All Children's Hospital.
Next, 2832 Charlie, another clip from the town hall meeting.
Was about information flow, data collection, how you really look at quality and safety, and how that gets fed back up to the board. So that is what immediate jeopardy means. Those
And to conclude the video clips from the town hall meeting, 2832 Delta. If you could turn this up a little quieter.
If Your Honor has the ability to increase it from the bench, that's as loud as I can get it.
That's as loud as I can do it. I don't know if we'll get any feedback, but there you go.
is a cultural issue. I think that's what the one thing that has struck me the most is that while on site, the stories that I've heard and the fear of retaliation and retribution if you speak up and speak out. And people have real stories that they've shared with me. And I have that.
Next, Your Honor, we would call Stephen Heese to the stand.
This way, sir. You stand here, face the clerk, and raise your right hands.
I solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do. All right, we're gonna come this way. You're gonna have a seat, Matt. Stand there.
The police's court.
Next.
Afternoon.
Good afternoon.
Thank you for being here on short notice. Would you please state your full name for the record?
Stephen Heese.
And would you please introduce yourself to the jury by way of your current position and profession?
Sure. I'm the president of the Chris Craft Boat Company in Sarasota, Florida. It's America's oldest boat builder, been in business for 150 years.
Thank you, Mr. Heese. I'd like to discuss for a few minutes your background, training, and experience. The jury knows the drill by now. But would you please give us the benefit of your formal education in business?
Formal education. I have an undergraduate degree. I grew up in Tampa. I went to Jesuit High School, went to Tulane University in New Orleans, got a degree in accounting, worked for several years at Price Waterhouse, went to business school at Harvard University in Boston. And that's the limit of my education.
Sure. Did I understand, and it was a Master's of Business Administration, an MBA from Harvard Business School?
Yes, with a concentration in finance.
Understood. And that was very brief. I'm going to explore it a little bit more. You mentioned, if I heard you correctly, that you worked at PricewaterhouseCoopers between undergrad and business school. Is that correct?
That's correct.
What was your role and function at PricewaterhouseCoopers?
Started off in the audit department, and then after I became certified as a certified public accountant, I switched to the management consulting department and installed enterprise resource planning software for the next following 3 years.
And how long were you at PricewaterhouseCoopers again?
Almost 5 years in total.
In those 5 years, did you have an opportunity to work within the healthcare industry?
I had audits of healthcare providers, hospitals.
Anyone that the jury might know?
Tampa General Hospital.
All right. And so you audited and analyzed the finances of Tampa General Hospital during those years?
That's correct.
And so you have familiarity with the finances of large hospital systems, is that correct?
Yes. I also grew up in a medical family. My mom was a midwife. My sister's a nurse. I have aunts and uncles that are nurses and doctors. My daughter is a pediatric ICU nurse at Children's Hospital in New York City.
And we don't need. What took you from Harvard Business School to president of Chris Craft?
Since business school, I've made my living buying broken companies, fixing them, and selling them, particularly in the power sports business.
And so, am I correct in understanding that Chris Craft, when you purchased it, perhaps was somewhat broken?
It was at a bankruptcy auction, completely shut down in 2000. It had gone bankrupt.
And you've been the president of Chris Craft for how long now?
23 years.
And under your management, has Chris Craft been successful?
Yes.
How many employees do you have at Chris Craft?
About 400.
And through your management of Chris Craft, have you had to purchase and manage the healthcare benefits and systems of Chris Craft?
Every year.
If you could, let me ask an open-ended question. Is risk management a concept that you learned at Harvard Business School?
I object to relevance foundation and relevance to this pursuit.
You can answer. Risk management, the concept of risk management. Would you please explain what that means, whether you're talking about the healthcare industry or you're talking about the marine products industry?
Sure. In any business, there's risk. Risk is something that every business has to manage. many risks cannot be eliminated. You know, in the marine industry specifically, boats have propellers, they've got fuel tanks, they've got carbon monoxide, they're used in the water. People are having fun when they're using them, often eating and drinking. These are
You should think
genuine
the boats
risks
are great.
that a manufacturer has to understand and
I think all the plaintiffs are buying a new
and
boat. Here,
do their
let's,
utmost to
let's
mitigate.
check notes issue.
Well, I'm pretty sure it's
What
Johns
role
Hopkins buying a boat,
does
but the plaintiffs
culture
get to sail
play
it.
within an entity, whether it's Tampa General Hospital or Chris Craft, in terms of the risk management attitude of the employees and leadership?
Objection again, foundation.
Overall.
Could you ask the question again?
Sure. What role does culture play in terms of whether you're looking at an entity like Tampa General Hospital or Chris Craft, as it interacts, culture interacts with risk management?
Again, foundation speculation.
It plays an important role, but not the only role. But for sure, the attitude of the employees is reflecting on the attitude of management and management's approach to managing the risk. So, if management is seen to be insisting that people are certified, insisting, with the standards that govern their activities, and if there's procedures in place to deal with exceptions, employees know that the employer is seeking to do the right thing at all times, top to bottom, and that culture gets created where those risks can be managed and mitigated.
Having taken over Chris Craft when it was in the midst of bankruptcy, did you have a challenge in creating the proper culture within Chris Craft to take it from bankruptcy to success?
I've been committed to standards and training of employees, and so those are the foundations. Systems, training, ideally outside certifications and training, written procedures that are followed and reviewed. These are the fundamental building blocks of risk management.
Throughout your career, whether it was at the beginning of PricewaterhouseCoopers or in your past 20-something years with Chris Craft, have you seen instances where the culture was such that it allowed retaliation and retribution for employees that spoke up about doing the right thing?
Objection, foundation scope.
Overall,
I have certainly seen that.
And how important is it to stamp out that type of culture that would allow such actions by leadership?
If the company's going to sustain itself, it's really important, critically important.
All right. Now, I'd like to discuss with you your report, which I believe you might have a copy there, and let's just keep it there for now. You'll have it as a reference. If you need to refresh your recollection, let me know. But for now, let's just try to do this from memory and your general understanding. Have you had an opportunity? Well, as part of your presidency of Chris Craft, do you monitor the industry for punitive damages awards?
I need to approach on this one.
All right, so this objection is so sensitive the jury can't hear what it is. So he's going to approach here. This is
Yeah, because he wants to testify. He's going to testify to other punitive damages that he has monitored, and the other conduct he's seen that would garner that punitive damage award. And it's difficult because every case is a little bit unique. So I can see why there's an approach on this particular question. We'll see. This number, I've been contemplating what this number could be. I give up.
I'm having a hard time finding the chat, so I'm trying to highlight here. Hogue Law was saying, so they're leading him back to, it needs to be big enough to reach management. So they want these numbers to be big enough.
I mean, the number that they already have is a number that hopefully will end some careers. I'm hoping that it ends some more careers, because that's, I think, what needs to happen on this one.
I don't think the jury's buying the bit that Shapiro shared. That's a completely different tone when he says, every dollar you take is a dollar that can't go to children's care in this community.
It was
it's a good line.
They had some good ideas in there, and the delivery of it was awful, and the tone of it was awful. Like, really, this is the time to come in and say, listen, you guys have told us that we've done wrong, and we take that seriously. We've already made changes to reflect this. We are going to make future changes. But you need to also understand that the hospital is full of good people who want to help children. We can't scare them away from doing that. And this, if the verdict is too high, that may have that effect. Also, this is help. We are there to help children.
Our job keeps getting
these are
easier.
lines you can make. You just need a better tone and a better.
Let's turn
spin on
to
it.
what has been marked as 2279H as in hotel.
My apologies, guys. That echo was my fault. I had a loop.
And the jury will have this document with them when they're deliberating regarding punitive damages. The jury will also have 2279 Juliet, as in J or Juliet, which is the next year's tax return. But let me start here because, first of all, would you explain to me and the jury what we're looking at here?
The first page is irrelevant.
What document is this?
Oh, it's a tax return for the 12 months ended June 30th, 2021. And it gets filed on the previous year because it's in the middle of the year. The new tax form isn't done, so they use the tax form for the previous tax year.
And informing your opinions, is this the document that you relied upon?
Yes.
And so it says 2020 in the top right corner.
Yes.
But if I understood your testimony, you're telling this jury that Johns Hopkins Children's Hospital files their taxes mid-year, so they would have filed in mid-year 2021, even though this says 2020.
Correct. So if you look in the middle of the page at the top, it says for the calendar year 2020 or the fiscal year beginning July 1, 2020 and ending June 30, 2021. And so that the forms all follow that same time frame.
All right. Now, focusing there on page 1, would you please tell the jury what total revenue was for Johns Hopkins All Children's Hospital in the fiscal year ending June 30th, 2021?
Yes, so you have to go to page 9. I don't know if you all have this in front of you.
We can get to whatever page you need, so you direct us.
So page 9, and the pages are in the upper right-hand corner. Total revenue for that year was $555 million. And that's in the bottom of column A, at the bottom of page 9.
Why does that seem low for revenue?
It says page 7. There you go. I'm sorry. These documents are not familiar to us, they're familiar to you. So if you could re-express what you just said. So now the
Sure, the
jury has
beginning of
it.
this is just checklists and required disclosures by the IRS, but the financial statements start on page 9 with the page number in the upper right-hand corner where it says page 9.
And you should have that in front of you on your screen. And
Yes.
the jury has the same. So if you would direct us to the figure that you were just discussing.
Column A, which the columns are labeled at the top, it says total revenue. And you go to the bottom of column A, and it's highlighted in yellow on what I'm looking at on the screen, $555 million.
So I imagine the jury knows the answer to this question, but for the record, what is total revenue as expressed here? What is that?
Billings,
2 million
invoices,
in cafeteria income?
charges that the hospital sent out
Doesn't
to
surprise
its
me.
patients and other people
Hospitals
that
do a
provided
lot of
services.
cafeteria traffic.
So you're aware
Where else do you
that
go?
we're here to discuss a punitive damage award if the jury deems that appropriate here. Direct me through the document as to what figures and categories you would look to in determining what resources are available to Johns Hopkins All Children's Hospital to pay any punitive damages award that the jury deems appropriate.
So it starts on page 9, but if you go to Page 11, it's the balance sheet of the entity. It's a nonprofit, which means that it seeks not to make a profit. Any extra cash that's left at the end of the year gets invested in the company the following year.
As of, you can stop scrolling, please. And if you could scroll up so we can see the page number at the top so the jury's oriented. They'll have that back there with them. So we're at page 11.
Yep. So
cash, non-interest bearing.
So that's $62 million that they have in there. Cash, non-interest bearing, that's typically in a checking account. Checking accounts don't pay interest, so that's at the end. It's column B actually. 46 million at the end of the year. The $62 million number is the start of the year. Column B is the end of the year. The $46 million.
So the jury can understand that at the end of the fiscal year 2021, June 30th. Johns Hopkins All Children's Hospital effectively had $46 million in its checking account.
That's on line 1, yes. But really, to get a clear picture, you need to go down to line 11 and add the balance of line 11, which is $518 million, which is publicly traded securities. So those are stocks and bonds that you could decide today that you wanted cash. Tell your broker to sell them, and you'd have cash tomorrow.
So that $518 million figure here, it would not be difficult for Johns Hopkins All Children's Hospital to liquidate those publicly traded securities.
And write a check 2 days from now.
They're traded on public markets.
It says publicly traded securities. People don't usually lie on their tax returns, so I would say yes, that is publicly traded securities that could be sold.
And if
That's
we
a bold
do,
statement.
I'll just focusing on line 1 and line 11. If you get a mental
Be a call
math,
made to the
imagine
broker
you
here
are.
shortly.
What are we talking about here for resources available to pay a punitive damages award?
$570 million roughly.
What other lines or figures would you look to on this form to determine if there's any other assets?
Right below there, you have almost $6 million in other securities, and then line 13, you got another $24 million in program-related investments. I don't know what those are, but they're certainly investments, and there's money sitting there.
By the way, were you available to attend a deposition of the CFO of Johns Hopkins All Children's Hospital this afternoon at 1 o'clock?
I was available.
And given what's happened here today, you didn't have the chance to hear that testimony, did you?
No.
So you haven't had an opportunity to explore as we sit here at 3:45 what this program-related investments are?
No.
All right. So considering those, am I correct that if you were at $570 million more or less before we add another $30 million, we're now at roughly $600 million?
Correct.
Are there any other figures that you would look to on this form to determine what Johns Hopkins All Children's Hospital would have available to pay a punitive damages award?
If you go further down the balance sheet, there's fixed assets, property, plant, and equipment, and real estate.
God.
So if you
Oh, they're going to pay. Are they going to pay her in land?
Sure.
I'm sorry, line 10A.
On the same page?
10A and 10B.
All right.
So there's $394 million roughly in property, plant, and equipment. And that number is purchase price less depreciation. So it's what was paid for it originally, less depreciation each year that goes by. Land doesn't get depreciated, so it was bought a long time ago, so I'm guessing it's substantially undervalued compared to these numbers.
It will have gone up a lot.
If I'm correct, the depreciation there is a tax concept, right?
Correct.
But if the purchase price here was, it looks to be $650 million for the real estate.
Land, buildings, and equipment.
$650 million.
Correct.
And so the figure there in the right column, $394 million, is after depreciation, but that doesn't reflect the true depreciation in value. That reflects how it's held on the books after depreciation is accounted for.
Correct.
So you made a statement that the $650 million, the $394 significantly underestimates the real estate assets available to Johns Hopkins Children's Hospital, right?
Typically, yes.
And is it your opinion that if the purchase price was $652 million, that Johns Hopkins Children's Hospital would have real estate assets in excess of that amount given inflation, appreciation, et cetera?
Yes.
Calls for speculation.
And again,
I think everyone knows what's happened to Florida real estate over the last 10, 20, 30 years.
Sure.
Last
you
2
live
years.
You say from Tampa.
Yes.
How long has All Children's Hospital, if you know, been in that location, in those buildings on that campus?
Since I was a child.
Does that support your
Age
opinion
yourself,
that these numbers here are significantly undervaluing what the worth of those real estate assets is?
Yes.
Okay, but we can go with the numbers that we have here. So before, we were at $600 million in cash and cash equivalents, am I correct?
Yes.
And here, although it's significantly underestimated, we have another $400 million in real estate assets as it's held in the books.
Land, building, equipment, yes.
And so we're at approximately $1 billion now
Yes.
that Johns Hopkins All Children's Hospital would have available to pay any punitive damages award.
Yes.
May I have a moment?
May.
Thank you.
Little ASMR there in the background.
I'm also guessing that the hospital has insurance, typically.
Well, I think for a mistrial, that's unbelievable.
I don't think they're going to get a mistrial, but it shouldn't go in.
Yeah.
They should have cautioned him not to say that. The judge is telling him, you're not getting a mistrial, but thanks for trying.
Well, the thing is, the existence of insurance you can't bring in on the actual. I don't know if it can come in on punitive phase or not. I know you can't bring it in for liability. Liability, you can't imply that they have insurance, so don't worry about it. But in the punitive context,
yeah, I mean,
it is out of bounds.
Yeah, now that because you're not supposed to find that they're liable, but if you're trying to figure out how much is actually going to hurt them to change their behavior, but the judge is looking at them really skeptically on the defense side. They're not getting their mistrial.
No mistrial. But you might get a jury shall disregard, and we're going to move on. Because the other thing is the jury.
That's what I think they're going to get.
And
that's what I think
no
they're going to
numbers
get.
that we talked about.
Yeah, I suspect very strongly we're going to get a jury. You're not to consider insurance. Disregard anything you heard about that. Move on.
So math-wise, just on that form, they've got well over $600 million of almost liquid assets available to them, which would be 3 times roughly the damages without them selling properties off.
Poor Maya looks terrified here. Can you imagine you're sitting there, you've just got this verdict, and now you hear the word mistrial, and they're having this discussion? Like, the things they're putting this girl through. And I've got a rant about, is it Law and Crime that's doing the filming, or who's actually doing the filming?
Court TV is running the cameras in the courtroom.
Yeah.
All right. Well, I'm not happy with Court TV, because they're spending all this time looking at Maya when they shouldn't be. And I'm going, come on.
This will go on record as like the fastest appeal of all time. You know for a fact the hospital's appealing this. It's going to be tied up. I just don't know how far they're going to make it. So
I suspect they've already got somebody drafting the appeal right now.
For those of you in the chat that are kind of contemplating why we're going through all of these different figures, the purpose of punitive damages, and you can tell the tone of the attorneys has completely shifted. They know they've won on liability. Now they need to drive the dagger home. Punitive damages are allowed to essentially, in limited circumstances where the conduct is sufficiently egregious, there's a certain amount of intentionality behind it, that the compensatory, just making the victim or making the plaintiff whole again, doesn't really serve as a remedy, because what you want to do is you want to deter the actor from doing the thing in the future. So you need to find a way to make it hurt. So you go through their tax returns and find out what they have.
On that last comment you heard about insurance, the first thing you need to do is totally disregard it. The
Yes.
second thing, I'm going to tell you that under Florida law, insurance does not address or cover punitive damages. So there is no insurance for punitive damages.
There you go.
So
That's
we
why-
were to totally ignore the comment made about insurance coverage. Mr. Whitney, you may continue.
That was the right that was the right
Are there
response.
any other figures on the balance sheet here that we haven't focused on that would inform your opinion as to the assets available to Johns Hopkins All Children's Hospital to pay a punitive damages award?
No.
Having reviewed the balance sheet here with the jury, page 11 of 2279 hotel, have all of your opinions been based upon your background, training, and experience and offered to a reasonable degree of accounting and management probability?
Yes.
And ultimately, what is your opinion as to the resources or assets available to pay any punitive damages award in terms of the numbers we've discussed on this sheet?
At least $1.2 billion.
When you say $1.2 billion.
Correct.
No further questions this time.
Mr. Shapiro.
Sure, thank you. Mr. Heese, you've known Mr. Anderson for what, 20 years?
Yes.
You guys were hugging and high-fiving in the hallway, weren't you?
What do you mean?
I saw you hugging and high-fiving Mr. Anderson in the hallway. Were you
I
not?
high-fived him.
All right. Let's talk a little bit about your opinions. This is a nonprofit charitable organization, true?
That was a good question.
It filed a tax return on a nonprofit tax return. So
I would have objected to it.
Yeah, this is a children's hospital. That's my point. You know this is a nonprofit 501c3, true?
Yes.
All the money, and I think you said this in fairness to you, all the money that's left over at the end of the year gets reinvested back into the community, true?
I don't know about the community, the entity.
Right, and do you know what the charitable mission of All Children's Hospital is?
I am not aware of that.
It's right there on the tax return before you
Be
testified
careful,
you
Mr.
didn't look.
Shapiro. I know too
Yeah.
many
You can draw my
501c3s.
attention
Sure,
to that.
2279H002. We can put it up on the screen. See summary, part one?
Yep.
What does it say?
I was looking at part 3. Part 1, which page are you on?
Please briefly describe the organization's mission and most significant activities. Am I reading this right? Provide leadership in child health through treatment, education, advocacy, and research. Is that right?
Strive to provide the highest quality of care to improve the health of the entire community through innovation, collaboration, service excellence.
Well, let's talk about innovation. Are you aware that All Children's has a training program to train the next generation of doctors and residents?
No,
You've lived in the community for 20 years. You had no idea there was a residency training program?
did not know that.
Did you know that All Children's receives grants to do research?
Yes.
Okay. Let me ask you a little bit about, you talked about revenue of $555,256,053. There's expenses, aren't there?
Yes.
Yep.
What were they?
If you look at the following page, the total is there. $519 million.
And that was with CARES Act money, true, right?
I don't know the answer to that.
Well, you can look at the prior year, they actually spent more than they took in, true?
The prior is not on the page.
All right. Let me ask you this.
Likewise misleading.
Whatever All Children's doesn't spend as a 501c3, you know they have to they reinvest it back in the company, right?
Not necessarily. They've got an awful lot of cash on their balance sheet.
Well, let's talk about that. Are you aware of what their strategic plan is?
I'm not privy to that.
Okay. do you know what All Children's plans on doing with the cash in the balance sheet in terms of helping this community facilitate patient care? Do you know?
Given that the cash balance is fairly stable from year to year, I would say they invest it.
When you talk about property, you mean the property where the hospital sits, right?
The line is called property, plant, and equipment, so that would include the land that the hospital sits on, yes.
So if they sold the land where the hospital sits on, there's no more hospital.
No, you could do a sale and lease back.
Okay, and if they sold property that they may hold in Sarasota, Florida, where they're going to build a clinic to, for example, take care of children dying from cancer to pay this award, that would hurt the community, wouldn't it?
Objection. Overruled.
You ask the question again.
Yeah, if when you talk about selling property, this isn't beachfront property. If they're selling property in Sarasota County where they're trying to build an outreach center to help treat children who have cancer so they don't have to make the drive to All Children's, that would be the type of property they would have to sell, right, Mr. Heese?
What I'm suggesting is they don't have to sell it to a third party who's going to put up a 7-Eleven. They could sell it and do a lease back, continue with their strategic plan, and pay rent if they needed to. But I'm also suggesting that I don't think they need to because they're sitting on an awful lot of cash.
That cash is needed because if you don't have an adequate balance sheet, you can't borrow money, can you?
It depends on what assets you have. There's all different ways to borrow money.
There are credit rating agencies that look at the hospital's financial stability, and if they're not properly financed, they can't get money. True?
If the balance sheet is in poor condition of a company, it will have a hard time borrowing money.
Right, because if there's $200, $300, $400 million going out the door, that's going to have an adverse effect on the balance sheet of a company and their ability to continue to do business. True?
No, it depends on the cash balance that's there at the beginning and what gets paid out.
Well, let me ask you, you said operations include equipment. That would include ventilators keeping neonatal children alive. True? That's equipment.
It would include all the equipment the hospital owns.
That would include the MRI machine that can detect early brain cancer and potentially save lives. True?
Equipment typically goes down in value. Land and buildings go up in value.
Right, and that's why they have to do constant upgrades on equipment with the cash they have so they don't have outdated technology. True?
Correct.
Do you sit on a board and decide when, well, let me ask you this. As president of a company, you have to decide where to allocate your dollars, right? Money's fungible. Money, if you lose money in one area, you don't have it to spend somewhere else.
Correct.
And have you ever had to sit on the board of a children's hospital to decide whether to upgrade the MRI machines that are detecting cancer versus the ventilators that are keeping neonatal children alive? Have you ever had to do that?
No.
Have you ever had to make the decision as to which outreach clinics you were going to fund, whether you're going to continue to expand in Sarasota versus Pasco County versus Polk County? Have you ever had to do that?
No.
When you took over your company, you said it was in bankruptcy?
Yes.
Did you make changes to it?
Yes.
And as a result of the changes, did the company improve?
Yes.
One moment here.
How'd you do?
That's all I have.
Not bad.
Pretty good.
Those were good
Pretty good
questions.
cross.
So that was good.
I liked the questions. I thought he was maybe a little hot,
Mr.
but
Heath, were you deposed yesterday?
at the end of the day,
Yes.
I think it was good.
How long did that deposition last?
15 minutes?
Were you asked any of the questions you were just asked here challenging you in that way?
No.
Am I correct that the purpose of the deposition yesterday was just to find out what document you'd be relying upon?
That was the main, seemed to be the main question that got asked.
And you told them yesterday you'd be relying upon the 2021 tax form we looked at today, right?
Correct.
Hold on a second. I have on Zoom and now Miss Angela Green and others.
Well,
So
what-
Put her away, Rick.
I'm going to do that.
Wait, the hospital's going to
Sorry
call
about that.
Angela Green?
This will be. Oh, we're gonna get a
I don't know if
replay
I
of the
got the answer
depot.
out there that I wanted, but you testified yesterday, consistent with today's testimony, that your opinions would be based on that tax return form.
Correct.
Since the residency training program was brought up, are you aware of the role that Dr. Sally Smith has played in this case?
Yes.
Objection, speculation, relevance, foundation.
Sustained.
Doesn't matter, Jerry heard it.
You mentioned a concept there that was not explored that I'd like to explore a little bit, sale leaseback. Would you please explain, let's just be specific here, if we're talking about real estate assets. What is a sale leaseback?
It's a huge industry in the United States. I get a phone call practically every week from representatives of investor groups that like to buy real estate and then lease it back to the owner. It's a way to raise liquidity. It's needed.
So it's
investors love it.
Is it a way to unlock value out of your real estate assets?
Correct. Get liquidity out of real estate.
And Chris Kraft, right? You received these offers?
Yes.
And so if you were to enter into a sale leaseback arrangement, can you explain the mechanics of that a little bit more in detail for the jury?
Sure. The land gets valued by an independent appraiser. There's an advance rate against that value. So say the land value is $1 million. They'll loan you 80% of it. They'll pay you 80% of it and lease it back to you, giving a return to the person that buys the land and buildings.
And then you effectively pay rent.
Correct.
And so using those figures, we discussed a moment ago, did we not, an underestimate in terms of plants, property, equipment of $400 million?
Yes.
And you believe that to be significantly undervalued?
Yes.
But if you're able to unlock 80% of the value of those real estate assets, considering that it's $400 million, what are we talking about? What number?
Easily 75% of that number.
And so that'd be $300 million?
Yeah.
And if the hospital, Johns Hopkins, all Children's hospitals, enter into an arrangement like this, they'd be able to continue operations in their hospital as it exists.
Correct.
And you wouldn't be shutting down a children's hospital by doing it.
Objection, foundation, speculation.
You just asked.
You wouldn't be shutting down a children's hospital by entering into a sale leaseback arrangement, would you?
It would depend on the amount of the punitive damages, but if the sale leaseback paid the punitive damages, you could have all your cash on your balance sheet and keep it there.
And so if you consider the cash on the balance sheet of $600 million and sale leaseback income $300 million, what figure are we talking about that would be available to pay punitive damages award?
Well, in total, you'd add the cash and the value of the real estate.
And 600 plus 300 million.
900 million.
And again, are all your opinions to a reasonable management and accounting probability?
Yes.
Thank you.
Absolutely.
So just so we're super clear on this leaseback agreement that you think the hospital should enter into, that means they're selling the property.
I didn't suggest that. I said it's an option that could be considered.
Right. And
I'm not recommending that.
But if a hospital, if All Children's Hospital had to enter in a leaseback, that means they're selling a property that they own that they're not currently paying rent on to somebody that's going to charge them rent, right?
But it allows them to keep their cash investments, which you explained were badly needed.
Yeah, well, that's going to decrease their balance sheet in terms of what they have to have going out the door for rent, true?
Correct.
And so, for example, if they had to sell $300 million worth of property and lease it back at, say, 8%, that's gonna cost the company what? How's your math? What, 24 million?
Yeah.
What's the cost of an MRI machine that could survey pediatric cancer and save children's lives?
Objection, foundation, relevance, speculation.
Sustained.
Do you know what the cost? Do you know what that 24 million could go to buy? How many lives could be saved by that?
Same objection.
Sustained.
No more questions.
Any follow-up questions?
No.
Members of the jury, do any of you have any questions?
Oh, no. Any questions during punitive phase?
That's brilliant.
I'm literally holding my breath.
Same.
What the hell?
Shapiro asked good questions though, because the point is punish the hospital, not the patients that the hospital serves.
Right.
That's the point. You have to punish the corporate. You have to find a way to tailor the punitive damages in such a way that you're using it as a scalpel, not as a sledgehammer. You want to hurt the hospital hierarchy. You want to hurt the corporation. You don't want to ultimately hurt the community of the patients that this hospital serves. And you don't want to really hurt the employees that, by and large, do great things for the care of kids. Because that's the other thing. The hospital is an employer. And if the hospital loses money, they fire the nurses and staff that care for a lot of kids. So it is a balancing act. And it's a tough question for the jury. So I thought those were good questions from Shapiro.
Let's see what the jury says on these questions.
I am terrified.
We're not going to get to hear these even over Zoom because the witness and the jury is still in the room, so the mics are off. But
Oh.
if there's a question that says something like, "Is there a limit to, to how much?"
Question. Can we ask that the lawyers personally pay some of the punitives?
I don't know. Just to me, that that testimony with the tax return, yeah, it's the bottom line numbers, but it didn't seem as invasive as I thought that the peek into the financial system would be.
Well, I didn't really agree with how Whitney started it, where you're looking at the revenue line item, right? And revenue is, yeah, that's the total money the hospital brings in, but they pay out a whole lot. Granted, if I get the revenue and the expense side in, then I go after the line items for expenses. How many of those are, corporate salaries? How many of those are corporate retirement plans? You start to get into the weeds a little bit. You don't have the time to do that. So you have to give a big picture look at it.
I think that there's a few places where they also could have made some noise. Like you were talking about the cafeteria amounts. You could say like, oh, so their cafeteria amount is this much. So, so an award of that would just be their cafeteria, revenue for the year. Juries kind of like pegging things in that. If we think of the McDonald's hot coffee case, jury was pegging it to however many days of coffee revenue.
Oh, that's right. I forgot about that.
Juries like that kind of poetic, poetic feeling. So give it to him.
Jury has some questions, sir. Where do punitive damages go?
Where they go?
Do you know who gets them? If you know.
Plaintiff.
They're paid to the plaintiff.
Next question. Mr. Shapiro mentioned Johns Hopkins All Children's Hospital needs its balances, or that its balances are needed for upgrades, which brings me to ask this. I believe you said Johns Hopkins All Children's Hospital runs about $1.2 billion plus or minus on their tax balance sheets from year to year. Is that correct?
You need to be more specific than that. So if you look at line by line, we only had through 2020 available when I did my analysis. Since that time,
this is not where you want to dodge questions
yesterday,
either.
I saw tax returns that were further 2022, for instance. The cash balances stayed fairly stable across all the years. So the argument that Mr. Shapiro made about they need that money to spend, there's no evidence of that in the tax returns. I'm not disputing the fact that he believes that, but the tax returns that I looked at, the cash balances are fairly stable from year to year.
Well, then the next question is, I would believe that Johns Hopkins All Children's Hospital has every year been making constant equipment upgrades, and with constant upgrades still keeps a floating 1.2 plus or minus billion on yearly tax balance sheets.
Again, you have to go into the lines themselves. The cash is the number that if it's the net number of what goes in and what comes out. So if you add the numbers up, it's fairly stable from year to year. So if they're investing in new equipment, which I can imagine they are, every business does, they're taking in sufficient cash to cover those costs.
Okay, thank you. Plaintiffs, any further questions?
Nothing further from the plaintiff for this witness.
Defense?
No, thank you.
Okay, was there any further from the jury?
Actually, I do have one more question.
Come on down, Mr. Shapiro.
Actually, I withdraw. That's good.
May this witness be excused?
Yes, ma'am.
Thank you, sir.
Like the price is right. Come on down.
Well, so here's why that's a little bit misleading, the cash balance here. The cash balance thing is...
And your next
people
witness,
do use
please.
that. Most payroll is paid by borrowed money. People don't know that.
For 1 second, Judge.
Like most companies pay their payroll with borrowed funds. They use the cash that are on the books to borrow the funds to pay their payroll, and then they pay that back with the cash they have. So they can actively invest the cash, make money on the cash, and then keep the payroll going. So it's kind of disingenuous. Just a remark.
Yep, but I mean that's for Johns Hopkins to explain. Like the two kids there just seem stunned.
It's not my job to do that.
Yep. Two kids seem stunned. I can't imagine how they're feeling. Oh, we got the echo back.
Sorry, that's when I unmute myself, I hear you through my laptop. That's why. So sorry. It's been a roller coaster for them, just emotion up and down. So just hearing a verdict that went a clean sweep their direction, and now we're talking about just massive numbers. You can't wrap your head around a number like that. You're just sitting on a bench as you hear it read from the clerk.
Why are we focusing on the gallery right now?
Because there's this one guy in the weird green shirt.
That would be a guy in a homecoming picture, I think.
Oh, so are you gonna have any other witnesses?
Seriously, Court TV? Are you kidding me?
I guess Court TV is focusing on a boyfriend or something. They're terrible.
What the hell?
That's the lady behind in the mask.
So
That's
is
the Court TV.
the plaintiff arrests, it's punitive damage case?
Yes.
Okay, members of the jury, we're going to take a few minutes break. You may not discuss this case amongst yourselves. You may not do any investigation. You may not receive any information. Let's go ahead and just take your break, and then we'll call you back and try to, hopefully within 10 minutes or so.
All rise. Jurors exit.
Are you kidding me, Court? Are you freaking kidding me?
Court TV really is awful, and they're endangering live trial coverage. Was it Court TV that was also doing the filming for Gwyneth Paltrow?
Please be seated, everybody.
Yep, and Valor Daybell, and they got kicked out of that one, didn't they?
Okay,
I would
have. The jury's out
sent
of our
somebody to
presence.
jail
Defense, do you
over
have your
Paltrow.
exhibits that we can talk about?
I think we're probably gonna use what's in evidence already.
Okay, so we're not going to do any additional exhibits?
I don't believe so, Your Honor.
And did you get those additional clips from the plaintiffs?
Not that I'm aware of, Judge.
They were sent, Your Honor.
They were sent.
I gave Mr. Cottrell the files on their hard drives.
Okay, so what we're going to do is we're going to take a 10-minute break. So if you want to look at those extra clips, you can do that. Mr. Altenberg.
I don't think I have a hard copy of the instruction of the verdict form. I just did the final change on that.
What I'll do is when I come back, I'll bring a copy, and if you can fly spec it. And I think we emailed it, so Mr. Elegant probably would have the ability to look at it as well.
Your Honor, I'm not sure I've seen the one with that one change we made on the verdict form. Let me see. I don't think that's cool.
I did not. You're right. I did not resend it after the one change that you made. So in a couple moments, I will resend that, and then I'll bring Mr. Altenberg a paper copy when I come back from break.
Thanks very much.
Okay, anything else before we go on break?
This is just delaying the inevitable.
Let's try to keep this to no more than 10 minutes, folks.
All rise. Court in recess.
So the clips that the defense is viewing right now, these are clips of that were taken from the media server, or at least from a play out of the media server from the hospital, of the Johns Hopkins CEO speaking to the Johns Hopkins employees during the town halls after the IJ. And so he was reassuring people and saying, those are the clips that are played. I think the plaintiff said they got 9 of them, and they were sort of like emailed anonymously to him, sort of like the homecoming pictures. They got 9 of those clips. I think they played 3 or 4.
You saw that was a cell phone cam.
And it was like filming a computer screen. So it was.
Yeah. Somebody at the hospital wants the hospital to pay for this. And I bet there's started a leak hunt right now. It'll be like, who are we firing? Because
if you go back through the depot that was of Miss Green on Friday, there were clips that were played in there. I think those same clips, and some of them featured people off camera, so you couldn't tell who it was, but it was somebody obviously who had the right to be there, so a doctor or an employee of the hospital. And they're saying, look, we're mad. We're furious about this, that we've lost the trust of the public. There's some really damaging stuff in there. People are angry at him. And I think we didn't see those the jury hasn't seen them. But those are the other clips. I don't think there's anything in there that the defense really can do anything with, but it'll be interesting.
Well, no. And then that ultimately comes back down to the whole point of the reason the judge is laughing there. And I think we need to go back to that because Hunter makes the point of, I don't know why this is comical or whatever he says with regard to the judge's remark, but the judge is laughing because Hunter is expressing this shock that this video, which apparently is a function, created by the hospital, his client, they videotaped it, they broadcast it, that Mr. Hunter is somehow shocked that this thing exists and is contesting the validity of the clips that are being sent and that they're inauthentic and they've been altered. It's laughable. You are their attorney. Yeah. That's on them.
If anything, that should have been provided maybe in discovery as material.
That's part of the reason he's chuckling. He's going, you have to turn over everything. Because remember that one, what was the comment? Everything that had a whiff or had the odor of a scintilla of having to do with the IJs, right? Presumably that would include, because remember the description that was attached to that subpoena ducis tecum was literally everything, internal communications, memoranda, recording, everything that had to do with the IJ. This would be in that list of things.
I'm betting this wasn't recorded. I'm betting that they played this live and did not record it. And they probably told people, please do not record this. And then we're shocked when somebody had their cell phone out.
How we get the clip? Sorry, guys, give me 1 sec.
Yeah. Ian, as far as the jury questions go that were just asked, did they give you lean one direction or the other as to what the jury might be thinking?
I think that the jury was partially, the question about where the money goes is an interesting question because that one I'm like, that could go 2 ways. They could be saying, hey, Maya's got enough. Because it's hard to imagine where they'd be worrying that it goes, right? But at the end of the day, I think it's a legitimate question. The jury might be saying, you know what, we really like Maya, which I think is an entirely reasonable conclusion at this point from the jury's reaction, and saying we're glad it goes to Maya. So that one could cut either way. I was sort of playing with it in my head because it was an interesting question for them to ask. Questions about the balances and all of that. I'm like, I think the jury is listening in part to the defense. I think they are hearing the question about we don't want to shut down a hospital. Because at the end of the day, they might be walking out going, the jury's going to go home after this and is going to say hey, did we do good? And did they end up, if they actually shut down a hospital, they might not feel great about that. So I think that they will try to pick a number that doesn't have that effect. So, and that helps Johns Hopkins because that's the argument they're making here, right? Please don't shut us down. So it'll be interesting.
The jury saying, where does the money go? I think there are a couple points during this trial where the jury has been surprised about what comes next, what their role is, what comes next, what the schedule, what they're going to do, how they're going to deliberate, who's going to deliberate, and now what is punitive damages and where does that go? So they're learning as they go. But as to actually calculating this, as far as the math goes, other than the cap limit, they just, what do you guys feel good about? I mean, what's the guidance? Are we going to have a testimony from a financial guy that tells them how to calculate the punitive, or is that just purely how they feel?
Well, the plaintiffs have rested. It's a feeling thing.
Yeah. I thought it was kind of weird that they've got a boat guy. I mean, he did well on the financial questions, but it is still weird that, like, what's your background? I sell boats. I'm like, okay, that's odd. I thought he did well with the questions, though. So,
yeah,
he might sell a few more boats as a result of this. So, I mean, it could be a win-win for everybody.
Well,
I was
the funny
also-
thing is like the high five in the hallway, the hug and the high five. That doesn't do anything for me. But again, that also, there might be a juror that might have stemmed the question of, who gets the money.
Yeah, that could be it. Do the lawyers get the money? Might be the question. And even when juries agree with your side, they hate lawyers. They just always. Oh, I'm sure that if the question or if the answer to that had been it goes to the lawyer, the jury would be going, well, we need zeros, but we just need one of them. And that's all we need. Just 1 0 is.
I don't know. I think
or they
the jury
would
might
like $46 and it was the gas money. That's an
gas money for the lawyers and 211 million for the Kowalskis. I think they might have. I think they like the jury. I mean, you've got all the jurors who are literally crying during Whitney's closing. Okay, they've connected at some point that they feel the same feels that he was feeling. So I think they're okay with them getting paid a little bit for their time. But yeah, the jurors have been the brunt of jokes for centuries. I think for as long as the lawyers, for as long as we've had lawyers, they've been the brunt of all the jokes.
Oh yeah, appropriately so too.
Well, and everybody thinks of lawyers as like, you guys are making millions, you're driving Lamborghinis around and so forth. And a lot of lawyers aren't. That said, I suspect they're getting a pretty good cut on this, on this money. So I think the lawyers will do okay. And I mean, they should, right?
From Jan, question for Rob: is punitive and compensatory, I can't say that word today, compensatory damages taxable in the USA? I think that varies per state, doesn't it?
No, I do believe that they're all taxable income. It's income to you.
Oh, so it's just the damages, the direct damages that may not be, right?
Yeah, I believe. Well, it's the direct damages might not be, but I still believe that a lot of personal injury income is income. Let me check my map. But again, I'm not a tax guy. Don't come to me for taxes.
Robert, are you doing a stream tonight going to cover the verdict form, or I see you tearing into that?
I'm gonna hold off until tomorrow. I'll recap that on Friday Night Frenzy. I took a break from work today to do this so I can go back to work.
Awesome. Ian, how about you? Are you going to delve into any of this?
There's some things I want to cover, and one of the things I'm really thinking I may do is just a video talking about like where they keep putting their video cameras, because I've got some issues with that, and I commented on it during the Paltrow case. I was like, it appears that, because in that case there was an order that they not focus on the parties, and I was like, it looks like they're willfully violating that order. That's what it looked like to me, is because they kept like lingering on Paltrow's face when they were told not to. And I'm going, like, during that verdict, we didn't need it to be locked on the face of a crying victim. And if you've got court TV and they're just kind of going with like, misery porn targeting victims of pretty horrible things, that's kind of gross. So court TV, do better. And I can say, if I was a judge and I'm getting a ruling now for, like, I'm getting court TV coming in asking for cameras, I'm going to be either saying, listen, sure, you can have cameras, but they're going to be fixed. Like, you get a camera at the witness stand and at the podium, and that's it. You don't get to move it. Or I'm going to be saying, listen, here are the rules. You get to focus on this, you get to focus on that. And I want to let you know that there is going to be money on the line. That if you guys screw up, I will hammer you. And, you know, if you guys want to eat a contempt charge, we can make that happen. Camera person, you're on notice too. This is the rules. And if you violate that, I don't care what your boss says, you have to talk to me. And, you know, I'd be like, all right, camera person, you're going to spend the night in custody. Think about what you want to do tomorrow. And because something's got to change. What we're seeing is really kind of disgusting.
Well, and we saw the Paltrow attorneys had a good handle on it. They had filed a motion prior to that case going forward, and they had the judge craft a very, very, very narrowly tailored order on what the media could and could not do. And they brought it to the attention every single time that happened. And the rules were completely fair. When the party is testifying, you can focus on the party. When they're not testifying, you can focus on the table, but you can't focus on the party's face. That was
and they violated that all the time.
Yeah, I think that's what we're going to see in Brian Koberger, is the judge really taking control of that, locking the cameras down, controlling maybe a Zoom feed, maybe a WebEx feed only, no other cameras in the courtroom. And it's definitely because of
And
that invasive
Mr.
camera
Altenberg,
style. That
I've got 4 copies of the verdict form
It's too far.
and the instructions coming.
Grant Horn
Where'd all the
says,
plans letters go?
tax guy here, punitive taxable minus lawyer fees.
Your Honor, do you see Mr.
Well, I have all the plaintiff's lawyers are out, so let's just wait.
That makes sense too, because that would be an expense to get the money. I really like this judge.
Oh, I think he's done a great job. And the suggestions that he's favoring one side too far or the other, I think he's played this right down the middle.
I haven't seen him
People were
favor
saying
anybody.
Well, yeah, people were saying that he was favoring the hospital, and how is he letting this stuff out from the plaintiffs? Look, the plaintiffs got an award that was everything they asked for, and punitives. So to say that he stacked the deck in favor of the hospital has just not played out at all.
In the waiting room, and I have a Miss Rogers, a Sharon Rogers.
Yes, sir. We were told just before this started that they would not be calling this Green, and that they would only be calling this Rogers.
Well, I have both of them in the waiting room, so.
Ms. Rogers will be first.
So you're calling both?
I believe Mr. Hunter doesn't intend to call Ms. Green.
I'm sorry, does or does not?
Yes, does.
Okay. And so everyone now has a copy of the jury instructions and verdict form, and I'm trusting that both plaintiffs and defense will fly spec it again while we are in the defense case. Too much stuff up here.
They take a break. I'll say that at the beginning of the trial, I think the reason why the judge seemed to be favoring the defense is that a lot of motions were made where the law was in favor of the defense side. Basically, the medical malpractice laws limit what the plaintiff could do, and things were getting thrown out for that reason. So it wasn't that the judge was in favor of the defense. It's just the defense had the law on their side.
We don't have a jury here. Do you need to approach, or can we just talk?
Let me just talk, I guess. We were given a number of audio, video, audio
clips, files,
clips, files, whatever they're.
And
Still gonna be
Bundy
given
says that
video
the
files we saw the other night.
Nope.
I think you're right. He got, we got, what we got was copies of what Your Honor admitted or ruled upon, and then we got audio, not video. So
Mr. Hunter, we still don't have the IJ, so if you want to play that game.
That was pretty good.
It's not.
Well, how about this? Can I have everyone's attention from the plaintiff's team?
My apologies.
Why don't we do this? Why don't we start with a defense case? In the interim, plaintiffs will re-give the video files, and before you rest, Mr. Hunter, I'll send the jury out, and then you can go look at the video files. Does that work?
I guess so, Judge.
Or do you want to?
I'm just concerned that we're going to get blamed for delaying this, given the hour and given the day and where we are. And
Okay, well, then if you want to do it now, we can do it now, and I'll keep the jury, and the jury won't know, so.
I don't have any objection to what Your Honor's doing, but I do want the opportunity to look at these things, and if indicated, to put a clip or three in, and we've got a problem with the prejudice that is being inflicted on us, given our position in presenting these things, and the potential perception that a jury that's already not particularly pleased with us is going to blame us for keeping them later.
Well,
How do you know
tell
they're
me,
not
do
pleased
you
with
want to do it now, or do
Oh,
you
he
want
knows.
me to send the jury out after you have finished with your two witnesses?
I think the two witnesses, Judge, we may make the decision that we'll go without. But
And Mr. Altenberg's trying to get near you.
I need to see.
Did whatever Mr. Altenberg just talked to you change your?
He was asking, and I thought of it. He was asking if I could step out and watch it while Mr. Shapiro is putting the next witness on. And what I told him was that I wanted to see what the next witness said, so as not to have overlap with the second witness we're calling.
Understood.
Your Honor.
Yeah.
We had requested to review the 2 boxes of additional materials that were not provided to us at the deposition of Ms. Green. We have yet to receive those.
I thought those were being brought this morning.
They were available here at the courthouse about the time the jury knocked.
So they're still available?
I believe so.
So someone can go out and look at them in the hallway or in one of the witness rooms?
We will do so. Where are?
Judge Carroll's about to drop kick one of these.
Defense, where are those boxes?
They're in one of the mediation rooms, Judge.
Do one of the
Paralegals
paralegals, can you help
Yes.
the plaintiffs? And then from the plaintiff's side, let's talk about those extra clips. Are we getting those in a position so that, I need the plaintiff's attention. Are we getting those clips that were not played here in court? They need to see them, so.
I understand. It was nothing intentional. We had some confusion. We are providing the full video clips that we have today.
And how are we doing that?
Mr. Reyes is preparing a thumb drive with the full video clips we received, and he will have them to them momentarily.
I think there's special video files that
Are we
can
ready
be
to
played
bring
on
in
an
the jury at
Alienware
this point?
computer.
Yes, Your Honor.
Plaintiffs?
Yes, Your Honor.
Let's bring in the jury.
I made an analogy last night of that this is very much like playing a game that Ian Runkle hates, football, where you have a long-term strategy. You plan the whole week on how it's supposed to go. Then you line up, you're the quarterback, you're supposed to control the entire offense, and all of a sudden one of your best offensive linemen goes down in the middle of the game. Now you have a rushing attacker coming from the side, and you have to fully improvise. The plaintiffs now have to look through 2 boxes of documents before this witness comes and takes the stand. And the judge is going to say, that's fine. That was your opportunity to look at those documents. You have to move.
Members of the jury, I want to confirm while you were away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that correct? No one from the media approached you. Is that correct? Or actually, no one, whether they are from the media or elsewise, no one approached you. Is that correct? And you haven't seen any media clips. Is that correct? Defense, your case.
Yes, we call Sharon Rogers. She's by video, Your Honor.
She's got her backdrop from Johns Hopkins so on the Zoom feed. You
And
should
what
get her here in
state is
just a
she
second.
She's here in Florida.
Okay. There we go. We'll add the spotlight. And Mr. Cottrell, are you going to be able to? There we go. Good afternoon, Ms. Rogers. This is Judge Carroll. Can you hear me okay?
I can. Can you hear me?
Absolutely, Ms. Rogers. And are you currently within the state of Florida as you sit wherever you're seated?
I am not in the state of Florida.
You're outside the state of Florida?
I am, yes.
Okay. Let me give you an instruction. I am a judge in
I'm
the
not
state of Florida, so
thrilled about
my
her background.
powers, if you will, only go to the border of.
You think they're trying to say something
the
with
state
it?
of Florida. Now, you may
I
allow
kinda
me
do.
to administer the oath to you, but if you allow me to do that, you're going to agree that any sort of action for perjury would actually occur here in Sarasota County, Florida, because that's where you're actually testifying, even though you're not physically here now with us. So understanding that and agreeing to personal jurisdiction here in Sarasota County, Florida, do you agree I can administer the oath to you?
Yes, I agree.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you give is the truth?
Yes, I do.
Okay, go ahead and lower your hand. Thank you very much. And I have Mr. Shapiro in front of me who's going to start the questioning.
Thank you, Your Honor. Can you please introduce yourself to the jury?
Hi, I'm Sharon Rogers.
And what's your current position?
I serve as Vice President and Chief Financial Officer at Johns Hopkins All Children's Hospital.
Okay, I'm going to take you back a little bit. Can you tell me where you got your undergraduate education?
Sure. I attended Indiana University in Bloomington, Indiana.
And what did you graduate with?
Bachelor's degree is in psychology.
Okay. And then did you obtain any other schooling after that?
Yes, my master's degree is also from Indiana University.
And what did you get your master's in?
The master's degree is in information science.
Okay. And did you eventually make your way to All Children's Hospital?
I did, yes.
In what year did you start at All Children's?
In 2022.
Okay. And what do you do in your current role?
I have responsibility for our financials.
Okay. And when you say financials, what do you mean? If you could explain that a little bit more.
Sure. So I handle financial reporting, budgeting for capital and operating. I work to ensure our teams understand how the financials impact the organization. I work with our executive teams to help connect financial decision, help ensure our financial decisions are grounded in data, and produce operating statistics for the organization.
Is All Children's Hospital a charitable foundation?
We have a charitable foundation.
In terms of your filing, how is All Children's organized? Maybe if you could explain what a 501c3 is.
Yes, we are a nonprofit organization, so we are here to provide care for the community. We are here to provide care for all members of the community. Of course, we're focused around pediatrics. We provide care for anyone who needs our care, regardless of payer or ability to pay.
Let me talk to you a little bit about that. Are you generally familiar with what the payer sources are for the children that you serve?
Yes, I am. We our payer sources, many are familiar that there are multiple types of payer sources, government and non-government. We are 61% Medicaid as our payer source, 35% commercial, 1% self-pay, and 3% other.
So in terms of Medicaid, the majority of the children treated at All Children's are Medicaid funded. Is that correct?
That's correct.
Okay. So when you're dealing with a Medicaid patient, are the reimbursement rates from Medicaid sufficient to pay the expenses that All Children's incurring to pay for them?
They're not. Medicaid is by far the most challenging payer. Does not cover the costs of providing care. That is pretty well known across the industry. So Medicaid covers roughly 70% or 70 cents on the dollar for the care that we provide. And given it's 61% of our payer mix, that has a significant impact on us.
So what happens if a child in need of medical care comes into All Children's with Medicaid? Do you still treat them?
Oh, absolutely. Yes.
And what if there are medications that the child needs that Medicaid doesn't cover? Do you still provide them?
we provide medications. Yes.
And where do you come up with that revenue if you're losing money on that?
We, all hospitals do their best. We are very uniquely poised because we have such a high Medicaid population. So we have fairly narrow margins. We, try to very efficient with our teams using industry best practices. We do our best to be efficient and resourceful to ensure that we can provide care for all patients who are coming in need and are in need of our care.
Let me ask you a little bit about a document that was shown to the prior witness. Do you have the 990 tax return in front of you, Ms. Rogers?
I do, yes.
And I'll put it up on the screen. It's Trial Exhibit 2279H. And for your purposes, Ms. Rogers, I'm going to turn to the second page. We'll put it on the screen as well. I want it 2279H-002. Okay.
Sorry, I had not enabled Mr. Cottrell to do that, so that was my fault. I'm sorry.
No problem. Can you enlarge that a little bit, Clay? Okay, and scroll down a little bit. There's total revenue lines. You see at line 12 the revenue for the year. Are you able to see that, the 544?
Yes, okay.
Yeah.
Yes, I see it now. Yes.
Okay. And there's for the prior year and the current year. Do you see that?
Yes.
And then, for example, in the prior year of this tax return, what was the revenue?
Prior year's revenue was $544 million.
And
$192.
And what were the expenses?
Prior year's total expenses, $563 million.
So did the hospital run a shortfall on revenue in the prior year of 2020 of almost 19 million?
Yes.
And was that the year, that was COVID, is that right?
The prior year was the start of COVID.
Okay. But the hospital keeps its doors open even though they had outspent what they took in. How do you do that? Do you tap into reserves or what's the function?
Yes. So the hospital kept its doors open. We did have to tap into reserves during the early period of COVID. We continued to provide care for the community. There were a lot of expense increases, not only in the early days, but especially in the periods following COVID. Volumes dropped significantly. So there were a lot of adjustments that had to be made, not only in the beginning of COVID, but a lot of adjustments had to be made afterward as well.
Let me ask you about the line 8 contributions and grants. What is that?
That represents primarily two items, one being a Healthy Start, which is a grant that's received, but in large part it is provider relief funds, which is our CARES Act, which is a federally provided fund that was given to many hospitals across the country to help support the period of the pandemic.
Did that CARES Act money, that $33.447 million, did that continue into this year or is that now gone?
That is now gone.
Okay. So that was a one-time funding from the federal government during the period of COVID?
That's correct.
Let me ask you a little bit about the capital, the $19 million in capital that's spent. And you can take that down for now, Clay. What does it mean to spend money on capital improvement?
Sure. So Like any large organization, you want to reinvest in the organization in order to keep up with routine maintenance, not only with routine maintenance, but you want to also be able to strategically invest. Most organizations, you want to be able to keep up with the rate of depreciation. We spent $19 million in capital this year, in the year that you're talking about. That does not keep up with the rate of depreciation. That was to handle some general routine maintenance. You want to make sure that everything from roofs to HVAC systems to elevator equipment, that you are keeping up with those things so that you don't get into problems down the line.
Okay. That money is used to ensure safety at the hospital. Is that right?
That's exactly right.
Now, in terms of the jury has seen that there's about $500 million in potential investments that the hospital keeps on its balance sheets. Can you tell the jury what's that for?
Sure. So any large organization needs to have a healthy balance sheet. We are no different from needing to have a healthy balance sheet. That balance sheet and those investments are, well, one, having a healthy balance sheet is important. Creditors look at that. If we are going to borrow, they want to ensure that we are fiscally sound. Having a healthy, having access to investments allows us to continue to provide care to the community that helps us uphold our mission. So not only those routine investments, strategic capital investments, but large strategic investments are really important. Every dollar that we have really needs to go back into the community. So that available investment pool is there for that purpose.
What happens if that amount gets depleted? Meaning, does that affect your ability to borrow money or credit rating agencies? Can you explain that, please?
Yes, if that money is depleted, that affects our credit rating agency. Absolutely, it affects us in the case of an emergency. I mentioned that during the period of the pandemic, we had to access and tap into that pool because of the emergency period that we were in. We wouldn't have access to that. Also, projects that are growing and extending our care to the children of our community who need us, that money is there for them, for those strategic growth projects that would allow us to expand our care.
Do you have outreach clinics in Sarasota?
Yes.
And if you know, do those operate at a profit or a loss?
So our clinics generally operate at a loss. This is pretty consistent where clinics operate at a loss.
May we approach these lines of questioning?
We're gonna try to bring Kurt on. Kurt has been following this case as well, and analyzing some of the stuff from day to day. Send him a link here. We'll see if he can join us. We're going to have some of the best legal minds available on YouTube right here. You can't pay for this quality. You really can't. So thank you, Ian, Rob. I don't know how long either of you are able to stay. I appreciate you guys being here. We're going to see if Kurt can join us a little bit. And
yeah, don't mind me. When I turn sideways, I'm doing work and just listening in.
When you turn sideways, I imagine that's billable hours, right?
Yeah, quasi. Yeah.
I'm doing a bit of the same, but it is interesting. One thing I'm noticing is how many times they're repeating certain lines. The back to the community line.
Oh yeah.
And that tells me, and juries aren't dumb. I'm sure they're sitting there going, like, they've got a rehearsed party line here. So that's what I immediately think when I see that.
Kurt, welcome.
Yeah. Thank you very much. Glad to be here.
Hey, Kurt.
So what I've heard from Mr. Shapiro over and over is basically we're a 501c3. We're a charitable organization. We need the money for the upgrades. It's all for the children. We run a net loss on a lot of these community outreach programs, the ones that do the most good for the people in the most need, and basically don't don't slap us with anything, because in fact, it doesn't hurt us. It hurts the people who need it, the
Is
kids.
that a real loss or is that Hollywood accounting loss?
You can unmute, Mr. Rogers.
I've got to open up the microphones again. Ms. Rogers, go ahead and unmute yourself, please. Can you hear me okay now, ma'am?
I can. Can you hear me?
Yes, absolutely. Mr. Shapiro, you may continue.
Sure. In the year, for example, 2020, 2021, did the clinics in the outreach clinics like those in Sarasota operate at a loss?
Yes.
And where does the shortfall come from? Does that come from the hospital?
Yes, it's made up by the hospital.
Okay. Let me turn back to some of the sources of revenue at the hospital that may cover that shortfall. Well, let me ask you if you know, just to cover this. Do you know what the largest source of funding is in terms of program?
Our NICU is our largest source. We care for the most critically acute or sickest children in our community, and our NICU is by far the largest program and revenue source.
And we're all familiar, at least with the acronym. That's the neonatal intensive care unit.
Yes, sir.
Is that, if you're familiar, is that where babies go when they're struggling to breathe after birth?
Wow.
Yes, sir.
Okay. And do you know, in terms of acuity, where All Children's ranks, at least state, local, in terms of what our All Children's acuity is versus other hospitals?
Projection, foundation,
Yes.
relevance.
Overruled.
You can answer.
We care for the sickest or the most acute babies in the state of Florida.
Okay. What about respiratory therapy? Is that another category that is one of the larger programs?
Yes, it is.
Okay. And what types of services does that cover?
Respiratory therapy is helping. It is also helping ensure that our patients and children can breathe effectively, and caring for inpatients in the hospital.
Do you know what comes next in terms of the order of funding sources, programs?
Our surgical care program is a very strong program as well.
Okay. Does that include both surgery for kids? Does that include children born in the neonatal intensive care unit?
Yes. Yes, it does.
Does that include children that have been afflicted with cancer and need surgery?
Yes, it does.
And are those programs, from your knowledge in terms of strategic planning, that All Children's is looking to expand if they have the resources to do so?
Yes, absolutely.
And do children, both those who are born with cancer and those who are born with congenital anomalies down in Sarasota, do you serve that population?
Yes, we do.
I don't get the feel
And do you
she's reading.
provide outpatient clinics to make it easier for people in the Sarasota area to access your services?
Yes, we do. It's important for us that we are providing care to our patients close to where they reside.
Let me talk to you about the concept of money being fungible. Do you know what that means?
Yes, I believe I know what you're referring to.
So let me try to break it down. Every dollar that's spent on something, you have a pool of money. You can either spend it on patient care operations or you can spend it on something else. Is that right?
Yes.
Okay. So just to be clear, the money that's left over at the end of the year, is it reinvested back into the organization?
Yes.
Let's be nice to the witness,
And
guys.
the money
Please be
that's
polite and
reinvested back into the organization, does it go into strategic planning to help sick children in the community, including those who have cancer, those who are born with congenital anomalies? Is that true?
Yes.
And we heard, you weren't here for it, but the concept of well, All Children's could just sell land and lease it back. Are you generally familiar of like sale leasebacks and what that entails?
I'm familiar with that concept.
That would cost All Children's money if they had to sell property and then lease it. Well, let me ask you. Would it lead to All Children's having a negative cash flow situation relative to where you are now if you had to sell property and lease it back to yourself?
Objection, leading vague, ambiguous.
Overruled. She can answer.
Objection, everything.
That would take funds out of our operating income if we had to pursue that option.
And when you say operating income, the number one goal of the operating income is to provide.
Objection, leading.
Stop leading.
Let me just ask you, what is the goal of the operating income?
There you go.
Well, the goal is to ensure that we have money to be able to provide care to fulfill our mission.
I'm trying, Judge.
Which includes caring for the community's most vulnerable children throughout the community. And that extends from sick children to, research, providing innovative care, ensuring access to drugs and therapies.
What if any sick children would die if
as well as those capital routine maintenance capital projects that I mentioned in strategic projects.
When you talk about strategic projects, as the CFO, does All Children's have the revenue right now to fund them all?
No, we don't. We have historically underspent on some of our capital needs and are assessing those now. Of course, keeping safety first and have pursued the items that we absolutely need to.
$238 million.
But there is a lot on the list of things that we both need and want to do that has not been pursued.
If All Children's were required to pay a punitive award in this case where the money left the hospital, would that cause you as a CFO to go to the strategic planning committee and tell them there are certain projects where you're trying to save lives in the community that now need to go on hold?
Leading.
Yes, it would put a stop to those plans.
Incredibly leading.
One moment, Your Honor.
You need to do what if any.
The answer is obvious, but like the sick children thing,
are you telling me children will die if we have to pay a like?
Just.
Are you saying that a punitive damage would be exactly the same as murdering a child?
The point is valid. There's money that gets removed.
Good afternoon, Ms. Rogers.
Good afternoon.
Thank you for joining us on short notice. Where are you physically today?
I'm in Indiana today.
Understood.
Did you
Does
cross
Johns
state
Hopkins
lines?
have a hospital in Indiana?
No, no, they don't.
I'm curious to know who writes or who you're employed by. Is it Johns Hopkins All Children's Hospital or the system?
I'm employed by Johns Hopkins All Children's Hospital.
Understood.
Where you going with this, Whitney?
I want to discuss with you and this shouldn't take long. I want to discuss with you the tax returns that are in evidence. And I want to begin with what's been marked as 2279 Hotel. Mr. Reyes, if you could please publish or share 2279 Hotel. In one moment, Ms. Rogers, just dealing with the technology.
Ask how much the CEO makes. That'd be good.
By the way, Ms. Rogers, while we're waiting for that, were you scheduled to attend a deposition at 1:00 this afternoon?
Yes, I attended and then was told that it was put on hold.
Understood. So you and I have not had an opportunity. I'm sorry.
Guys, for once, that's not our end.
You and I have not had an opportunity to speak before, have we?
No.
Are we close? Ms. Rogers, while we're 2279 Hotel. while we're pulling that up, do you also have in front of you there the fiscal year 22 Form 990?
Yes.
Is there a fiscal year 23 Form 990 that's been filed yet?
'23?
Yes, ma'am.
Not yet.
If I understand correctly, the fiscal year for Johns Hopkins All Children's Hospital ends on June 30th each year. Is that right?
That's correct.
And so, just out of curiosity, what month is the latest fiscal year's tax return typically filed?
It is typically.
This is
You'll
something
have to
she should
excuse
know.
me,
I think.
because I will have to check. I am newer to the organization, so I don't know the typical month. I know we're finishing our audit for fiscal year 23 at the moment.
Understood. And yeah, thank you for reminding me of that. You joined Johns Hopkins All Children's Hospital last year.
Beginning of last year. Yes.
All right. And so you weren't around when the 2021 tax return was prepared, or the 2020, right? Ma'am?
I was in place to acknowledge it and review the 2021.
Typing?
Oh, you were? All right. All right. Turning to what's in front of you, and can you see the
Not
tax
me.
return on your screen, ma'am?
Yes.
All right.
It's on the court
If
feed.
we would turn to the next page. And Mr. Reyes, if you would focus in on line 19 here.
I wonder if she's IMing somebody right now in the background. That'd be hilarious.
If you could
That'd
zoom in on line
be
19,
a
please.
good way to get into a lot of trouble.
Do you see line 19, ma'am?
I do.
And so the $19 million loss that you discussed with Mr. Shapiro there, that was the prior year, correct?
That's correct.
And you discussed the loss at some length, but the next year, the
There's something
hospital
off
had a
screen.
profit of $36 million,
She's
right?
glancing off screen a lot.
That's correct.
And if we turned to the 2021 form, which would have been filed in 2022, just keep this here for now. The next year, you had a profit of $31 million, correct?
Yes, 30.8 million. Yes.
And so that year that we saw there in the 3-year trend that we have is the outlier, the loss of $19 million, right?
You have to consider it is not, if you went back to the prior year, the year before, the one that's shown with the negative 18, you would see an even more significant loss than that listed. And you have to factor in the one-time receipts of the CARES Act, the Provider Relief Act funds that we received during this period.
For the 2 most recent years on file, Johns Hopkins All Children's Hospital had profits of $36 million and then $31 million. Am I correct?
Yes, we received over $60 million in provider relief funds.
So the 2 most recent years on file, Johns Hopkins All Children's Hospital has been profitable. Correct?
Correct, with the inclusion of the provider relief funds.
Understood. And the hospital wouldn't end up with a $600 million cash accounts and cash equivalent balance if it had been operating at a loss over its history, would it?
No, not if you look at the history in total.
All right.
If you look at the recent year's performance, the
Cash on
hospital
hand,
has
right?
had very challenging years, which, and you would see that the operating margin has been very much challenged.
So $30 million profit and $35 million profit, you would characterize those as challenging years?
Yes, absolutely, because the revenue that is leading to that bottom line there is a one-time, not something that's sustainable. And so, like with any of our, families or home situations, we want to be able to have income that we can depend on. And those one-time provider relief funds and CARES Act payments aren't something that we can continue to rely upon into the future. Those were temporary infusions that we received during the pandemic, which was obviously an outlier period. So those are very unique circumstances.
I'll move to strike the answer to the extent it was non-responsive.
Overruled.
Ma'am, over the history of Johns Hopkins All Children's Hospital, it has on more years operated at a profit, leading to a $600 million cash and cash equivalents balance as of 2020, correct?
Well, to clarify, when you speak to the history, the entire history of the hospital, I can't go back to the entire history of the hospital.
It must necessarily be true. The answer
But
is yes.
when we're looking at our recent performance and decisions that we're making now based on our current operating margin, we have to look at how we're performing right now and how we performed in recent years in order to determine what decisions we're making now and what free cash flow looks like right now.
It's about
That's
200
the
million.
challenge.
Mr. Reyes, if you could turn to this same document, what Mr. Heath referenced, which was labeled in the top corner, page 9. And I think that's page 11 or 12 in actuality. Perfect. Nope. I see that.
He's like, I am on page 9.
Can you scroll forward and back a couple pages? I'm not sure. Next.
So I'm thinking if the jury
Back.
agrees with what they're hearing from the
Back.
defense, I still think they go with punitive, but they limit it to the cash on hand.
Why is this not matching up?
60 million,
I have a moment,
something
Your Honor.
like that.
Sure.
I would agree with that. If they
I
buy
can't
this,
see them saying, yeah, you've got to sell your hospital. and
Yeah, no,
lease
that's
it.
I can't see them going like the lease back plan. Just makes no sense to me.
what do you think their insurance policy will pay out for that compensatory?
I'm guessing the full amount.
Do you think 220 or 200 plus million?
That's one hell of an insurance plan.
That's
I mean, it depends on how their insurance plan is set up. But if their insurance plan is set up for a yearly versus per instance, I mean, if it's not,
true.
if
If they
it's
have
set
like
up,
a yearly cap.
If
Yeah.
you could display that page, please. My apologies, Ms. Rogers. All right. You recognize this as the All Children's balance sheet as reported in 2021?
Yes.
And is it accurate that after factoring in depreciation, the book value of the land, buildings, and equipment held by Johns Hopkins All Children's Hospital was $400 million, just under $400 million as of 2021?
The answer is yes. Like it's not complicated.
Yes.
And would
just
you
doesn't
agree
like
with
the
me that if you look at the figure $651 million and change, that the $400 million we see reflected in terms of book value of the real estate significantly underestimates the market value of land, buildings, equipment as of 2021?
I can't speak to that.
You'd agree with me that the value before factoring in depreciation was $652 million approximately?
The red arrow is
Your question is
My question is, ma'am, in box 10A, before you factor in depreciation, which is a tax concept, is it not?
It is.
That the value of the buildings, equipment, and land was $652 million before depreciation.
Just answer the question.
Yes.
Have you, since you've been at Johns Hopkins All Children's Hospital, has the hospital had the value of its real estate, including land, buildings, and equipment, appraised?
Oh no. Oh no.
Yes,
I bet
yes,
they
you have.
In total, I would have to verify.
Oh, don't weasel.
I would have to verify that. I'd have to defer to our operations team.
Do you have an estimate of the?
In about every single piece of land, I'd have to validate that.
But in your role as CFO, do you have a rough estimate of the appraised value, market value of the land, buildings, and equipment currently held by Johns Hopkins All Children's Hospital?
I would prefer not to provide a rough estimate.
Why is that?
Well,
I don't have a rough estimate.
You're in court. It's not about what
You're
you
not familiar.
prefer.
All right. Moving on.
CFO doesn't know.
Line 11.
Hammer. Damn it.
Publicly traded securities. It's accurate that as of 2021, Johns Hopkins All Children's Hospital
Why
held approximately $518 million in publicly traded securities.
make her answer the question?
That's correct.
What are the top 5 holdings of Johns Hopkins All Children's Hospital in terms of public securities?
I would need
Treasury
to.
bonds.
I'd need to validate that.
Would they be Dow stocks like we would expect, Apple, Google, Microsoft, et cetera?
No, we have complex. I mean, we have just like any organization. We have investment portfolios that are managed. So it's not individual stocks.
Are you aware, even through your investment vehicles, what the top 5 holdings of publicly traded securities are?
No, not with individual companies.
If we look at the category of investments program related, and I see $24,265,000, what are we talking about there?
On
Line 13, ma'am.
okay, that
Can
is.
we get a sidebar, please?
Yeah, no kidding. I want to know what she's doing on that computer.
If she's typing with someone,
Apologize.
that's muy bueno. That's muy. The tone
Those
of your
are
screen
our
is changing. Can we?
board designated investment holdings.
Counsel, you got to get on this.
Can you give us an
This is
example or
big.
two?
Also, have you noticed that sometimes the color on her
I'm not
face
sure what
changes
you're.
from the screen?
I'm not sure what you're looking for.
Oh,
Yeah.
well, you just mentioned they were
Yeah.
board directed investment holdings. I was wondering if you could give us what those would be in concrete terms. What does that mean? What are they?
No, I don't have the names of the funds.
And then
I don't have the names of the funds written.
Understood. And line 15, other assets of $46 million. Do you see line 15, Ms. Rogers?
Yes. Yes.
Well-
And I'm sorry, 13, those are board designated funds used that's for the debt service.
Understood.
Can you
No.
pick up the grilling, Whitney?
Those are for debt service.
This is a
And then $46 million on line 15, other assets. Do you see that, Ms. Rogers?
Yes.
What are we talking about there? What types of other assets?
Here she goes. Type. You type. Ready? Are
He's
you
letting her
phoning
off
a
way
friend,
too
ma'am?
easily.
Correct me if I'm wrong, but the CFO should pretty much know what these numbers are from, right?
Well, there's an explanation. Here's the thing: if she's allowed to have her notes, she's a CFO. You're allowed to testify based on your notes if you have that. If you need to access them, you need to access them. But you have to disclose that you're looking at your notes. You have to make it
That
clear that you're looking at your
is
notes, and you have to give those notes to the person who's asking the question.
Right of use, prepaid inventory.
Are you finished with your answer, ma'am?
Yes.
All right. And would you agree with me that as of the filing date here of June 30th, 2021, Johns Hopkins All Children's Hospital held total assets of $1,163 million and change?
Total assets, yes.
Nothing further this
As reported there.
Nothing further this time. Thank you.
Oh, he left so much on the table.
I
redirect
jury
briefly.
she's distracted.
Ms. Rogers, you there?
Yes.
Okay. When Mr. Whitney was asking about income of 36 million, 31 million, that all goes back into the hospital. It's not distributed as profit.
Objection,
correct?
meeting.
Overruled.
That's correct.
And so, in other words, if All Children's is able to operate at a profit, they take the money back and devote it back into patient care in the community. Is that right?
Yes. All of the money goes back into the hospital in order to expand programs, extend programs, compensate team members, compensate providers. All of the money stays within the hospital. Patients.
And every dollar that you don't have available, whether it goes out in a punitive damages award or otherwise, is the dollar that All Children's does not have to fund patient care, including helping children struggling to breathe in a neonatal ICU, children with cancer. Is that true?
That is true. Yes.
Thank you.
Anything further, Mr. Whitney?
No, Your Honor.
Hold on a second, Ms. Rogers. Let me see if the jury has any questions.
Hang on there.
There's going to be a jury question, so just hang tight.
I
Ms.
admit
Rogers,
Mr.
I'm
Whitney
gonna
did not
unmute
do
your microphone.
Mr. Whitney did not do a stellar job on that, but he did not get a depot on that. They were scheduled for a depot at 1 o'clock, and that did not happen. Had he had time to sort of flesh some of these out, I think he would have been able to chase those rabbits that she left dangling, where she said, "I'd prefer not to say." That's like,
no, I know.
it's
But
punch
When she
here.
says I'd prefer not to say, you just say, like, this is not a preference. Answer the question.
And this is a witness that is like very, very at that point in time openly evasive to your questions, is clearly distracted. The fact that he didn't draw the attention to the fact that she's distracted, that to me was frustrating.
Yeah.
Like, are you distracted, ma'am? Or do you need me to repeat the question? Are you doing something else right now?
Would you tell this court what it is you're doing right now?
Is there someone else in the room who's handing you papers or Googling stuff for you? Because the delay between the question and her answer for, what is this figure? What does it mean?
Are these your answers, or are you getting a message right now?
You can't talk to a witness when they're on the stand. That's very illegal.
Yep. Who are you talking to? And if the answer is counsel, counsel's in a world of hurt. I don't think it is. But I mean, there is a possibility she might be talking to somebody from the hospital.
Hey, to all three of you who are much better at StreamYard than I am, is it possible to have you three on the left and me on the right? Is there an easy way to do that? Or?
It should be somewhere on the settings for that.
Because we've got a lot of people watching on TV, and chat is covering you three as it's scrolling up. If they have this chat on there, I was trying to
On the
fix
bottom,
it for you.
on the bottom, it has different layouts. I think it gives you a list of different layout options.
We just nuked Rob. Or he disconnected.
Yeah. So right below the window, there should be like a bunch of like little boxes that show different layout options.
I think I need to build a new layout. I haven't done anything with it, so I've only got the. Oh wait. Here we go. So this one.
Well, we moved it around. That's a start.
We're halfway there. That's all I've got. Sorry, that's the extent of my technical knowledge when it comes to StreamYard.
Can you like physically drag the things? Is that possible?
I'm worried where it will put you. I mean, I'll drag you around and.
Exciting.
Yeah, I can put you in the big box. That's about all I can do.
It's also very exciting for me.
I'll do some work offline and learn this.
All right, fair enough.
All right, it's I didn't see how many questions were coming in from the jury. Granted, we're down to 6 instead of the 12 or the 11 we've had previously, so obviously fewer question writers means probably fewer questions.
You know, that now that they know how much cash is on hand, they're probably going to feel a lot less bad about writing bigger dollar amounts. Won't this take money away from the cancer-ridden, not breathing children, though? It's pretty thick. Just laying it on a little thick there.
I mean, they had to, but it got a little obnoxious.
Why don't they just put a picture of a deer on the screen with like the big cartoon eyes and be like, this deer will be sad if you find them any more money.
They've got to pull at the heartstrings a little bit. I mean,
Here are the pictures of the actual children that you could kill.
Yeah, isn't this a patient in the NICU? This child right here, don't they need the money more than Maya does? Woof.
yeah, there was no question about CEO pay, salary pay. I realize this is a massive organization, and
I would have asked the CFO what she makes. I would have asked her what the CEO makes.
Yeah, I'd be surprised if she's clearly in the 6 figures, and probably comfortably
like 7,
so.
to be honest.
I love the comment from the chat. She was updating her resume.
She's got a new LinkedIn profile, so.
Isn't it true you're the CFO of Johns Hopkins? Not anymore. I've tendered my resignation 5 minutes ago. I'm out.
Then you got to do the mic drop.
Yeah.
I don't know if Rob had somewhere to go. I promise I didn't boot him out. He might have had an internet issue on his side as well. If he's able to come back, he's got the invite to come back. So he's been delving into the verdict form, the 48 questions of the verdict form, looking at that. So did they just get another question handed to them? Was that a second? I'm really hoping that we get an insight into where the jury's leaning on this. Now that they know where the punitive damages are going, that it goes to the plaintiff. I think we're going to have a quick response. It's going to be tonight, for sure.
I think the jury's ready to be out of there. They just realized they got to write a lot of zeros first.
Ms. Rogers, if we could go ahead and have you unmute. Are you able to hear me?
I can.
There's a series of questions. Based on what I heard Mr. Shapiro comment on about the 2020 Johns Hopkins All Children's Hospital tax return, which is the only tax return this jury has been allowed to view, in 2020, you basically lost money between what you took in and then what your expenses were. Is that correct?
Between 2020, yes.
Okay. You pointed out that this was a COVID area year. Therefore, your income was not that of the non-COVID years. Is that my understanding of what I believe you were stating?
Is that your understanding?
Can I restate your question to make sure I'm?
Yes, you may.
Yes.
Okay. So this was a COVID era. So this was, our income was not what we were used to. That is not exactly correct. We are not a hospital that has high margins in a normal year. Because of our challenging payer mix, we are not a hospital that has a benefit of having large margins in a normal year. The COVID period made things even more challenging for us because of all of the challenges that came with the pandemic. During COVID, we received a one-time payout that hospitals across the country received to help during that period. So that number is represented in the financial statements for those COVID years.
Okay. Next question. Are you saying that Johns Hopkins All Children's Hospital is forever operating in the, quote, financial red, end quote, and never makes enough money for upgrades to better your programs, surgical rooms, or even research?
Not forever, but for the past 5 years, 3 of those 4, actually I'm looking at 4 years, 3 of those 4 years without the provider relief funds have been negative. And the one that wasn't, it was less than 1% margin. So very narrow margins. Which means we have to tap into other sources.
A 501c3 is a nonprofit, but by no means does it mean that it cannot make money. I see just 1 year's tax balance sheet, and Johns Hopkins All Children's Hospital carry balance and assets, at least in the COVID bad income year 2020, about $1.2 billion. So am I correct that nonprofit does not mean no money?
Correct. Nonprofit doesn't mean that an organization is not allowed to have funds available. Those funds are used to be able to expand and extend the mission of the organization. And it is the intent of those funds to be able to deliver upon the mission. That's the purpose of those funds.
You mentioned that every dollar goes to pay for items and it goes back into the hospital. But Johns Hopkins All Children's Hospital does have, for just the 2020 tax file, in cash, securities, and assets, about $1.2 billion saved up in various forms that Johns Hopkins All Children's Hospital declared on federal taxes. So not everything goes back into the bill. Am I correct?
So the $1.2 billion that is on the balance sheet, that is not available. That includes buildings and lots of other assets that aren't accessible. It includes many different things. There are some. There is a portion of that is for strategic investments.
Mr. Shapiro, do you have any further questions of this witness?
Yeah. Just briefly, so the cash, if you have a shortfall, then you can tap into those reserves. Is that right?
That's correct.
Okay. And again, whether you have a profit of 1 million or 33 million, or if it's a good year and it's a little higher, when you think of profit, all of that money goes back into saving children's lives in this community. Is that true?
Yes. It all goes to advance our mission.
Mr. Whitney, anything further?
No, Your Honor.
Do the jurors have more questions?
The jurors have been fixated on that $1.2 billion number, which is probably not very pleasing for Mr. Shapiro.
Aw, Muffin. I'm okay if Mr. Shapiro has a bad day.
Mr. Shapiro is just the attorney, not the client. The client's the jerk. Mr. Shapiro is just trying to keep his client in check.
And it's not just that the client corporation is the jerk. It's this is a tough one. Like when you get to punitives on this case, I know that Jay Hatch did a ton, but I don't want to see a hospital. I don't want to see a hospital that does do good, treat and has, from what I have seen, done a whole lot to address it. Even Corcoran said the hospital has brought in a whole new team. The new team's done great. They have great plans in place. I don't want to see that hospital become unable to help kids if they've done the right things to put the stuff in place to fix the issues they had.
I want to see the hospital recover and get better, but I also want to see this end some people's careers. Where it's just like, oh, you were involved in that case, and that's why you're looking for a job now? No. No, we're not.
And Ms. Rogers, if you can unmute your microphone. Members of the jury, I'm not going to be able to ask that last question. Mr. Shapiro, do you have any further questions?
No, thank you, Your Honor.
Mr. Whitney, anything further? No. Okay, Ms. Rogers, thank you very much for being here.
Thank you.
Okay, members of the jury, what we're going to do is we're going to take a 10 to 15 minute break. I'm going to ask the court deputies to take your dinner order at this time. So it's going to take us a little bit longer for this break. Do not discuss this case amongst yourselves. Do not do any investigation and
What are they
receive
getting?
no information. We'll call you back in 10 to 15 minutes.
All right.
What did you get for $220 million? It's got to be a good dinner, right?
This one is, well, I don't know. He's going to address the attorneys, right? Presumably.
I think we're done.
All right, so
Leave the bench.
Judge left the bench. I don't think we're.
Steve, is there anything we need to address before we take our 10-minute break?
The only thing I want to bring to your attention, Your Honor, is it occurred to me in this unusual situation, I need to move for a directed verdict on specific intent. I would have had it been pled in the front end, I would have moved for it at the end of their case and at the end of all the evidence. But before this goes to the jury, I think I need to make the argument that they have never proved the evidence required for specific intent on any of these claims.
Okay, what I'll do is I'll take it under advisement. I'm going to allow it to go to the jury, but I will keep it under advisement. Okay?
You will.
Thank you.
Okay, 10-minute break.
All rise. Court in recess.
At the risk of pointing out the obvious, intent can be shown by actions. That's one of the principal ways you show intent. There is more than enough information from which a reasonable jury could conclude this was done with intent. So, no.
So he was saying that the specific intent. So the argument that's being made there, Kurt, is a little bit nuanced, and I caught the tail end of it when Altenberg was making it. It's that the hospital wasn't placed on pleading notice. So you've got the pleading notice requirement for punitive damages. Punitive damages require specific intent, and so throughout the claims, Altenberg is saying that you have to allege specific intent existed in order to substantiate and support your punitive damages claim.
I see.
So it's a technical
So they're saying it's
argument.
absent from the pleading. Okay, that's fair then. Fair enough.
Yeah, so he's saying it wasn't in the pleadings, and even though the evidence as adduced would suggest there was specific intent, and the jury might be able to make that finding, they weren't on pleading notice to get there.
Fair enough. Okay. I don't know the answer to that question then.
So the judge saying he's going to take the directed verdict under advisement. If the jury deliberates, it's a little too late. Then it's the J-Nov only afterwards, right?
Oh, no, the judge has already said it's J-Nov. Like when the judge said I'm taking it under advisement, I'm letting it go to the jury. That basically means now your argument is a judgment notwithstanding the verdict.
Yeah.
But he has to make it for timing purposes because he at least has to make the motion to shift the burden to the judge to say, I'm not going to rule on it now. I'll let you make the motion later in a different format.
Yeah. Preserve the issue.
Yep. Which, I don't know. Alton Burn was reverb, Scott. Okay.
Sorry.
Scott, you got a couple of people there. Lady Drake, if you can post a comment in all caps, maybe Scott can find it and maybe mod you. Same with Sandy, because there's a bunch of people in chat right now. And Scott and I have similar rules. And, one of the rules that I've got with my chat is you can make comments about the testimony being relayed, but not the person that's relaying the testimony. We're not going to go into a back and forth mudslinging competition over the individuals on the screen. And especially when we're talking about the hospital as a whole, I want people to keep in mind that hospitals do a great deal, and a lot of them do face personal injury claims a lot of times. This one is one specific case. We're talking about one specific case. We're talking about Maya Kowalski and whether punitive damages are appropriate. There's going to be some heated discussion. There's going to be some heated opinions. Please be respectful in the chat. Otherwise, this video risks getting taken down by YouTube because, yes, YouTube filters do see the chat comments when it get reposted, and videos have been taken down for commentary and chat dialogues before. Please be respectful and don't fight with the mods. That's a losing battle. They're going to time you out and block you before all of your comments are not a big enough reason to not have Scott's channel taken down. So he's going to protect his channel, and that's the way to go.
All right, I got Lady Draconis. Is there anyone else that you?
Sandy, if you're in the
volunteer?
chat.
Sandy's a great mod.
Sandy, type again. The chat is a blur. I'm having a hard time even reading it as it goes by.
I know, and that's the problem. And what I've noticed is there's a whole lot of members here, and the fact that a lot of members are here, members evade slow mode. So slow mode, members are immune to slow mode, which means that it keeps flying.
Why are there balloons?
I don't know, Scott. That's
a you issue, man.
I don't know why there are balloons going up. I have nothing.
Trigger like every
I have
1,000
nothing on my end
years
that would make
before.
balloons happen.
You just cross the threshold subscribers.
Hang on. Did Court TV? Maybe? I don't know.
If it's Court TV pointing the balloons on the screen, that's pretty funny.
Yeah.
Maybe they're celebrating for Maya.
Mm-hmm. So Scott's channel hit 50,000 subscribers. That's a reminder to a lot of the new viewers here. I know there's about 11,000 of you who are watching here right now. Okay. Hi, I'm Rob, channel Law and Lumber. Above me is Kurt, channel Uncivil Law, and above him is Ian Runkle the Bailey. And our host today is Recovery Addict Scott. He has done a phenomenal job covering this trial, gavel to gavel, and has his channel has grown commensurate with the quality of coverage as the trial has gone on. I know that Kurt has jumped in and done some coverage and done recaps of this trial and has done a great job at doing that. But I've really enjoyed seeing Scott's channel grow. If you are here, I will borrow a phrase that my friend Kurt above me uses quite often. If you see the little button that's beneath the screen, and that button is gray and dull and boring, that button that says like, that little thumbs up, you need to hit it. You need to turn it from the dull and gray monotony of the rest of the world that exists and make it a bright red color that says that you have liked this stream. And if you wouldn't mind hitting that subscribe button so that you can catch all of this commentary as he continues to cover trials. He's done a great job at doing that trial coverage. I'm speaking a lot because he's doing a whole lot on the back end right now to try and manage the 11,000 of you that are in chat. So that's why.
Are you streaming tonight, Rob?
No, I am not streaming tonight. I'm
All
going to keep my remarks.
Kurt, are you going to follow this one tonight?
I will be streaming. I typically stream on Thursday nights at 8, so I'll go ahead and post that so that we can do that for my regular Thursday night stream. But it will include much more.
I've got a podcast
commentary.
I've got a podcast at 8 tonight. It'll last for about an hour, but I'd love to join afterwards, or not join, but maybe I'd steer people your way afterwards if I could.
Sweet.
Okay, so I do apologize. I still am fighting the audio loop. If I talk, there's feedback. Unless I turn them way down, then I cannot hear Rob, Kurt, or Ian in my headphones. I can only hear myself, so I have to hear them on my laptop. And I'm scared to touch anything because it was so bad. We got it working, so it's don't break it. I'll fix it later. But yeah, I do appreciate it, Rob. Thank you, and thanks for donating a couple great mods to help out my mods who are.
I may have the solution to your problem on the audio thing. For some reason, StreamYard sets the audio output specifically for it different than the system audio. So if you go down to your settings in StreamYard and go to audio, it will list the speaker. Make sure that you're using the right speaker inside StreamYard. It does not default to the Windows default speaker.
Yeah, my problem is I've got hardware interfaces I normally run audio through, and so when I tie in StreamYard, it creates an audio loop, and I have to do a mix minus, a USB mix minus, and solo things. And it's a beast of my own creation, so it's my own fault.
Another suggestion from Anselmo, not the helpful suggestion he thought it was. Oh well,
These are a lot of big words that I don't know. I know the law words. I don't know any of these other things. I don't know. So the jury's going to have their dinner, or they're going to have their dinner. A hospital's done with their witnesses, or did they just take a break?
So they've got one more witness. I thought they said they might do both. They were going to do Miss Green as well from the depot on Friday.
That's a nightmare scenario. I mean, they deposed Green. That depot was pretty brutal. So, okay. What do you think the jury's going to take as far as deliberation? I think the jury's going to take an hour, maybe 45 minutes. Pick a number, come back.
Probably right.
Time Lords, can you type in chat for me?
I guess I'm slightly surprised, but not totally surprised that they basically blew out the top. I mean, they came in, at 211 million instead of 238 million that they asked for. So close enough, right? What's 10% between friends?
I mean,
I'd take that 10%.
It was the thing that surprised me was this argument of the causation and the substantial contributing factor to Beata Kowalski's decision to end her life. This is a rather novel issue in civil litigation.
Oh, yeah.
It's been heard in criminal cases, and you have statutes to back it up. But as far as creating a legal theory for liability, this is really new. And the fact that this got to verdict, I mean, this is going to be the one that's most likely to be challenged on appeal, and I think that is at the highest risk on appeal, because the judge has jumped out into the void and trying to figure out how we're going to get these to a jury verdict. Substantial contributing factor, where the mind, what was the specific language? God, what was it? Where she lost control. It was essentially.
Oh, it was an irresistible impulse, I think it was.
Impulse, yeah. Yes. The hospital created in the mind of Beata Kowalski an irresistible impulse, and that the hospital's conduct was a substantial contributing factor to the creation of that irresistible impulse. And at that point in time, you have waded into a world where there's a ton of unanswered questions. What is the substantial contributing factor? How much? Do you need to be 51%, just 32%, 10%? And then you have the intervening decision by Beata Kowalski. And if there was any independent thought there that stood apart from the irresistible impulse, like I said, a court of appeals is going to have quite a bit to parse on this.
And they may well say, we're going to toss some of this because, I mean, I have trouble with the irresistible impulse aspect.
It's tough.
I mean, irresistible impulse, you're typically thinking of something that is essentially automatic. It's like a good classic example is, the young kid in the front seat and they, stop fast and the mom just puts her arm out, without even thinking about it. It's something that is essentially automatic. Irresistible impulse, that this manner of death involves a little bit more thought than irresistible impulse would typically cause in my mind.
I mean, it seemed in a weird way she had a plan to help her, help her daughter. And it's an unfortunate situation, but that's where she was pushed to. But I don't know that it was an irresistible impulse so much as just they created such a horrific situation that what else can she do?
And I've also noted that if you can use the hospital's IIED as a substantial factor in Maya's mother's mental state that essentially caused depression leading to self-harm, then by logic, it would seem that you could do it for any mental state. So in the alternative, if my mother hadn't become depressed and despondent, but had become angry and violent and had lashed out at somebody by, assaulting them,
Goes to Maya Kowalski.
are they equally responsible for that because they in some sense induce the state, either IIED?
But Mr. Shapiro,
they both are voluntary actions.
Whatever she wants with it.
So there's some sort of...
So the question is, Mr. Shapiro wanted to object to the instruction, and
Yes, we object to it.
the court's going to agree with the defense, and I will not give that instruction, or let me just say not give it.
Judge, we're going to,
He's like, let me just save you some time.
we've taken a quick glance at what's been sent us, and we've reviewed the situation in which we are, and discussed it in as much detail as time will permit. So we are going to rest at this point under the circumstances.
So you're not going to call the...
Correct.
That person's no
That was
longer
a
in
good
my
choice.
Zoom queue, so
She was
she was told.
very, well,
Okay, it doesn't matter.
she's left.
Now, you looked at those extra video clips. Did you want to?
We can't edit those things in time to do any good with them, Judge, and it would take time to get that done, time that we believe would be prejudicial to us to do at this point. And the time situation and the situation in which we find ourselves in that regard is part of is the major force behind this decision. If it weren't this hour, if it weren't this situation, we might feel differently. But editing the clips in the way we want to do them would take upwards of 30 to 45 minutes, from what I can tell at least. And we're just not in a position to do that with where we are on this evening in this situation.
Well, I'm giving you the opportunity to edit the clips if you wish to edit the clips. So that's going to be your decision whether you want to do that or not.
I understand, Judge. What I'm telling you is we're all watching the same jury. We're all watching the same reactions. And I think you understand what I'm saying.
Oh, they have no.
Now they can read the jury.
So if the defense is going to rest, is that going to end our evidence?
No, Judge, we're resting too. We go on to closing.
Okay, so that ends our evidence.
That ends our evidence.
Okay, we're done.
Mr. Anderson, I anticipate brief closings.
Now, then before we bring the jury back, and this goes to Mr. Altenburn and Mr. Elegant, have you reviewed the jury instructions in the verdict form? And again, I am saying that I understand the defense is objecting to the specific intent instructions and do not want them, and I have overruled that. So,
And you reserved ruling on my directed verdict motions, and so the question is, are these consistent with your rulings? And I see nothing that needs to be changed that would make these inconsistent with your rulings.
you said it much more eloquently than I could, Mr. Altenburn.
That's
Thank
an
you.
honest.
Mr. Elegant,
That's a good way of saying it.
anything relative to the jury instructions?
No, there were a couple negatives in there, but they look good to me, Your Honor. I think you've done what you said you were going to do, and that works.
Now, is the plan that I'm going to read the jury instructions and go over the verdict form and then closing arguments? Is that the plan?
Can I request that?
Either way, Judge. I'm used to either way, so whatever the court's preference.
And I think I've given you all the paper verdict forms. I just had an extra one.
These will
Let
be
me
much
hand,
shorter jury
One
instructions.
of these instructions to the court reporter.
Yeah, think of a number between
Madam
1 and
Court Reporter, you
500.
need a copy of the verdict form as well. This will go to the jury. Okay, let's go get the jury and bring them in.
Did you hear earlier when the judge said, bring this jury?
Yes, I did.
Earlier today, when they had a verdict. He made this very clear. Bring this jury.
That was so, by the way, that was Hunter looking at the jury, looking how the jury was viewing their CFO, and then going, am I going to dare place Ms. Green on, the risk manager, and have her try to explain anything?
Be seated, everyone.
Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that correct? And no one approached you about this case. Is that correct? Correct. And you did not see any media accounts of this case. Is that correct? Okay. Defense, do you have any more witnesses you'd like to call? Any more witnesses from the plaintiffs?
We rest, Your Honor.
Members of the jury, I'm going to have the court deputy hand each of you a copy of the jury instructions for phase 2. And didn't either Mr. Reyes or Mr. Cottrell get a copy of them so they can publish them, or are we just going to not? I know we sent them to the team. I just don't know if they got them to you. I'm sorry? There we go. Someone has them. Thank you. Whoever has it.
Mr. Cottrell, thank you very much, sir. Okay, members of the jury, you can listen to me or read along and listen to me at the same time, whichever you'd like to do. Members of the jury, I am now going to tell you about the rules of law that apply when you determine whether punitive damages should be assessed, and if so, in what amount. When I finish with these instructions, the parties, well, I apologize, I should have read this earlier. You will consider the additional evidence along with the evidence presented, and you should decide any disputed factual issues by either the greater weight of the evidence or by clear and convincing evidence as specified on the verdict form. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Clear and convincing evidence differs from the greater weight of the evidence in that it is more compelling and persuasive. Clear and convincing evidence is evidence that is precise, explicit, lacking in confusion, and of such weight that it produces a firm belief or conviction without hesitation about the matter in issue. You are to decide the amount of punitive damages, if any, to be assessed as punishment against Johns Hopkins All Children's Hospital and as a deterrent to others. This amount would be in addition to the compensatory damages you have previously awarded. In making this determination, you should consider the following. A, the nature, extent, and degree of misconduct and the related circumstances, including the following. 1, whether the wrongful conduct was motivated solely by unreasonable financial gain. 2, whether the unreasonably dangerous nature of the conduct, together with the high likelihood of injury resulting from the conduct, was actually known by the managing agent, director, officer, or other person responsible for making policy decisions on behalf of Johns Hopkins All Children's Hospital. 3, whether at the time of the loss, injury, or damage to Maya Kowalski, the managing agent, director, officer, or other person responsible for making policy decisions on behalf of Johns Hopkins Hospital had a specific intent to harm Maya Kowalski, and whether the conduct of a managing agent, director, officer, or other person responsible for making policy decisions on behalf of Johns Hopkins All Children's Hospital did in fact harm Maya Kowalski. And B, the financial resources of Johns Hopkins All Children's Hospital. However, you may not award an amount that would financially destroy Johns Hopkins All Children's Hospital. You may, in your discretion, decline to assess punitive damages. Now that you have heard and received all the evidence on the issue of punitive damages, you have now heard and received all the evidence on the issue of punitive damages. Your verdict on the issues raised by the punitive damages claim of Maya Kowalski against Johns Hopkins All Children's Hospital must be based on the evidence that has been received during the trial of the first phase of this case and on the evidence that has been received in these proceedings and the law on which I have instructed you. In reaching your verdict, you are not to be swayed from the performance of your duty by prejudice or sympathy for or against any party. Your verdict must be unanimous. That is, your verdict must be agreed to by each of you. You will be given a form of verdict, which I will now read to you. And Mr. Cottrell, do you have those that you can, the verdict form? Okay. We, the jury, return the following verdict in regard to the punitive damages. For claim 1A, false imprisonment between October 7 and October 13, 2016, Maya Kowalski. Question 1, what is the total amount of punitive damages, if any, which you find by the greater weight of the evidence should be assessed against Johns Hopkins All Children's Hospital for the false imprisonment of Maya Kowalski occurring between October 7 and October 13, 2016. Now the form tells you what to do. If you elect to assess punitive damages against Johns Hopkins All Children's Hospital for this claim, please write the amount on the line immediately below and then answer question 2. If you elect not to assess punitive damages against Johns Hopkins All Children's Hospital for this claim, you should enter a 0 as the amount of damages, skip questions 2 and 3, and answer question 4. And there's the line if you elect to assess punitive damages. Question 2. Do you find by clear and convincing evidence that at the time of the false imprisonment of Maya Kowalski between October 7th and October 13th, 2016, did Johns Hopkins All Children's Hospital have a specific intent to harm Maya Kowalski? And did the conduct of Johns Hopkins All Children's Hospital in fact harm Maya Kowalski? You will answer that either yes or no. The form tells you what to do next. If your answer to question 2 is yes, you will skip question 3 and then proceed to question 4. If your answer to question 2 is no, you will answer question 3. Question 3. Do you find by the greater weight of the evidence that at the time of the false imprisonment of Maya Kowalski between October 7 and October 13, 2016, did Johns Hopkins All Children's Hospital have a specific intent to harm Maya Kowalski, and did the conduct of Johns Hopkins All Children's Hospital in fact harm Maya Kowalski? You will answer that either yes or no. The form tells you to go to question 4. This is claim 1B, false imprisonment between October 18th and October 20th, 2016 for Maya Kowalski. Question 4. What is the total amount of punitive damages, if any, which you find by the greater weight of the evidence should be assessed against Johns Hopkins All Children's Hospital for the false imprisonment of Maya Kowalski occurring between October 18th and October 20th, 2016? The form tells you what to do next. If you elect to assess punitive damages against Johns Hopkins All Children's Hospital for this claim, please write the amount on the line immediately below and then answer question 5. If you elect not to assess punitive damages against Johns Hopkins All Children's Hospital for this claim, you should enter a 0 as the amount of damages. You will skip questions 5 and 6, and you will answer question 7. Question 5, do you find by clear and convincing evidence that at the time of the false imprisonment of Maya Kowalski between October 18th and October 20th, 2016, Did Johns Hopkins All Children's Hospital have a specific intent to harm Maya Kowalski? And did the conduct of Johns Hopkins All Children's Hospital, in fact, harm Maya Kowalski? You will answer that either yes or no. The form tells you what to do next. If your answer to question 5 is yes, you will skip question 6 and go to and answer question 7. If your answer to question 5 is no, please answer question 6. 6. Do you find by the greater weight of the evidence that at the time of the false imprisonment of Maya Kowalski between October 18th and October 20th, 2016, did Johns Hopkins All Children's Hospital have a specific intent to harm Maya Kowalski? And did the conduct of Johns Hopkins All Children's Hospital, in fact, harm Maya Kowalski? You will answer that either yes or no. Please answer question 7. Now, question 7 deals with claim 1C and claim 2 combined. That's the false imprisonment and battery on January 6, 2017. So they will be handled together. Question 7. What is the amount of punitive damages, if any, which you find by the greater weight of the evidence should be assessed against Johns Hopkins All Children's Hospital for the false imprisonment and battery of Maya Kowalski occurring on January 6, 2017? The form tells you what to do next. If you elect to assess punitive damages against Johns Hopkins All Children's Hospital for this claim, please write the amount on the line immediately below and answer question 7. If you elect not to assess punitive damages against Johns Hopkins All Children's Hospital for this claim, you should enter a 0 as the amount of damages, skip questions 8 and 9. The verdict form in that case would be complete. The foreperson must sign and date the verdict form on page 7. Question 8. Do you find by clear and convincing evidence that at the time of the false imprisonment and battery of Maya Kowalski occurring on January 6, 2017, did Johns Hopkins All Children's Hospital have a specific intent to harm Maya Kowalski? And did the conduct of Johns Hopkins All Children's Hospital, in fact, harm Maya Kowalski? You will answer that either yes or no, and the form tells you what to do. If your answer to question 8 is yes, you will skip question 9 and your verdict is complete. The foreperson must sign and date the verdict form. If your answer to question 8 is no, please answer question 9. Do you find by the greater weight of the evidence that at the time of the false imprisonment and battery of Maya Kowalski occurring on January 6, 2017, did Johns Hopkins All Children's Hospital have a specific intent to harm Maya Kowalski? And did the conduct of Johns Hopkins All Children's Hospital, in fact, harm Maya Kowalski? You will answer that as yes or no. The verdict form is now complete. The foreperson must date and sign the verdict form. Okay. Now we are going to proceed into closing arguments. Again,
They have 20
each
minutes
side
each,
has
right?
the same amount of time. The plaintiff will be able to reserve a few minutes of that
I bet they
time
go
to
really short.
proceed after the defense has finished its arguments. Who's going to make the argument on behalf of plaintiff? And are you
All right,
seeking
guys, I hate to leave
to
now, but
reserve
I'm gonna
any
jump out.
time
I
for
gotta get
rebuttal?
See you, Rob. Thank you so
I'm gonna
much.
take
Appreciate
4
you.
minutes
You guys,
and then
my
1
pleasure. Have a
minute.
good one, folks.
Okay. There you go.
You're all tired, and you get it. The problem is, they don't. I thought they were gonna get up here and explain how much money they had expended in order to correct the cultural problems and all of the internal issues that led to what happened here. But they didn't come up and tell you that. And I got a little upset, I have to tell you, when they started talking about all the lives they were going to save. And I kept thinking to myself, where were the efforts to save Beata? So let's cut to the chase here. This is a company in immediate jeopardy. You have access to all of the prior evidence. You don't just take what's in here. You can take all the evidence that you had before, which is why I was mentioning the email chains to indicate the direct line up from Jackie Crane, who's number 2 in this place, right up there next to the CEO, across to risk management and straight down to Kathy Beatty, who is the implementer of all that. That's about as specific of an intent as you can because it's directed to Maya. So now, how do you do it? Well, there's a number of questions again about specific intent as to each one of these. You all talk and consider the evidence there. One other thing as to specific intent, consider the aftermath and the entire ketamine girl exchanges. Just think about that when you're discussing.
This is not punitive damage argument, Your Honor.
It's overruled. Now, there's $600,000.
I also object because it doesn't go to false.
$600 million.
Hold on a second.
It doesn't go to false imprisonment or battery, Your Honor.
What?
I will actually sustain that the claims for punitive damages are in battery and false imprisonment as to Maya Kowalski and not as to anything having to do with wrongful death as it relates to Beata Kowalski.
I understand, Judge. I understand. That was my intent with that one.
The jury is going to disregard the argument with respect to Beata Kowalski.
So here's what you've got: $600 million in cash and cash equivalents, and then you've got $1.2 billion in the total assets. So my suggestion is this: there's 3 questions there, 3 different incidents. One's combined, and you can assign percentages. But I suggest again that you come up with a total number, and then go back and for your incidents, then based on what you think in terms of egregiousness, you assign a percentage.
I object to the lump sum calculation being divided by a percentage as improper.
If I could get it out and explain it, Judge.
Sustain the objection.
So what you have is you can then take either 600 million or the 1.2 billion and decide what percentage of that spread among the
Same
amount
objection, Your
decide
Honor.
for each one. That's the only way to do it.
Sustained.
I think you understand.
He's saying either
So
600
the
million
numbers
or
are 600
1.2
million
billion.
or
You choose.
1.2 billion.
Same objection.
Something out of that.
Also, I object because those numbers would bankrupt the hospital, which is what.
Speaking objection is not.
Okay, I agree with no speaking objections. I'm overruling the objection, and you can have your own argument when Mr. Anderson's complete. And it appears he's complete for now.
Okay, thank you, Your Honor.
They
I know
went
it's
short.
late, so we'll try to get to the point with y'all, I promise. Again, these damages are to punish and deter, and if your anger is at Kathy Beatty, she's not there. I think you heard from Mr. Corcoran, and I'll just be brief on this, that whatever the emergency problem was in 2019 was immediately corrected. He was complimentary of the hospital getting it on the right track after that. That's undisputed testimony from Mr. Corcoran that the corrective action plans were made immediately. So there's nothing to punish and deter from what happened in 2016. I just want to talk to you about a couple quick concepts. Some of these findings, in fact, most of them, require a specific intent to harm. And I would just ask you to go back to some of the evidence you heard for 9 weeks. Was there really a specific intent to harm Maya when they were asking the family to stay at the hospital? I know you disagreed with it. I get it. Okay. You wouldn't have checked the box saying there was false imprisonment if you thought that all children's, for whatever conduct it was, wanted them to stay, put pressure on them to stay, whatever it was you found, and I don't have a chance to interview individually. But I would just ask you to go back and put yourself, I would ask you to go back and consider the evidence of healthcare providers that were presented with a situation where they were told that Maya Kowalski was given an amount of ketamine that was 200 times what their protocol was, that they saw her in withdrawal, that Beata Kowalski was asking for intrathecal clonidine pumps that Dr. Santana told you could be lethal, that they were asking for ketamine comas that are illegal in the United States because of them alone. It caused them alarm. There was never an intent to harm Maya Kowalski. There was never an intent in that week period. They were trying to do what they thought they could do to protect Maya. I know you disagree with it, but I'm really hoping in your hearts you don't think they were trying to harm this child in that week. The reason why they wanted her to stay was because they thought they could help her.
He's begging.
Thought they could get her on the right course. I would ask that since your verdict in this is going to be, it's to punish and deter, is that the effect that you want of healthcare providers who've dedicated their lives to medicine to be muzzled, where they are afraid that a child could go to imminent harm or death? Do you want with your verdict what's coming next to be telling these healthcare providers at the hospital, don't say anything? Because...
Objection, Your Honor. Crossover to 39.
I'm sorry?
Crossover to 39.
I sustain that.
Move to strike.
Members of the jury, you're going to disregard the comment about the reporting. The punitive damages are on battery and false imprisonment. That has nothing to do with any sort of dependency court issue.
My point, Your Honor, was not for the call, but for the week where the All Children's was telling the family, we want you to stay, for that week before.
You can make your argument to the jury.
Yes, and for these damages, where you have to find a specific intent to harm, ask yourselves in your heart, do you really believe that these providers who've dedicated their lives to
I think they
medicine
do.
are
I'm just
trying
going
to
to guess,
harm that, or
Counselor. I
do you
think they do
believe
think that.
that they were in fear that something bad was going to happen to her? And I would ask you the same with the EEG room and the other categories, because you do have to find that they were literally, not just one of them, but an entire hospital of people who've dedicated their lives to caring for sick children would somehow turn on this child. I don't think you believe that in your hearts. You do not have to award punitive damages. You know that this form gives you an out to say it's enough. I would remind you that you've awarded $238 million, almost $250 million to the Kowalski family. They are asking you, and $57 million for these categories when I added it up. They're asking you for more. You've heard from Sharon Rogers. It's all going to patient care in your community. It's not a joke, right? And if I'm a little bit cracking up in front of you, because I know every additional dollar that goes out the window, as the judge told you, this isn't insurance. These are real dollars that the hospital is going to have to take from its strategic plan that they have to help children that can't breathe when they're born, that don't have access to cardiac surgery, don't have access to neonatal surgery, don't have access to cure cancer. I would just ask you in your hearts to think, is this really necessary at this point to continue to punish
That'd be great.
Children's Hospital? I would ask you to look at the amounts, and I would ask you to ask yourself whether that message is one that you want to continue to send to pediatric providers that have dedicated their lives to medicine, and with a hospital that has corrected errors, undisputed testimony. Let them go forward with their mission to help this sick. Please. Please.
Mr. Anderson.
One thing I think the American people understand is that this size companies always have an argument why they need more money. And I can't believe they're still going after what Beata Kowalski decided to do. They still just don't get it.
Object. Yeah. Withdraw the objection.
Okay. Are you finished with?
I'll say it again. Help them get it.
I like that.
Do the
Still don't get it.
lawyers
That's
wish
cute. I
to
like it.
examine the evidence before it goes back to the jury room?
It was brief. It was very brief.
No, you're
Okay. So in a moment, the clerk is going to deposit, and you can go ahead and take both the phase 1 evidence plus the new phase 2 evidence back to the jury room. Here is the verdict form. Jury, you're going to be back in charge of timing, and it's going to be totally up to you for the length of time you wish to deliberate. At some point, if you're deliberating late into the night, I might call it and say you're going to come back on Monday. Okay. But you have the option at your own discretion if you want to keep going, or if you want to, at some point just say you all want to go home. So that is going to be up to you within some sort of reasonable hour. Okay. Yes, you can go ahead and take your notes back with you. Yes, you can take the jury instructions with you. The clerk is bringing in the evidence. At this point, may this jury begin to retire or to deliberate?
Yes, Your Honor.
Yes, sir.
Okay, at this time, you can retire and begin your deliberations.
All right.
If they're
So
not
now I'm
going to
gonna
be
start
in
another
tomorrow,
timer.
yeah, if they're not going to be in tomorrow, then they're going to come back tonight. So I feel reasonably confident. It's the weekend. They all want to go home. No one wants to come back in on Monday. So if there's no court tomorrow,
Presence, are there other
get an egg
issues that
timer.
we need to address before we depart and wait for the call of the jury?
Not from the defense room.
And everybody knows we're going to go ahead and reclose the courtroom. So we're going to be in recess at this time, and we will be at the call. Please don't go too far. The clerk has your telephone number, but let's try not to go too far. Okay, we're in recess.
I wouldn't go too far. Yeah, I think the odds are very strong. The odds are extremely high. They'll come back tonight. When the jury gets to the end of that week and it's Friday or the equivalent, because they're not coming back in. No one wants to come back in on that Monday. Everyone wants to go home. They've got
the
their
weekend
food.
is here.
Yeah, the
Look
weekend's
at
here.
the boyfriend in the shorts and t-shirt. That's awesome. Dressed for court, Florida. Gotta love it. Let's see here. Let me see if I can get this.
What a sad closing that was from Johns Hopkins. Just begging.
It was. He was almost. All he did. The only thing he didn't do was get down on his knees and say, "Please don't destroy us." He did object to when Mr. Hunter said, or Mr. Anderson said, your numbers are 600 million or 1.2 billion. You choose between the two. We're fine with either one. Okay, but he's like, no, that would destroy us. That's too much, and the jury is not allowed to destroy them. That's one of the instructions that they can't do that. But hold on, let me move this around a bit. Where's my window?
Your guys are gonna have to do a bake sale or something.
Kurt, did the chat call you out for contemplating everything as you were listening to it? That's how you close your eyes and deeply think about what you were
I was
hearing.
using my phone. Yeah. Chat was mean to me.
I'm sorry. I may or may not have snored on a couple live streams. I'm just saying.
I haven't passed out on a live stream yet, but one of these days I'm pretty sure it's going to happen.
It almost happened to me during the 24-hour stream.
Yeah.
I was getting pretty close. So that objection was pretty spicy. Objection, that would destroy, that would bankrupt us. It's like, slow your roll there. Yeah, that was exciting.
This turned out to be a bad investment from Johns Hopkins.
Now that we're not listening to the court, I'm going to try to route it so I can hear what you guys are saying without it causing problems for me. So give me just 1 second here.
Sounds good.
Output goes here. And you tell me if... Can you still hear me?
I can.
Yep.
But I cannot hear you.
No, that's no good. You got to hear us.
Now's the time where I can say all the things Recovery Addict can't be allowed to listen to, such as you should absolutely hit that subscribe button because he deserves it. Make sure to give him some of your love. And if you considered hitting a super chat or maybe giving a gift membership to somebody, that would be nice. We appreciate all your support to his channel.
Came back to hear Kurt say we appreciate. Yeah, I'll figure this out. I swapped laptops between the two streams, and I completely butchered it. And Rob bailed me out, providing a stream through a secondary window, secondary login. So big thanks to Rob. I thought I could just seamlessly slide from a hardware encoder to a StreamYard and make it all work, and it did not. So I really appreciate Rob for
I'm just
saving the
impressed
day
that
there.
you have at least the theoretical ability to clean up court audio. It's like, can you just clean up court audio for all of us so we can stream from you, so we don't have to deal with the terrible court audio? Can you re-export it and we'll get it from your stream?
Kurt, you bring up a point that my goal in life is, yes, I want to do that. I'm slowly acquiring hardware to be able to be the pool feed from court.
Outstanding.
Oh, nice.
And I would love to be able to do that.
Now, important question.
Yeah.
Would you be focusing solely on like
Mostly
Maya?
I do close-ups. I just like eye shots, just like really close, so if I could see the tear roll down. No. I would not. It's I think the cameraman. I mean, I'm a cameraman, right? I went to school for this. I've shot everything from sports and dramas, documentaries, TV shows. I'm a cameraman at heart, and I love it. And I can see why a cameraman would want to get that shot, because that's the one where people are going to click and they're going to stay on longer. It's got the emotion, it's got the view. There's a million reasons, but for all the parts that is good, that is wrong as a true crime fan, because the judge rules in the courtroom, and the judge has to protect the whole court procedure, and it has to be fair for the defendant as well. And if you're invading that space and you're getting so close that you can read their lips and hear their breath, it's like, that's not fair. And we all end up losing because we get kicked out, like we did in the Lori Vallow trial, or, it's almost.
Also, that wasn't the case that anyone was trying to make when they said we should allow cameras in the courtroom. The case everyone was trying to make was, we'd like to see the trial. That's what we want to see, right? We want to see the witness testify. We want to see the attorneys argue. We want to see the trial. So the cameraman pointing at Maya is sort of it may be revealing what they really wanted the whole time, which is also part of the reason the judges are not so happy.
Yeah, like it's kind of gross. They're just kind of going with misery porn. Like,
that is not my preferred variety.
I think the best way, and what I think, technology isn't here yet, but I think I would like to be able to get to the point where you can choose what you watch. Like, have you ever watched a concert? When DVDs first came out, right? The technology they promised us was like, you can have like multi-camera angles. You can switch angles as you want to watch. And so if you're watching a concert, you're like, I want to watch the drummer. I want to watch the guitar doing the solo. You could choose as the viewer which one you had on screen.
That would be cool.
We're not quite there. We're close, but on the gathering end, on the camera end, we do have the capability to send multiple feeds and send multi streams, and then be able to. We're almost there, where you could say, I'd like to see this window and this window at all times, and as long as we're not zooming in on the defense table and watching so we can read the lips of their the counsel talking to each other, I think courts would be open to that. And I think people would enjoy that better than what we're getting right now. So that's my ultimate goal, as I'm working towards that. So,
I mean, it wouldn't be that hard to just have a few fixed views. I mean, you wouldn't even need that much. You're just like, here is the witness stand. Here is counsel.
One at the bench, one at the
podium.
witness, one at the lectern where the attorney speaks. You got it made, man.
Yep. So.
All right.
Yeah, I'm just not a fan of what they're up to on, what is it, Court TV?
Some producer somewhere.
Hold on just 1 second here. I'm trying to. Oh no! I was trying to bring Jules on, and she just dropped. But I've had a nightmare on my phone. My burner phone, I think, is full. It's occasionally it just sits there and just gets hot, and then it starts saying I have like 500 messages and just scrolls through them. So I think I've overloaded it, and I'm having trouble bringing calls in. But I'm about 329 super chats behind right now.
That's a good problem to have, but also a terrible problem to have.
It's terrible right now. I feel awful. I could click very quickly through all of them, and none of them would get the attention and the appreciation they deserve. I will tell you that you guys have been incredibly generous, and many, many, many really good questions, both for me and for these three amazing lawyers we've had on here. Rob had to bail off, but I think we're going to stay on for a little bit. I have the podcast that starts at 8. Obviously, we want to see what this happens, and it might be a quick. There are 3 places on the jury form they need to write a number if they decide to do a clean sweep again. Is that right? Is there 3 possible punitive amounts?
I also, on a personal, or I guess more of a professional level, I really appreciate the judge separating things out and all the details they've done, because it makes life so much easier for the appellate court to review things. And I really appreciate where they segmented out do you find this by preponderance of the evidence? Do you find this by clear and convincing evidence? And Johns Hopkins over here objecting a storm, and the judge's answer is like, well, I would really hate to ask the question, and the Court of Appeals say, well, it's the wrong question, so I'll just ask both. And then they know the answer to both, and that's great, because if they know the answer to both, then they have both answers, so they don't have to wonder. So I'm making life easier for the appellate court, and Johns Hopkins apparently didn't like that option.
Oh, Johns Hopkins hates that option because they know what the result is going to be. The result is going to be that it's like, well, you think they used the wrong standard, but you still would have lost on the better standard, so you get no remedy.
Right.
Send a voicemail. Press 2.
I'm going to bring Jules on. She's not going to be able to hear you. Just 1 second here. Hey, Jules, I think I figured it out. Are you there?
I'm here.
Oh, wonderful, wonderful. We didn't get to hear from you after the verdict because I had problems with my phone on my end. It's working right now. I'm not going to touch anything. Tell me a little bit. What is it like there now?
Relief. I mean, when the verdict first came in, the first time around, I lost it. Okay, there were 8 deputies in the courtroom. The security was that was like insane. The most amount of deputies that had been in there the entire time. But there were 8 deputies in there, and there are 2 people, other than the legal team, because my hat's off to Mr. Anderson and Mr. Whitney and their entire team. Samantha Lawrence, Dan Rez, Gabby and Connie, all of them. My hats are off to all of them. But Dr. Corcoran, I think, laid that foundation for that IJ stuff that came in. But before that, Dr. Scott Richards, the psychiatrist that testified over Zoom while he was in, I can't remember if it was Pennsylvania or Ohio, his dad passed away, and that's why he was up there and couldn't be in person. But he's the one that spoke for Beata and for her doing what she did to herself. His testimony, I believe, this is my opinion, it was his testimony that persuaded this jury to go with the counts that they did where Beata was concerned. And again, I think Dr. aced it at the end there when it came to the Joint Commission and all of that stuff.
Jules, let me ask you really quick. We've got a lot of questions from chat that I'm trying to get filtered through. Regarding this last little bit with the closing statement for Mr. Shapiro, how did the jury react as he got up there and sort of came out swinging a little bit and tell him, look, you're wrong, you're angry at me, you overcompensated the family here. How did they accept that?
I can tell you for sure, number one, which by the way, he is the foreperson.
Okay.
He is the foreperson. He wasn't, I don't think he was buying it. Two of the women jurors, I don't think so. And the other gentleman who I had referred to as, Mr. Clean. Yeah, I would say there may have been one of the women that listened quite intently to him, but he did come out swinging. And I'm sorry, but please don't use sick children to gain the sympathy of the jury, because that's all he kept doing.
Yeah.
Was using,
It was a think of the children
That,
defense.
but-
That was what he was providing. Just think of the children. Jules, I'm gonna cut you short a little bit. I know you've got a TikTok. We've been sharing that throughout this trial. I'd love to see your take on this. This is the big moment of the trial. I'd like to hear that through your TikTok talk and watch you there. I want to say thank you so much.
Well, I'm not doing anything tonight.
You're
Thank
spent.
you.
You're
No,
spent.
thank you. I'm not doing anything tonight on it, but what I will say is what I said to Maya today. The whole world heard you. They believe you, and your mom's been vindicated. That's all you need to go with,
Yeah, even
Anyway,
if there's no
have a great
punitive at this
night.
point, the family won. They got what they were seeking. Thank you, Jules. I appreciate your help. It's good to talk to you. We'll be in touch.
All right.
All right. Bye.
Same here. Bye. Bye.
All right. Before I lose this, let me just say, Ian has done a fantastic fundraiser, and it was a 24-hour stream. But the fundraiser itself is not over. I'm trying to find a way we can link this or to chat.
I can drop it in the chat.
What's the best way we can do this? Because chat's going so fast. You put it in chat and it just scrolls off the page. Let's see. Let's see if I can. I can't see how to pin it using. Oh, there it is. Let's try this. Pin message. Is the pinned message able to be clicked on? Is the link clickable?
I think so.
Okay. So here's what I'd say. I would beg, please do not send any more super chats. Please do not send any more super chats. If you would like to say something, please try to tag me. I honestly, most of them I'm not going to be able to get to. I wish I could, but it would be wonderful if you were able to click this link for that's up in the tagged message. Ian has a fundraiser that is for Extra Life. It is amazing. It's done a huge job. He's currently sitting in third position as far as the highest amount fundraised. And it would only take just a little bit to get him up to second. So we'd love to see that continue and see some more wonderful donations that go to an amazing cause. So if you're inclined that way, I'd say please don't send super chats to me today. You guys have been most generous, more than I deserve, 100%. On top of yesterday as well. I'm very, very appreciative. But if we could route things towards Ian's fundraiser, that goes to a hospital that could put that to work, and it does go to the children. so thank you, Ian. Anything you want to say about that?
Yeah, it's the Stollery's doing great work. Some of the stuff that they've got going on. Last year, we raised about 50,000, and so they took me through a little tour. And they do, organ transplants. They do all sorts of things. But one of the projects they've got going is they want to build like a little outdoor play space, because a lot of the kids who have like immune issues and so forth may have never been outside the hospital. So they have like an indoor play space, but they want to expand that to have an outdoor space. And, that would be sort of protected, so they're not at risk from, anything else out there. And I really hope that they can get that built, because that'd be fantastic. I myself spent a lot of time as a kid in hospitals. It's a pretty miserable experience. So I appreciate that they're putting a lot of work into making it a nicer place. And, we can see what happens when hospitals go bad. From what I can tell, the Stollery seems to be trying to do things right. And so, and Maya herself was a sick kid at one point who deserved better, but hopefully there can be better for these kids, I guess. So, yeah.
That's wonderful. I appreciate you doing that. That is amazing. Just another sign of some of the incredible kind hearts and souls that make up the LawTube community. If you followed when they see a need and see somebody that needs help, they've stepped up in a big way. And you, all of you, have been a part of that, and that's been awesome to see and be able to participate in a little way. 20 minutes. I'm a little surprised it's taken this long for the jury.
I didn't think it'd be quite that fast, but if it's not within the hour, I'd be a little surprised.
I mean, they're going to have to take the time to write all those zeros out.
And make sure they get the commas right. I mean, the comma placement. This is the time where you really need to get your numbers right. So, we'll see where this happens. I'm sort of torn. I've listened to this, and the jury seemed to. Part of me thinks the jury didn't understand what punitive damages were. The fact they didn't know where they went, like who gets the punitive damages. At least one of the members of the jury possibly didn't even realize that there was going to be a second round, maybe. And so
I suspect several members of the jury were like, "What do you mean we're not done yet?" So that's got to be heavy.
Yeah,
it's interesting because you spend all this time trying to explain it, and it's like compensatory damages by their nature are meant to compensate. That's all they're meant to do. So compensatory by their nature do not depend on the person who's doing it, and don't depend on how rich they or poor they are, right? The compensatory are just to compensate. So if I burn down your $1 million house, whether I'm poor or extremely wealthy, I owe you $1 million house. That's compensatory. It has nothing to do with the evilness of the act or even my ability to pay. So, but you spend all this verbiage trying to explain that, and well, you wonder if the jury understands it all. Apparently not.
And a lot of the time they're learning it as they go. Like nobody sits there and explains what punitive damages are until they're being asked to award some. And then now it's like, now we'll tell you what punitive damages are. And some of them probably also were sitting there going, wait, that's not all the money we're giving them? We're giving them more money after this? They may have actually thought that they may have rolled in the expected punitives.
Yeah. Which means they could always put 0 on the form if that's what they did. Right? It's like, oh, we already did that, so we'll just put in 0.
Yeah, the jury, by their verdict, they've said this makes the family whole, right? That everything they've got makes them whole for their loss.
That's the idea.
Yeah.
Or at least on paper, right? Really, no amount of money replaces a life. It's hard to equate suffering to dollars and cents, but the idea is that they're made whole at this point. So everything above this, yes, it would go to them, or at least split up between the taxes and the lawyers and everything else. But the whole purpose is just to punish the hospital. So if the jury, they can side 100% with the plaintiff on this one and say, run the gamut, yes for the plaintiff, all the damages, and then at the same time come back and say, but we think the hospital's made the changes necessary, and do zeros here, and it would be okay. It would be feasible.
Now, the other aspect is they did say that there's deterrence as part of this. So it's not just the hospital, it's also we've got to deter others. So, I mean, they may or may not figure that. They might say, oh, the hospital did fine or has fixed, they've made the changes, but we still want to put some punitives on this so that no other hospital thinks this is a good idea. That's the sort of tell your friends.
A $250 million feels like a lot of deterrence to me, but maybe it's just me. Even if I have $600 million in the bank, that's half my bankroll. I'm going to notice.
Yeah.
So, yeah.
I mean, I can say a single million would be life-changing money for most people. The vast majority of people. So, yeah.
But we'll be spending forever on appeal on this and post-trial motions. This isn't going anywhere for a long time.
What's the first time the family would see something? If assuming everything gets upheld on appeal, or even if the numbers change, what's the soonest the family would get any of this?
A hospital will probably pay it out fairly quickly. They're not the sort of organization. They're not the sort of people who can run away from a debt owed, because if you sue your neighbor, it might be really hard to get money out of your neighbor. But when you sue something like an institution, they usually pay their debts pretty quickly, and if they don't, enforcement mechanisms tend to work really well against big companies.
Yeah.
Now
their financials, so you know where their bank accounts are, which means you can get writs of attachment. You can literally seize their bank accounts from the bank.
Yeah. And usually they don't want you doing that. That's the thing, is these big companies would actually prefer to pay they'd prefer to write you a check because then they get to pick where it comes from, as opposed to you starting to seize accounts. Or in some cases, people have gotten like authority to go and seize property. And the last thing a hospital wants is for Maya's legal team to come in and be like, so what's an MRI machine worth? And also please start loading it to the, into the truck. Like they're not going to want that at all.
So the instruction in this, on the instructions for the jury, it says you can't award enough that it would destroy the hospital, but could they award enough that it would, severely cripple the hospital? Or, I mean, what point does destroy come into effect? If they have to fire 20% of their staff, downsize, sell off a building, is that considered destroying?
I don't know what that means.
I mean,
Court of Appeals to figure out someday.
Yeah, if it gets into that question, the Court of Appeal may ask, like, is this destroying? But something like the issue of, like that lease back would not be considered destroying, I don't think. So, yeah.
Yeah, the hospital was not very fond, at least the lawyers were not very fond of that option of selling off the building and leasing it back and paying rent for something they currently have owned for a generation or so. But that is it's something that exists. It's something that happens in the corporate world, and that would free up all this capital that's sitting there on that land, which is worth a ton. That's been depreciated over time. And yeah, the numbers on the tax form are much lower than they're actually worth as they've depreciated different things.
Oh, I mean, land always goes up, and I mean, houses that when I was a kid would sell for 100,000 are now selling for like 1.5 million. So, I can't imagine what a block that size. That's got to be like downtown in a city as well. So, yeah.
Well, they've got the oceanfront view as well. I mean, you've got it's beachfront property. Maya had beachfront view from her room.
Giving the devil their due, Johns Hopkins does have a point, though, that I'm sure it must be true. They can't be a purely evil hospital. It must be true that they do a lot of good work for a lot of children who are very, very needy. And this will hurt them, and it will hurt their ability to help marginal people. So they do have a point.
And that's the thing, is these things end up, lots of people have good intentions and they go off the rails, right? And I'm sure that's what happened here, right? So,
yeah, I'm gonna stick with my prediction that if they do award punitive damages, it will probably be that amount of cash on hand as a max. I don't see a 1.2 on here. I don't see a 600 million. I don't see multiples of the damages on here. I think
600 million would be within the 3x cap, so they got that going for them.
I think if they had asked the question of what is the executive compensation, they might well have seen something like, we're going to award like the CEO's salary plus the CFO's salary, something like that.
Yeah.
So.
Yeah. Interesting. I appreciate both of you. I don't know if you want to stick around for as long as it takes to get a verdict.
Stick around for a while. I think it's gonna come pretty fast. Let's stick around for a while.
Yeah, I kind of suspect that they aren't going to want to be stuck with this all weekend. I think that they're probably doing some horse trading on the amount in the back, and that's it.
They don't have to prove their math on this one. They really can pull a number out of the hat, and as long as they agree, it's fair, right? There's within reason, they can pick a number if they agree. They don't have to say, well, we chose this number because the actual damages. Here's the bill. Here's the lien. Here's the hospital. They don't have to add up the math and come to a penny. So it's probably going to be a round figure or something symbolic, which we've seen juries do before, where they have a very symbolic figure that they come back with.
Why don't you read some super chats while we're waiting? Get that done.
Here we go. Buckle up. I'm going to start from now and work back. Well, yeah, I'm going to start from now and work backwards. Ready? RA and Lawn Lumber and Runkle are Dreamstream goals. Found all y'all through Emily D. Baker. She's my OG. by the 6 degrees of separation rule. Happy to be part of the community. Thank you, Outside the Box. Appreciate that. Welcome. Grant Horn, it's telling us where Ian stands is only 3,500 away from number 2 on the Extra Life fundraising, which is awesome. Hope we can close that gap. Davenport family, can you give a quick recap of the case? I can't. It's a 9-week case.
Johns Hopkins did bad things. They owe money.
It was a doozy. You've got a child with a very rare and hard to understand illness, getting treatment that was outside the norm for what the hospital thought was right. Brought to the hospital with some symptoms that were troublesome and weren't being managed by her traditional doctors in a way that they felt was successful. And the hospital, instead of researching that and trying to follow that same path of treatment, they looked at it and said this might be a medical child abuse situation, and things sort of escalated from there. And there was efforts that it involved DCF, it involved a shelter order from the courts, where the courts authorized the hospital to take Maya and have her in custody, where the family could no longer just take her at will. It became pretty bad. It lasted for about 3 months that she was in custody. And through this and other events, including the DCF court and one where the Beata, Maya's mom, wasn't even allowed to hug her at court, Beata realized or came to the conclusion that as long as she was in the picture, she was being blamed for what was happening, even though she felt and said, it's all the disease. If you just do the research, that's what it is. We're trying to help her. She came to the conclusion that if she were to take her own life, it would at least get her daughter back home and be able to get some treatment. And that's the decision she made. And as soon as she made that decision and followed through with it, tragically, the hospital, the courts relinquished Maya, and that began this battle that has taken 5 years to get to this point. It's taken several attempts to get to court. It's surprising that it even got here. And it's really a David and Goliath story with a little tiny person suing a huge, powerful hospital, and now at this point winning, at least on the initial damages. And so that's a quick recap. I think I've skipped all the pertinent information, but that'll get you going. Let's see. That's the update for you, Betty. Thank you very much. Grant. Create Trust that owns buildings, rent paid to the farm.
Bam.
I mean, it's possible. I don't think it's likely, but you need the fam's agreement on that.
Laurie says, thank you. It's much more intending to watch you than on another channel by yourself. I'm glad you're here. Thank you very much, Laurie. Appreciate that. I've now clicked on about 1% of the super chats. Chantel says, I'm donating to Ian to get him the second. Who's going to follow? Thank you very much, Chantel. Appreciate that as well. Emma, thank you to all the lawyers jumping on. Found you via Rob and bug spray. I've got this little raid mug right here. So I'll never live that down. Rob did a great job on that video. Thank you very much, Emma. Appreciate that. Let's see. Gifted memberships galore. Thank you very much for all those who are generous gifting memberships, welcoming new people in with a free seat at the table. Miss Lisa, your abilities as a producer of audiovisual things would be perfect for that. Thank you. Today's stream excluded. I really butchered that one, especially the start. Diane, thank you. Appreciate your super chat as well. John, so how do we get Mr. Runkle to second place on Extra Life? Well, it just takes a couple people doing a little bit, and we can get him there. He's about 3,500 away. Last I checked. Are you keeping an eye on it? Are we able to?
I'm giving it a refresh here.
Okay, we've got a link at the top of chat right here. I think we do. Where's the message? If we can post it again in chat. I thought I linked it. Let's see.
I thought it was a pinned chat.
I think we accidentally deleted it. If you can post it again.
Yeah, 1 second.
I'll link it here. There it is. Hang on. Wait. I've got Lady Draconis has it here. Okay. Thank you, Lady Cronus, and thanks for stepping in as a volunteer mod today. I appreciate that. Rob made some great recommendations, and we got some volunteers. You can click on the link there on the pinned chat, and you can make a donation. That donation goes to this Extra Life fundraiser, which Ian has been a huge part of for many years in a row. Last year, he raised over $50,000. This year, he's over $100,000. He's almost in second place. We'd love to see him get there. I think the fundraiser is open until the end of the year, right?
Yeah, I think they close it off at the end of the year, and then they start a new year. So then I'll be fundraising on that new year.
Yeah. Are you still getting an echo on your end? I'm trying to maneuver the mics and turn the volume down so you don't hear yourself. But I can barely hear you guys. This is like the minimum. So if I stare at you and squint, that's because I can't hear. If they admit a fault and apologized, I would award 0. Jen, they didn't throughout this. And I mean, how do you say sorry, it was our fault, and then also defend yourself in court? So you can't really expect them to do that before. But some sign of contrition.
What you say is not, we did it or anything like that. You say, we've heard you. We hear that you are, that you consider this to be unacceptable. Something where you're not directly stating we agree we did it, but where you actually acknowledge the jury's verdict, because they basically came out and were like, jury, you're wrong, and you're angry, and you're jerks. And I was like, this is entirely the wrong approach. I think that's little speech about how, you're angry and, we think you've overcome, like all of those things that they were saying. It's like, that's probably going to get them to add some numbers.
Yeah, that didn't win them over. And at that point, really, the only thing that's standing between you and your ride home at the end of the day is the jury telling you how much you're going to be paying. And yelling at the jury, or getting forceful with them, saying, "Hey, you got angry. We get it. You're angry. I can't figure out why you're angry, but you came to the wrong conclusion, and now be nice to us." I think it was the wrong start to that. He did have some good stuff in there. I really did like his Mr. Shapiro's closing. There, honestly, the argument about the children, as cliche as it is, it did ring true with me. It's like, this is a hospital that helps many, many people. There are many families that look at Johns Hopkins Hospital and would say, thank you for what you did for our family. Thank you for what you did for our child. Thank you for making the last days so wonderful. That you're gonna find stories all over the place like that. And yes, at the bottom line, if the hospital has to pay out, that's $1 they can't put somewhere else. I'm not saying that that $1 would have gone to a child who was literally sick and struggling to breathe, as Mr. Shapiro sort of laid it out. It might have gone to, upgrading their computer system in an office, or buying a new computer here, or changing the lights out. It could go a million different places. But his argument did sort of ring true with me. Hey, Mrs. R.A. Ooh. I was just provided a steaming hot cup of Stevens hot cocoa, which just happens to be my favorite.
I'm envious.
I can pour some on the microphone. You can listen. Is that sort of like ASMR? You can lick your headphones and see if the flavor comes through. Not sure if that's a thing.
I think a flavor would come through, but
not that one. Oh. They can hear my voice going hoarse. I've talked a little bit too much today.
I'll cocoa.
I mean, you have the capacity to get cocoa.
Let's see. Thank you. A lot of people are saying a big thanks to Ian, Kurt, and Rob for providing this. I like to say, I'm not LawTube. I'm LawTube adjacent. I'm not a lawyer. I'm not here giving legal advice. I love true crime. I love the law. I love to study it. But you really can't replace these guys with the great analysis that they offer on all the different cases and issues of the day on their channels, and all cover it in completely different ways from different angles,
and thing
differently
is
than I would. Yeah,
you can say you're not LawTube, but at the same time, you ask the right questions and you look at the right issues. I think that there's a lot of like first year lawyers who would not be as insightful as in terms of what matters and where the case is kind of pivoting as you are. So I wouldn't sell yourself short here. It's
it's a skill that I picked up when I got my degree in communications. And they say when you get that degree, they say all you need to know is everything an inch deep and a mile wide. You don't have to go in depth in anything, just enough to fluff
like
your
the
way
bars
through, and then you're good. So I do know a little bit, but it's been from watching you guys. It's been from watching trials and learning and saying, hey, what is that? And Googling and searching and studying the law. And man, it blew me away. I thought I was learning really well. I'm like, okay, I've got this down. We're following a Florida case. I'm like, this is what it means. It makes sense. Then I go to another state and they have completely different rules because every state has precedents that are unique to that state and unique rules. It's like, man, you need to be a lawyer for every single state to follow this. So every day, every time we jump to a new trial, it's like starting over.
I still
again
get surprised. I get surprised every once in a while because something happens, and I'm like, that can't be a thing, and it still happens. Like when Chauvin, for example, with the George Floyd, they charged him with felony murder using the underlying assault as the felony. I'm like, you can't do that. That's not a thing. And I think I had to read 5 different Supreme Court cases from their state before I believed it was a thing, because it went against my expectations. And so that kind of thing happens. Or, for example, when we were doing a thing in South Carolina with the disabled child who was left in the car while it was hot and basically suffocated through the heat. And they were charging, they said, okay, with drug intoxication. And so I was saying, oh, well, that's a defense for specific intent crimes. But in South Carolina, it's not. And I was like, okay, so that was a surprise. So every once in a while, I get surprised on the law.
Yeah, when it comes to the law, the United States really is like 50 little countries, and you move from one state to another, and the laws are very, very different, and the way that the law operates, even though it's we've got the courts and the judges and the juries, and the big parts are still the same. They're completely different. I mean, Alex Murdaugh trial, can you imagine? The jurors were not allowed to take notes. They're prohibited from taking notes. In other places, the jurors are encouraged, like they were today. They kept 48 notepads were offered, and they could take notes and ask questions. And little things like that make a big difference in how things play out in court. So
it's one thing that I think actually Canada does fairly well, which is that our criminal code is federal. So across Canada, the criminal law is the same. Which is good, because I think it might be a bit of an annoyance if you're like, all right, what is the criminal law here? What can I do and not do? So,
yeah, like Alec Baldwin, for example, good case in point. Like the legislature changes the law sort of by accident, it seems, for a 3-week period that just so happens to be when Alec Baldwin did that shooting. It's why they can't have the gun enhancement. They basically made a mistake in the legislature. And it was only the law for 3 weeks before they fixed it, but it was the opposite of 3 weeks. So that's how it goes. It's weird sometimes, man.
And I mean, at the end of the day, you're entitled to that protection. You might have decided to be careless with a firearm specifically because of that sentence reduction.
Yeah. Well, he got unbelievably lucky. Lucky, but yeah, that's the way it goes.
So let me ask you this, sort of off topic a little bit, but as from all the trials, so you followed everything from I know, Ian, I think you followed the stuff from the Rust trial and everything. Where's the trial? What state? I guess Florida is the right answer here. But what state has the juries that are most unpredictable? Is there one state that seems to be more so than others, where you just never know? And because Florida, I think of Casey Anthony. We've got Alex Murdaugh in South Carolina. That was fairly predictable. But what state has the unpredictable juror reputation?
I'm not sure that there's a particular state that has that. Jurors are kind of a wrinkle everywhere, kind of. I mean, it's you never really know what a jury's going to do, and they can really surprise you.
I've heard it said before that there's basically a 5% chance the jury is going to rule for you just because, which sounds about right. There's about a 1 in 20 chance you're going to win no matter what happens.
The reverse is true.
Yeah,
you could
this
get
is-
convicted just
And
because the
it's-
jury.
Attorneys get surprised. I've been surprised. There have been cases which I thought were dead sure that it didn't go my way, and cases which I thought were incredibly marginal, which no one had a problem with. It's like, so I get surprised.
There was a
I'll make
trial
it up.
here. There's a trial here where a lawyer was charged with some pretty serious crimes. They got several years in prison for it, and the prosecutor on the way out, I just sort of talked to them a little bit, just a few sentences, and they said, I never thought I'd get that conviction, and I was like, oh wow, right, like so. Even like, and that was a judge alone trial. It was no jury. So even judges can surprise you. So just is what it is.
If you guys will let me, I've got my podcast partner calling right now. I'm going to see if I can bring him on live. Can you hold on for just 1 second? Hey, Thomas, are you there?
Hey, Scott, can you hear me?
I can hear you. You're live with everybody.
Oh, what an honor. That's fantastic. I was just putting a quick memo in chat, but I know there's so many. If by chance, as it always seems to happen, you're still in verdict watch come podcast time, you can just, if you want, keep the stream going, and I can either join with you guys there, or you can just keep the flow of what you've got going.
Sounds good. I like that because that gets me out of singing the song I wrote. I'm playing on the guitar on the stream, which I'm not excited about doing. You guys sort of trapped me into that. So if I can get a pass on that, that would be great. Sounds good, Thomas. I think hopefully we'll get wrapped up. Hopefully the jury is just dotting the I's and putting the commas in the right place, and then we're ready to go. So
Absolutely. Hope so as well. But if they don't, I'll just I'll hop in the studio come that time.
Sounds
and
good.
hang out with you guys.
Thanks, Thomas.
All right, thanks, Scott.
Bye.
Bye.
And I mean, they're either going to come back with a verdict soon, or the judge is going to say, you guys are done for the night. And, off
No
you
one
go.
wants to come back in on Monday.
No, yeah. He's got that new trial period that starts on Monday, right? He's got another case that starts Monday morning. And
Not if
everything is
this
going to
runs
get
long.
pushed. Oh man, it would be. It was funny with him giving the instruction to the jury this morning. You could see him. He can't really tell him to hurry it up. He can't tell him, you've got to get it done today. He can't push that. But he's like, so what's the plan? He wants to carefully just guide them a little bit and say, go ahead, go do it. If you do deliberate longer than today, it will be coming back on Monday. So hopefully that was enough of a encouragement that they won't. Maybe they'll eat a little bite of dinner and then be back in the courtroom.
I don't know. They might let them deliberate as they eat too. They
Make
might
it
just
some
be
finger
outright.
food.
They're all in the
something
same
they
room,
can-
why not?
They can eat and run.
I mean, if you got a big plate of food, you're just sitting there eating and being like, I think they should get all the money. And somebody says, I think only 75% of the money. And, I mean, there's going to
Yeah, what
be
was-
some debates as to just how much money.
With the objection from Mr. Shapiro from Mr. Anderson about Mr. Anderson on the end, what was the problem with him saying percentages? Why can they not say choose an amount and then divide it between these?
It's not really the
these
right
different-
way to think about it because it's not real. It's not really the right way to think about the percent of like what they have available. It's not quite right. It's based off the harm, not based off of their cash flow. So it's just a strange way of thinking about it.
Yeah, I think I know the math on the direct damages seems very clear to me. That's something you can add up. That's a calculator job, right? If you feel this is
Yeah.
right, that's a calculator job.
Although
Punitive.
there's also a little bit of like, how much is this worth? Because a lot of value ends up being sort of hard to figure out, right?
Yeah.
In the Depp trial, how much is Depp's reputation worth? You can get all sorts of expert evidence on it, but at the end of the day, you're picking a number out of your feelings. So,
Yeah, it does feel a little haphazard sometimes, but we don't really have a great alternative.
well, it's like, what is the value of a life?
So I guess the jury has implicitly decided this is 20 times worse than Johnny Depp.
Well, it's just,
Inflation.
different people suffer different damages. So
Yeah, I know.
Rob says, by the way, shout out to Lady Drake, one of my mods, who first pointed me to your channel for live coverage about halfway through this trial. Thank you, Lady Drake, and thank you very much, Rob, as well. Rob's been absolutely amazing. Just a kind soul. I think you guys will both agree. He's just a good person, and I can't say thank you enough. Gwyn Bly, that sounds Welsh. Gwyn Bly says, repeat super. Sorry, I'm sorry, Gwyn. Please, sorry if I already answered. Will the hospital's insurance pay for any of the payouts? Now, the issue of insurance was not allowed to be presented to the jury when it came to punitive damages, but they should have insurance that pays for it.
They won't pay for punitives.
They won't pay for punitives?
Yeah.
They pay for direct, but not punitive.
Some of the direct damage, yeah.
All right, thank you for that. And then the monthly, what is it called when you pay your insurance? The premium is probably going to go up just a little bit for the hospital in the near future. So.
I mean, it depends. I mean, it's going to go up, but it really depends on. I'm wondering what their caps are, because I mean, if their caps are per year, they might be able to just eat this whole thing and then pay out. If their caps are per incident, then Johns Hopkins is going to, they're going to take a bath on this.
Another insurance company lawsuit. How fun.
I see we're gaining a little bit, but Stephen Gorg is a little bit ahead of you, Ian. You're up to 112. We're about 1,600 behind him.
And I mean, I'm sure he does good. I don't know who he is. It's I'm gonna try to figure that out and try to reach out to him, just because I think it'd be fun to talk to him. But yeah, just be like, hey, let's try to reach out and say, hey, let's let's maybe invite him on for a stream and just be like, so we're neck and neck. Donate to one of us.
So Magic the Gathering, what's the story behind their group? Who is that?
That is like Hasbro. So
it's like corporate America right there.
When you click their donations on the Magic the Gathering, they've raised a total of $289,586, of which $282,079 is from Hasbro Incorporated. So Hasbro donated $289,000 to Hasbro's thing, and then Ultra Pro International, who makes card various related sort of accoutrements. They have they donated $7,000. So between the two of those, it's basically that is the sort of donations. Beyond that, I think they've got less than 500 in individual donations. So
it's not really a fair comparison to put you up against.
They're cheaters.
A multi-million-dollar corporation that can write a tax write-off for $250,000 and make a great donation. It's a great donation. I'm not putting that against them. This is awesome that they're donating. I love it. But
and
it's
I like
not really you against them.
Yeah, it's not really a competition, because I am not Wizards of the Coast / Hasbro, but I mean, it's really for them, I think, just their advertising budget. But good for them for donating, but I'm not in competition. And I can say, if I won the lottery and was able to put $500,000 or towards and just donated $500,000, I'm pretty sure Hasbro would immediately be like, nah, bro, we're stepping this up. So that'd be a good thing, but yeah. Maggie says I need a corporate sponsor. Maybe next year I will try to get some corporate sponsors together just to see if we can push the numbers up.
You're sponsored by Uncivil Law LLC.
There we go.
There you go. You'll have the jump on that one for sure. That's really neat. That's awesome.
Oh, yes, and somebody was saying that the journal cover. So this has to go in the mail soon, but was one of the things we auctioned.
You made that by hand, which is very impressive.
Yep. So.
I mean, that's so much intricate detail. That is a lot of work.
I am. I'm gonna have to get back in the leather shop sometime soon, and I guess get started on my next project. So, but
Well,
yeah.
Moo Cow is on its way. It went into the post office today, so
Nice.
it is it's on its faithful journey to its new owner.
I also have to get this sent.
The rock.
Yes, the rock.
This rock.
I have a hoodie coming my way. I have to sign it before it gets delivered, so I have to ship it to me first and then out. But it's going to be headed out. So, and then I've got a recording I have to ship off as well, a voicemail recording. So I'll do a couple of recordings, see what they like, and go from there. But that's awesome. It was wonderful to take part in that. Kurt, do you want to be big for a little while?
Sure.
I've had a turn for a while. We've given Ian a shot in the spotlight. So,
Yeah, okay, cool. I'll read some super chats if you put them on screen. I'll help you out.
Can you read them for me? Can you click them?
Sure.
Or
No, I can't click them. You'll have to click through it. I'll read it for you. Save your voice a little. Lex
I'm
Tech
struggling.
became a YouTube member. Thank you very much.
Okay, hang on. My computer, every time there's like a new chat, it puts me down on the bottom of the super chats, and I'm starting to scroll up and fight. And so after about 20, I can't get up to the new ones because it just I can't get there. I don't know how.
Just start clicking through, baby.
Let's see. So we're going way up to the top. Let's see if we can do it.
Now
Let's go.
I'll say let's go. Thank you very much for your contribution. Not that Mickey gave 350 ZAR, said bring this jury. Thank you. Combating Chaos with Cherry, €5.99. I'm getting seasick. Slow chat, please. Well, you guys are too generous. M. Bali Mitchada gave 14 ZAR. Say the speed of this chat, RA, you are loved. Matt Bond gave $2 Australian, I'm guessing. It's on, like Pokemon. Nick Duff gave $9.99. Say, thank you for all your hard work covering this case. Drama Llama gave 35 ZAR. Say, Rob called the time pretty close. He said verdict at 2. Yeah, I thought it was going to go the end of the week. I didn't realize that was today, but yeah, we're there. Krista Woodworth said $5. Thousands of people in this live stream and only 4 likes. I am so just asking. Hit the like or else. Amy L. 2022 gave $10. Said Runkle's in chat. He needs a wrench. Runkle has an X. Aisha gave $1.99 to give a super sticker. Thank you for the super sticker. Sessionar Fan Club gave $2. Say, you getting a haircut helped make the verdict come. Kim R gave $1.99. Said, justice for Kowalski's. Maya, thank you very much. ASMR with Molly gives $4.99 pounds to say it's Lost Souls Paranormal on my new channel. Congrats on 50K. Very well deserved. It is well deserved. He does a great job. Snazzy Trinkets Jewelry gave $2. Say, can only imagine how Maya's feeling right now. Well, Maya knows she's in for a long slog, but she's already been through a long slog, so nothing new there. Jess Med gave $20. Said, good vibes for the Kowalski family. May justice be served for Beata, who fought so hard for her daughter, of course.
The other thing is that the appeal slog will be a lot easier for Maya because a ton of that'll just be like her lawyers are just like, yeah, we finished the factum. Like, we finished our memo. That's the next step. She's not going to have to be there in court every day the same way.
Fair enough. Tonelli Suzanne has been a member for 1 month. Thank you for hitting that join button. Please say hello to my mom, Sandra. We're watching together. Hello, Sandra. Teresa gives $3. Give a super sticker. Thank you. Ella Cole gives £9.99 pounds. Say, everyone, hold on to your knickers. That is a British thing. Thank you very much.
I literally the scroll wheel, the scroll bar has not moved on the list of super chats. On all these, it's still at the very top. So you're going to have to read like 4 times as fast, or we're going to be here all weekend. I'm not sure which is the case.
They're coming in faster than they're going out.
Becca Lynn gives $10. Rod, say, thank you for going to lunch, recovery addict. I gavel. Justice for Maya, Kyle, Jack, and Beata. Thank you very much. Rudy Patootie gives $2. Say, I need to walk, but mom won't go. Knitting Addict gives a gift membership. Thank you for hitting that join button. Sarah Adams gives $2, saying a piece of chocolate cake too. Jennifer Johnson, $5. Can you move your picture up to the top left corner? I'm already there. Haley's Comic gives $2, says, I am nervous. Here for the Truth gives $4.99. Should have taken an early lunch, Scott. Murphy's Law, LOL. Honey, 2800 for $2 says, flails like Kermit the Frog. Yay!
Thanks for acting that one out. I was going to ask you. So that's good.
Woman of Steel became a YouTube member. Thank you for hitting the join button. Nikki Zizbas gives $10. Say, let's do this. Justice for everyone who has to go through this. Hoping change starts today. Ricky Watson gives 5 gift memberships. Thank you very much. Here for the Truth gives $1.99. So could have prompted an earlier verdict. Just JS lol. Smudge the Cat gives $5. Said, there's no place I'd rather be right now than with R.A., Rob, Runkle, and all of you in chat. What a journey this has been. Carla Vera gives $1.09. Says, get Peter Tragos also. He's pretty cool. Joska gave us a sticker for $6
on his own right
Thank
now.
you very much.
I heard Peter had a bug in his studio. Is that true today? I heard in chat that, because I had the bug that was on the wall, and Rob immortalized that. I heard Peter had a bug as well. I need some confirmation on that one.
Isabella Jones give $2. Say, thank you, RA mods and lovely chat. Bella, member for 10 months. Hello, friends. Back from the cabin again. Saw a verdict notification, so I popped in. I haven't followed this case. Hope you're all doing well. Sandy became a YouTube member. Thank you for hitting the join button, Sandy. Katrina Harrington became a member by gifting a membership. Amy Matta has been a member for 7 months. So grateful to be here. Becca Lynn, $5. Yay to have Rob here. How exciting. Justice for Maya, Kyle, Jack, and Beata. Shell CD says, judge is speaking on Zoom.
Here's one I'll read. Palmyra Productions. It sounds like we denied your entry into the Facebook group. I think you might have missed a question. We tried to rule out the bots. So if you just hit join and didn't see the questions on the bottom, just try to enter again and just make sure you answer the questions on the bottom so we can make sure that's not a bot that's trying to join. That's it. But thank you very much, Palmyra.
Session R Fan Club says, Rob, you're so handsome and good looking. Thanks for the coverage. Much love from Rona. Laura Wharton became a YouTube member. Thank you for hitting the join button. So, Seashell gave $2. Say, Rob, can RA be an honorary law tuber? True crime. He's law tuber adjacent.
Yes.
Nibali Mitshaw gave 14 ZAR. Say, we can't hear court sound. Sergeant Mom 2 said, no court audio. Nathan C said, Scott, change how you're sharing on SY for audio.
Yeah, this was
Mitchka gave him crying tears of joy. Justice for Maya.
This was me failing at the beginning.
Baby Gator gave to 5 gift memberships. Thank you very much. Alex Martin said, how much dollars so far? All of them. Pet Leaf gave $1.99 for Maya. Sergeant Mom 2 said, time to put CB in jail and on trial. Lady in Gray gifted 5 gift memberships. Thank you for hitting those join buttons. Karen Fan gave $10 for a super sticker.
You're reading faster than I can scroll and click. You know that? I asked you to read fast, but I didn't realize I would have to.
Told me to do. I'm reading faster.
I have to up my game as well to keep up with you.
I'm here for it, Scott.
Okay, I'll see if I can read some here. Let me swap over. You've done a great job, Kurt. We'll have to do readings together. You're fantastic at it. I can learn a lot from you. Jennifer D. God bless the Kowalski family. Parrot Court says Ivan Victor is getting a haircut on a live stream. I think he did make a bet about something about the 200 million level and his mullet. We'll see. I do have to pre-read a couple of these because we did get a couple messages that I don't want to put on screen. We can't share that. Being acknowledged in this way must bring up such emotions for the Kowalskis. So happy for them. Thanks for the great coverage, gentlemen.
Apparently there is a verdict, by the way. Your chat is flooding, so I'm going to take
Whoa. Hey. Attorneys are back, says the chat. Okay, so let's put this on hold for just a minute.
So, yeah, an hour. So it's basically on the money. So, yeah. Okay, great. So I claim credit for that win.
Thanks for reading that. I have not been able to keep up, as you can see, on all of this. Let me say thank you to all those who have given a super chat, given a donation, gifted a membership, super sticker. Thank you so much. You guys are incredibly generous, more so than I deserve, and I just wanted to thank each of you individually, even though I will not be able to on this live stream, and I feel terrible about that. I literally won't sleep very well about it because of that tonight. We'll have to figure out a way to do this better. I'll have to take lessons in StreamYard or something.
Apparently, it's not going to be read for 10 more minutes. We could read more super chats.
Okay. Let's see. S. Elizabeth, welcome. High recovery. My sister said on Fox News it was 220 million. I've heard the numbers between 211 and 238. I think Mr. Shapiro said it was about a quarter billion. Of course, that sounds really bad when you put the B in front of it, but I'm not sure what the final number is. We'll be back at 2 for the punitive phase. The punitive phase is, I guess the jury's over that, so we'll see what happens just in a minute. Here for the Truth says, world is your oyster, kids. Continue to do great things. You may not realize the magnitude of this, but you're changing systemic culture in many fields. Hope all the facilities smarten up and clean up their act. Godspeed. Thank you, Here for Truth. Appreciate that. Luis says, thank you for your coverage, RA. Rob and Jules, so much love for the family. Beata, may you rest in peace. Super sticker. Thank you, Karma and Jay, both of you. Inquiring Mind gifted, member for 6 months says, what was the defense reaction? I think the defense is still having a visceral reaction to what they've heard today. That's a tough one. They basically, everything they did for 9 weeks, the jury said no to. And it was a lot of effort they put in. The jury literally sided against them on every single front.
Not just no, but hell no.
Yeah, it reverberated through the halls of court. This most likely is probably going to be the biggest win of monetarily wise of Mr. Anderson and Mr. Whitney's career. This is huge. I mean, I can't think of the last time. What was the tobacco settlement? Do you remember when the tobacco companies got sued?
No.
I don't know what the amount was.
I think it feels like it was smaller.
That 40%'s looking pretty good.
Yeah, if they're getting 40% on commission.
Ooh, get the computer system open.
All right, here we go.
You're early.
I mean, in that case, I would love to interview them at their private island.
Two-factor authentication.
The court's early. Since when are courts early?
Yeah, what is this?
The judge really wants to be done before Monday, so he's pushing this if he can.
Okay, let's see, we've got Shapiro going to be joining us. Okay.
Mr. Shapiro is crying in the corner somewhere.
And looks like everyone else is here. This is case number 2018 CA 5321 NC Jack Kowalski, etc. et al. Versus Johns Hopkins All Children's Hospital. I've been advised that there is a verdict in phase 2 for punitive damages. Are there any issues we need to address before we bring in the jury? Okay, let's bring in the jury.
All rise. Jurors entering.
Okay, please be seated. Members of the jury, I understand that there is a verdict in phase 2 for punitive damages. Is that correct?
Yeah.
Let's hand the verdict form to the court deputy who will hand it to me. Okay, Madam Clerk, please publish the verdict.
In the 12th Judicial Circuit in and for Sarasota County, Florida, case number 2018 CA 005321NC. Jack Kowalski individually, Jack Kowalski as parent and next friend of MK, a minor, and Jack Kowalski as personal representative of the estate of Beata Kowalski, plaintiff
I wonder who MK
versus
is.
Johns Hopkins All Children's Hospital Incorporated defendant. Punitive damages verdict form. We, the jury, return the following verdict in regard to punitive damages. Claim 1A, false imprisonment between October 7th and October 13th, 2016, Maya Kowalski. 1. What is the total amount of punitive damages, if any, which you find, by the greater weight of the evidence, should be assessed against Johns Hopkins All Children's Hospital for the false imprisonment of Maya Kowalski occurring between October 7th and October 13th, 2016? $15 million. 2. Do you find by clear and convincing evidence that at the time of the false imprisonment of Maya Kowalski between October 7th and October 13th, 2016, did Johns Hopkins All Children's Hospital have a specific intent to harm Maya Kowalski, and did the conduct of Johns Hopkins All Children's Hospital in fact harm Maya Kowalski? Yes. Claim 1B, false imprisonment between October 18th and October 20th, 2016, Maya Kowalski. 4. What is the total amount of punitive damages, if any, which you find by the greater weight of the evidence should be assessed against Johns Hopkins All Children's Hospital for the false imprisonment of Maya Kowalski occurring between October 18th and October 20th, 2016? $10 million. 5. Do you find by clear and convincing evidence that at the time of the false imprisonment of Maya Kowalski between October 18th and October 20th, 2016, did Johns Hopkins All Children's Hospital have a specific intent to harm Maya Kowalski, and did the conduct of Johns Hopkins All Children's Hospital in fact harm Maya Kowalski? Yes. Claim 1C and Claim 2, false imprisonment and battery.
Hey, Court TV, get the camera out of her ear.
Maya Kowalski. 7. What is the total amount of punitive damages, if any, which you find by the greater weight of the evidence should be assessed against Johns Hopkins All Children's Hospital for the false imprisonment and battery of Maya Kowalski occurring on January 6, 2017? $25 million. 8. Do you find by clear and convincing evidence that at the time of the false imprisonment and battery of Maya Kowalski occurring on January 6, 2017, did Johns Hopkins All Children's Hospital have a specific intent to harm Maya Kowalski, and did the conduct of Johns Hopkins All Children's Hospital in fact harm Maya Kowalski? Yes. So say we all this ninth day of November 2023, four-person.
May I have the verdict form back, please? Do the attorneys wish to examine the verdict form? Yes, sir.
Why are they zoomed in on these two and not like the lawyers?
So it's 50 million?
I would much rather see Mr. Hunter and Shapiro right now than Maya.
Exactly.
I'm so happy for Maya, so happy for the family, but at the same time, that's where the action is.
Yep. But no,
So Kim-
Court TV is going to get the camera right in her ear.
Well, the punitives are a lot more reasonable, so that's nice. They didn't blow it completely up the top, so that's nice.
That'll help them on appeal.
Do the attorneys wish to have this jury pulled?
Yes, sir.
Madam Clerk, please pull the jury.
Juror 93, is this your verdict? Yes, it is. Juror 97, is this your verdict? Yes, it is. Juror 98, is this your verdict? Yes, it is. Juror 19, is this your verdict? Yes, it is. Juror 17, is this your verdict?
Yes.
And juror number 1, is this your verdict?
Yes, it is.
Madam Clerk, here's the verdict form. Let's process it and have it
become publicly available. Plaintiff's defense, are there any other issues that we need to address with this jury, or may they be discharged?
They may.
Okay. Members of the jury, in a moment, I'm going to give you the official discharge instruction, but let me just take a couple of moments. First, I really appreciate your time and attention over the last 9.5 weeks. I do have a certificate for each of you. I'm going to hand it to Deputy Coley, who will hand it out. And we've given the jury. Okay, you have the jury notes? Okay, they have the juror notes. Okay, so if you need to give them to your employers, they'll give you those juror notes. The instruction to not talk about this case will be over. So you will be free to talk about this case or not talk about this case. It's going to be up to each of you whether you wish to preserve your privacy. The lawyers and their agents will not be able to approach you. You, of course, may approach the attorneys, but again, that's going to be up to each of you. At this point in time, I'm going to give you the official discharge instruction. When that occurs, I'm going to have the court deputies escort you out of the building and take you to your cars. So thank you very much for being with us. Members of the jury, on behalf of the parties, the attorneys, and the people of the state of Florida, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years the jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. The attorneys and their representatives are not permitted to initiate any communication with you about the trial. However, you may speak to the attorneys or anyone else about the trial. You also have the right to refuse to speak with anyone. A request may come from those who are simply curious or from those who might seek to find fault with you. And it will be up to each of you to decide whether to preserve your privacy as a juror. And at this point, this is the last time I'm going to say this. You do not have to not talk about this case. You may talk about this case or not talk about this case. You may watch or not watch any news accounts that you may, and you may approach or not approach anyone. So at this point in time, I am discharging you with the court's thanks and the people of the state of Florida for your time and attention. And if you can follow the court deputies, Lieutenant, if I can see you just a second.
All rise. Jurors exited.
So $50 million in punitive damages. Not going to destroy the hospital, but that is not a small sum. They'll feel it. They'll feel that. That's big enough. That's I think that may accomplish something. So
It's not going to destroy the hospital, but it's going to make some people think. And some people have to put on their resume, cost Johns Hopkins $100 million.
Are there any issues that we need to address tonight? Okay. At this point in time, we will be in recess. Thank you all for your time and attention. Take care now.
And just like that, 9 weeks of our lives comes to an end with "Take care now" from the judge. Incredible finish to this, where we see a trial where a jury was more united than I've seen any jury before. Just incredible. The numbers that came out of this, the verdict is enormous on the damages. It was quite sizable on the punitive, obviously smaller than the damages, but they weren't there to destroy the hospital. That wasn't their goal. We saw that. They did stick to about that number. I think I just want to say I was right. They stuck to about that number they had on cash, about $50 million. So I think that was That was very telling. The jury was not there to destroy the hospital, but.
All right. Well, that's it. That's all she wrote. So.
Yeah. And I've got.
I'm gonna sign off for now because I got my show in about 25 minutes and I need a little break. So, anyone who wants to after Recovery Addicts podcast, of course, I'll see you over that way.
That would be awesome. Kurt, thank you very much. Appreciate that. Ian as well, stuck in here for hours as we talked and shot the breeze and watched the happenings. Ian, super jazzed that I got to help out in a very small way with your fundraiser. I'm hoping it continues to go through the roof and get you up there.
It's not a small way. It's a really big way because at the end of the day, people come on because there's a bunch of people there. It's a fun sort of thing. It's, whatever else. And if I was just there doing it for 24 hours, there'd be a lot less interest. So everyone who helps out, it's a big help. It's and I appreciate it because this is a good cause. And I think at the end of the day, we'll hopefully accomplish some good. I'm trying to talk them into, I'm going to try to maybe guilt them a little bit into putting up something for Corey, like a little...
That'd be awesome.
I'm going to try to get them to paint a pirate, image on the wall or something.
That would be really neat.
Yeah. But I'll let you get through the super chats. It was wonderful hanging out. We've got to do it again. And you absolutely fantastic coverage. Everything, I've seen, I'm like, yep. It's funny because I watch a lot of true crime channels. Well, people send me to true crime channels, and I just kind of end up wincing, and you don't make me wince, which I know you sort of are like, I'm not LawTube, I'm not like, but you don't make stuff up, you don't anything. It's all good information and good presentation. So I really appreciate. I found you via Rob, finding you, and I'm like, I'm really glad I did. So, all right.
Ian, thank you. I look forward. We'll have to do something in the future as well. I know you've got some high interest stuff that I like following, and I'm not sure. Are you going to address any of this down the road as all the paperwork comes out and the dust settles to look back at this?
Probably. I'm thinking I'm probably going to look at the appeals because I like appeals, and appeals are often kind of boring. I guess they're not going to have the same sort of trial theatrics, but it's important to go through appellate documents and sort of understand what's going on with them. So I'll probably do some of that and have a look at that. And just that said, it would not surprise me if this never ends up. It wouldn't surprise me if what we hear after this, like if at 2-3 weeks, we might hear they have reached a confidential settlement. And that would not surprise me at all with them saying like, here's our price to not appeal and to just call it a day. So, and I think that would actually be a classy move on John's Hop. I mean, it might save them a few $1 million too, but
and it gets money to the family sooner as well, so it lets them move on.
But it would be a classy move for them to just be like, let's just let this be over for you guys because they've been through so much. It's an absolutely tragic case. But anyway, I will. I'll let you go here, and the take care is kind of an interesting. Somebody in the chat mentioning that as the wrap up. That's going to end up in a documentary somewhere.
Yeah, well. Yep. Ian, thank you so much. Have yourself a great night. I look forward to doing something in the future as well. So I appreciate you, my friend.
Cheers.
All right.
Night.
We'll see you. Can't thank those three phenomenal gentlemen enough. Rob, Ian, Kurt, thank you very much for the help they've given me. We're going to, I don't know how to go through all the super chats. I really don't know how to get all this done. I'm looking at this. I have 372 either super chats or gift memberships or anniversary messages, and I've got 20 minutes before the live stream. Let me say that the love and support that you have shown the channel has been through the roof. Thank you so much. It means a ton to me. It makes it possible. This is my full-time job. This is what I do. I love it. I love every minute of it, and I've loved getting to know you and spend time with you throughout this trial. We do follow court cases every day. That's what we do. We will be following more court cases. We don't have a huge one that starts right now, so we'll follow some of the smaller cases that are happening, and in some of the smaller courts do some court hopping until we get ready to move to our next big case. But if you have liked this coverage, I would ask that you do click the subscribe button, ring the bell, and come back and join us. This is a fun place to watch true crime. It's a friendly place where we don't all have to disagree. We do have to be respectful. We don't have to agree either. We don't have to disagree or agree. But it's a fun place to be, and I think you've seen that through just the amazingness of the people you meet in chat here. So thank you very much for all of you. I have to end this because I have to fix this audio before we do the podcast tonight. I am so sorry. I'm so sorry I'm not able to show the super chats for everyone. I've got to figure out how this works a little bit better. I'm not really proficient on StreamYard for that. So we'll do that, and please accept my apology on that. But thank you everyone for the generous support of the channel and for your input and questions. That being said, we're going to end it like this. We're going to have the podcast here tonight. Starts at 8 o'clock right here on this channel. So if you click the subscribe button, you're going to be notified. Hopefully, if you ring the bell when it starts. So I've got just a few minutes to get things switched around and get ready for that. I'd hope you join us. It's going to be a lighthearted look back at some of the things that happened this week. Some funny news stories. Some fun involvement. We're going to ask you some questions. Let you weigh in on a few things. It's sort of a light way to get ready for the weekend. It is Thursday. Weekend's almost here, but I just encourage you to join us that way for that. Tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe till we go live again, which will be in about 19 minutes now with the podcast. Thank you all very much, you guys. Have yourself a wonderful evening. Be good to each other. See you.